Okay, good morning, everyone. Let's call to order this hearing of the Assessment Appeals Board for August 3rd, 2015. And we'll start by asking our clerk to call roll.
Board Member Crow.
Present.
Board Member Little.
Present.
Board Member Stern.
Present. Thank you. And now we'll ask that everyone stand for the Pledge of Allegiance. If you do intend to provide testimony today, please remain standing after, and we'll get you sworn in. Ready, begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Great, thank you. And please do remain standing if you intend to provide testimony.
So everyone that will be addressing the board this morning is to be placed under oath. I'll now read you your oath, and when I complete reading your oath, please state I do. Do you solemnly affirm that the testimony you're about to give in the matters now pending before this board will be the truth, the whole truth, and nothing but the truth? Thank you. You may now be seated.
Okay, it's good to see such a large group this morning, and what we'll start by doing is go through each agenda item to determine the status of each, and then once we know who or what applications will move forward, we'll proceed with those hearings. So we'll start with our agenda review, which is a group of items that hopefully we can take action on all at one time.
Item 5, Agenda Review for August 3rd, 2015. The Clerk of the Board recommends approval of the Agenda Review by the Assessment Appeals Board. The Agenda Review consists of the following agenda items. Items 66 through 78. Application numbers 13-12015 through 13-12027. McGrath and RHD Partners removed from the agenda due to submission of a withdrawal. Item 80, application number 13-12146, applicant Technicolor Thompson, continued to October 5th, 2015, pending receipt of original stipulation. Item number 81, application number 13-12146. And number 81, application number 13-12310, applicant Francis, spell the last name, R-E-H-W-A-L-D, approved findings of fact. Item number 92, application number 14-10533, applicant Timothy Handshot, continued to October 5th, 2015, pending receipt of original stipulation. Item number 94 through 101, application numbers 14-10645 through 14-10652, applicant South Street Center, LLC, continued to October 5th, 2015, pending receipt of original stipulation. Item number 104 through 105, application numbers 14-10765 and 14-10766, applicant Air Center Helicopters Incorporated, continued to October 5th, 2015, pending receipt of original stipulation. Item numbers 123 through 125, application numbers 14-11117 through 14-11119, applicant Aspen Helicopters Incorporated and Charles McLaughlin, continued to October 5th, 2015, pending receipt of original stipulation. Item number 128, application number 14-11206, applicant Technicolor, continued to October 5th, 2015, pending receipt of original stipulation. Item number 134, application number 14-11291, applicant NLA 118 LLC, denied due to lack of appearance. Item number 135, application number 14-11295, applicant Mayland Enterprise Property Tax, denied due to lack of appearance. Item number 136, application number 14-11297, applicant Forever 21 Retail Incorporated, number 797, denied due to lack of appearance. Item number 137 through 138, application number 14-11300 and 14-11301, applicant JP Morgan Chase Bank National, continued to October 5th, 2015, pending receipt of original stipulation. Item number 147, and so just 147, application number 14-11338, applicant Ojai Oil Company, removed from the agenda due to submission of a withdrawal. Item number 151, application number 14-11342, applicant Golden State Self-Storage, removed from the agenda due to submission of a withdrawal. Item number 156 through 157, application number 14-11347 and 14-11348, applicant Hillcrest Oaks Limited, removed from the agenda due to submission of a withdrawal. Item number 158, application number 14-11351, applicant Sears Holding Corporation, continued to October 5th, 2015, pending receipt of original stipulation. Item number 159, application number 14-11357, applicant 1090 SPA HD Moore Park, care of Home Depot USA Incorporated, denied due to lack of appearance. Item number 162 through 164, application number 14-11483 through 11483 through 14-11485, applicant Tehaz Patel, approved findings of fact. Item number 202, application number 14-12188, applicant Charles Carter, denied due to lack of appearance. Item number 203 through 204, application number 14-12202 and 14-12203, applicant NDB Investments Incorporated, removed from the agenda due to submission of a withdrawal. Item number 205, application number 14-12204, applicant John Zaki, continued to October 5th, 2015, pending receipt of original stipulation. Item numbers 206 through 207, application numbers 14-12205 and 14-12206, applicant Young Lee, denied due to lack of appearance. Item number 214, application number 14-12218, applicant Janet Oghayan, continued to October 5th, 2015, pending receipt of original stipulation. And item 216, application number 14-12224. I'll spell the first name M-A-H-N-A-Z, last name J-A-D-I-D-O-L-A-H-I. That will be denied due to lack of appearance. And that completes the agenda review.
Okay, thanks, Mr. Vlahakis. First, I'll ask, is there anyone in the audience who heard their application number or applicant called as part of the agenda review? Yes, come on forward.
Good morning, Kenton Schubel, Ryan, LLC. I wanted to point out agenda item 135. Although it's not mine, my company does have agency. I don't know anything about the application, but it seems like it may have been overlooked, the fact that there was no confirmation of appearance. I would perhaps request the board's forbearance if I were to request a continuance on our behalf. If it's something that wasn't intended to be followed up with, then they could do an administrative withdrawal, if no one has any objection.
So the clerk would recommend removing item 135 from the agenda review,
Okay.
application number 14-11295 for Medland Enterprises property tax.
Okay, Mr. Schubel, we will come back to that probably.
Thank you.
But first, I'll ask if there are any questions from the board on the agenda review.
No.
I have none.
Okay, and so with the exception of item 135, looking for a motion to approve the agenda review.
So moved.
I'll second that motion.
Okay, moved by Miss Little, seconded by Mr. Crow, and motion carries.
Oh, that's right, we have to do that. Okay.
You're down here. There you go.
Oh, so click on that second right there with your mouse.
Okay.
Thank
Okay.
you.
There you go. Okay.
Please vote.
Got a
Yes.
no on her.
Is it yes?
Oh,
Oh, yes. Yes.
there it is.
This is going to come up as a stip on 184.
184. Okay, thank you.
No, we got it.
Okay.
All right. Okay. Modern technology.
So again, we'll go through the remaining items on the agenda. Thank everyone in advance for your patience, and we'll determine the status of each. We'll start with item 6, Application 12-12169. Applicant is Bank of America.
Good morning. Kenton Schubel Ryan LLC for the applicant.
Welcome back.
Thank you.
Mr. Schubel, are you prepared to move forward today?
No, I'm not, Mr. Chairman. I was advised the assessor's not prepared to go forward, so we didn't come prepared.
Okay.
But I did want to point out there are a number of applications that are all related. It's the same property. There are a number of items on today's agenda.
Okay.
If you'd like, I can give you the item numbers.
Sure.
Okay, it's item 6, item 139, items 196 through 198, and items 199 through 201.
Okay.
And what we have here is change of ownership for the property. It's the Bank of America across the street. The item 6 application 12-12169 was filed on a reassessment for a change of ownership. That application resulted in action on the assessor's part, which then subsequently resulted in the other applications. The real core of our issue is with the applications for 14. It's my opinion that the 12 application could be withdrawn. In an excess of caution, the taxpayer requested that it be continued pending the resolution. So I'll leave it in the board's decision on how they'd like to handle that.
Okay, and you're just referring to item 6 right now?
That's correct.
Okay. And let's go to the assessor with any comments.
Kent Meyer, Ventura County Assessor's Office. Good morning, everybody.
Morning, Mr. Meyer.
Item number 6, that one situation, the parcel was voided, and for all the roll years subsequent to and including the year of the application, we reduced it down to 0 value. So there really is no issue on this one.
Other than waiting for the refund to happen. I don't have any trouble with that. So as I said, I'm okay with that being, I don't have permission to withdraw it. If the board would like to deny it, I don't have a problem with it. I don't think it curtails the taxpayer's rights in any way, although it was their request to leave it open with the other items and continued.
Okay, Mr. Meyer, any comments? In terms of status or
No further
recommended?
comments on that particular application.
Okay.
However, on items 196 through 198 and 199 through 201, which is still is part of the same property, there are duplicates on those. So there needs to be some determination in the near future as to which of those applications need to be withdrawn as duplicates.
Okay, let's take this one first. I'm not sure that we can deny due to lack of appearance if we have someone appearing. So other options, I suppose, could be a continuance or a withdrawal.
As far as we're concerned, the continuance is fine.
Okay. Does that make sense to the applicant?
It does. I mean, one thing I can say is when this comes back before the board the next time, it will be the last time, will be resolved, and all these applications will go away. So
Okay.
if it's convenient to continue them all at one time.
Okay. And is there a recommended date from the assessor in terms of a continuance?
The assessor would recommend December 7th on everything that we continue today, unless the clerk of the board determines that the calendar is too full on those days.
December 7th would be perfect with us.
Okay. Another issue with every application that we continue today, we would request that all the information or data that has not been provided be provided to the assessor within 30 days of today, i.e. no later than September 2nd. The reason for that is we have a very full calendar on November, and with all the continuances today, we will likely have a full calendar in December also. So, and we have almost no cases going forward in September or October. So if we can get all the information within 30 days, we might be able to resolve all of these cases well before hearing.
Okay, thanks. We'll keep that in mind. Thanks for the info. Mr. Schubel, is December 7th acceptable date for a continuance?
Yes, it is.
Okay. Are there any questions from the board?
No.
All right. So I think we're looking for a motion to continue item 6 to December 7th.
So moved with the proviso that all information be submitted to the assessor by September 2.
Yes, it will be.
I'll second that motion.
Okay.
Thank you.
Okay. Moved by Ms. Little, seconded by Mr. Crow, and motion carries. So then let's go next to item 139. application 14-11312. And the applicant is GPT Gig Boa Portfolio. And Mr. Schubel, was this related to your other items?
It is. It's the same property. There was a statutory change in ownership that involved change of the entity holder title. So
And
the
same
request-
status in terms of looking for a continuance to December 7th?
That's correct.
Okay. And to the assessor, any comments on that?
No comments other than the data be provided within 30 days.
Okay. And any questions, comments from the board? Okay, so looking again for motion to continue to December 7th.
So moved with the additional proviso that all
I'll
related
second that motion.
information within 30 days.
Got it? Okay. Moved by Ms. Little, seconded by Mr. Crow. And the motion carries as soon as we push all of our buttons. Okay, great. Let's then go to items 196 through 198. Applications 14-12171 through 14-12173. Applicant is First States Investment. And Mr. Schubel, same status with this?
That is our request, yes.
Okay. And to the assessor, I believe we're talking again about a proposed continuance to December 7th?
That's correct.
Okay. Any questions, comments from the board? Okay. Looking for a motion to continue to December 7th.
So moved with the additional proviso about information.
I'll second that motion.
All right. Moved by Ms. Little, seconded by Mr. Crow. Motion carries.
Thank you.
And next, items 199 through 201. Applications 14-12174 through 14-12176. And the applicant is, again, GPT Gig Boa Portfolio Owner LLC. Mr. Schubel, same request?
Same request, same set of facts, Mr. Chairman.
Okay. And to the assessor, continuance to December 7th?
Correct.
Okay. Any questions from the board?
None.
Okay. Looking for a motion to continue to 12/7.
So moved with the additional proviso about information.
I'll second that motion.
Okay. Moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Okay. Thanks, Mr. Schubel. Next, we'll go to items 7 through 12. Back to the beginning almost of the agenda. Applications 12-12177 through 12-12182. Applicant is BG Terminal California LLC.
Mr. Chairman, there's several interrelated applicants, so it'd
Okay.
be best to just deal these all together. This also includes item numbers 54 and 55, application numbers 13-11285 and 13-11286 for BG Terminal CA LLC. Item number 56, application number 13-11287 for BG Ground Terminal CA LLC as affected party. Item numbers 57 and 58, application numbers 13-11288 and 13-11289 for BG Ground Terminal CA LLC. Item number 83, application number 14-10360 for Terminal Freezers LLC. And item numbers 208 through 213, application numbers 14-12207 through 14-12212 for BG Terminal CA LLC.
Okay, thanks, Mr. Vlahakis. And Mr. Schubel, let's start with items 7 through 12, or should they all be?
Well, I'll
Discussed in
comment on
terms of
all of them at once.
Okay.
If you don't mind. What we have here is Ryan LLC is the agent of record for all these applications. We filed a 2011 base year, which was heard before the board, and it was resolved. After which we advised the taxpayer that we would not continue with any of the Prop 8s that were filed protectively, giving them the option to proceed in another way if they chose to. I was advised that as of today's hearing, that they had it under control. I don't know exactly what that means. I'm not aware that anyone's present here today to substitute in for these applications. So I'm in the unusual position of being the agent of record. I don't intend to go forward with these, so it's not a no-show, but on the other hand, I don't have the taxpayer's permission to withdraw them. The one thing I could suggest is if the board would allow a continuance to allow the taxpayer time to substitute in or make any arrangements they want to. I don't know how
Okay.
else to
The clerk has a note on that. On late Friday, we got a revocation of substitution of agent that seemed like it could apply to these applications, but they weren't very clear. They didn't have the same applicant name. They didn't give us any application numbers, and they had, but they had all the parcels for the affected applications included. But there's tons of applications on file for the parcels. So we sent it back to them and said, we can't tell what you're being revoked on and what you're substituting on. And so we told them, we need a clear revocation and substitution. And we didn't receive anything. And so it's kind of, like he said, in limbo. We don't know exactly what they're revoking and substituting on with the new agent. They didn't make that clear at all. I was hoping they'd be here today to clarify that, but they're not. So it may be recommended to continue these. I'm not sure, because technically we got Mr. Schubel still as the agent of record until the other agent clarifies which cases that he's being revoked on. So it's kind of a mess, but
It would be council's recommendation to continue, to let it all be sorted out
I do believe
properly.
it was the taxpayer's intent to substitute in on all the open applications, even if they didn't get it right, which, considering the number of applications, I could understand how that could happen.
Okay. Let's hear from the assessor.
The assessor's opinion is that they sent in a slip to revoke the agent and listed the parcel numbers, then I believe that he no longer actually represents these appeals. And since the agent is not here, then I believe that they should be denied due to lack of appearance.
Okay, thank you. Let's go back with a quick question to our clerk, Mr. Vlahakis. Did you say that in terms of the revocations and the parcel numbers, it was clear, or it sounds like it was unclear in terms of...
because the new agent filed applications for 2014 and 15. So, and there's multiple years, and we require that the prior agent be clearly revoked before and that a new one is substituted. And I read it in the code last night about revocations. I can't remember what code section it is, but there was something that said, that the applicant's required to clearly revoke the agent on the application prior to a new one being substituted. I can't find it offhand.
Okay.
But since it's not, the specific applications weren't listed, the clerk of the board wouldn't consider it to be a valid agent revocation. It'd just be the same as if they didn't revoke the agent at all, because we don't know which specific cases were revoked.
Okay, thank you. Are there any questions at this point from the board for any of the parties?
No, but the assessor might have additional information.
Okay.
A lot of these applications also expire pretty soon, so we'll need a 2-year waiver. So that goes to the revocation also.
Okay, thank you, Mr. Meyer. I guess I have a question back to our council. Thank you for being here. And sounds like we have, like we said, some lack of clarity exactly on whether there's been a valid revocation or not. So if we do continue, I guess if the 2-year period comes and goes, then they would be invalid. But do you still recommend that we continue and let things get sorted out?
Under the circumstances, it would be council's recommendation to grant a continuance to the next hearing date in order to let the revocations be clarified to the clerk's satisfaction.
Okay. And let's go back to the assessor in terms of if continuance, is there a date if all of these matters are continued that would be most acceptable?
December 7th on anything that gets continued today, with the proviso that we do receive all data within 30 days of today.
Okay. Okay. So let's discuss. Are there any comments or questions from the board?
Yeah, it's a bit of a catch-22. He's not officially revoked, and the new one hasn't stepped in, so I agree with council.
Okay. Mr. Crow? Okay, so, and just one more question for our clerk. Is it okay to make one motion for all of these items, or do we need to?
Yes. No, yeah, it's fine to make it all one motion.
Okay, so we're looking for a motion, just to clarify, that would relate to items 7 through 12, 54 and 55, 56, 57, 58, 83, and 208 through 213. Is that consistent with what we talked about, Mr. Blahakas?
Yes, it is.
Okay.
So moved.
I will second that motion.
Okay, and just to clarify, Ms. Little, the motion was to continue to...
December 7th, and with the proviso that any supporting documentation be submitted to the assessor by September 2.
Okay.
Thank you.
So moved by Ms. Little, seconded by Mr. Crow. And good morning.
Hi, Ken Kaiser with the Assessor's Office. Just one
Morning.
question on the motion.
Yep.
On 57 and 58, the 2 years expires 9/16. And it's been continued to when?
December 7th.
So did we get the 2-year signed prior to December 7th?
I'll try to work it out with the new
Makes
agent.
sense.
I understand what you're saying.
Otherwise, I think it's de facto.
Right.
Okay.
So in order for it to go through, I guess the 2-year waivers would have to be executed before that date. Well,
Otherwise, they could contest continuance.
Okay.
I know you could have their way if it expires and it wasn't.
So maybe we should we amend the motion to include the provision that the 2-year waivers be executed?
That the approval is contingent
Contingent
on the
upon.
2-year waiver being executed prior to the expiration date of 9/16.
Okay, motion is so amended.
So
Okay.
send it to-
And Mr. Crow, are you still on board for a second with the amended motion?
I'll second that motion.
Okay, so motion amended by Ms. Little, seconded by Mr. Crow, and motion carries. Thank you.
Thank you, Dr. Kaiser.
Thank you.
Okay, let's go back to item 13. Application 13-10777. Applicant is Green Energy Holdings, LLC.
Good morning, Michelle Fatia, appearing for Green Energy Holdings.
Morning, welcome back.
Thank you.
Are you prepared to move forward today?
Yes.
Okay, and let's go to our assessors representatives.
We're prepared to move forward.
Great, so we will get through the rest of the agenda and come back and determine how we can most efficiently move forward. So,
Wonderful. Thank you.
okay, thank you.
Time
Can we just
estimate?
clarify if findings of fact are requested on this item or not? I do not believe I've received any payment for findings of fact.
Okay,
So is the applicant requesting findings of fact?
I'm not sure. What does that mean?
Yeah, okay. I'll give the applicant a description, and before the hearing starts, they can let me know.
okay. Ms. Lill, did you have a question?
Do we have an approximation of time?
Oh, thanks. Do you have a guess on time of your presentation?
I have pictures and stuff to show you and give you my argument. It depends on how long the opposition is, but maybe 15 minutes.
Okay, great. And,
The assessor estimates 15 minutes.
okay, great.
Okay.
Thanks.
One question for the assessor: has the applicant provided the subpoenaed evidence?
We are willing to move forward without the subpoena information.
Great. Okay, let's go forward to items 14 through 49, applications 13-10950 through 13-10955.
Mr. Stern,
Sorry.
the applicant and I have had several discussions, and we are both in favor of a continuance. However, there's a lot of issues that need to be covered within the continuance itself, so we'd like to trail this item until we go through the rest of the agenda, because we anticipate it could take anywhere from 15 minutes to 45 minutes just to go through to get the continuance.
Okay. That's fine.
Barbara McAfee is appearing for the residents.
Okay. Okay, thank you. We'll come back to you. Okay, next to item 50. Application 13-10976. Applicant is Tina Rasnow.
Part of the same deal.
Oh, thank you.
And also, 107.
Okay, thank you. Okay, next up, items 51 and 52. Applications 13-11059 and 14-10192. Applicant Moore Park Campus Park.
This is a validity hearing. I expected the agent to come here. Lori, has anyone checked in for this item? Right. Right.
Okay, well, just to ask one more time, anyone here for items 51 and 52 representing Moore Park Campus Park?
So the clerk was expecting them to go further with the validity hearing. I printed out a couple hundred pages of documentation, but let's see. Since it's a validity hearing, I guess the recommendation would be to deny. I'm not really sure. I guess the board could deny due to lack of appearance.
Okay.
Because we were requesting the board examine the application and these applications and determine if they were valid or not. So
Okay.
I don't know if it's appropriate to declare them invalid without seeing the materials. So maybe just deny due to lack of appearance.
Any comments from the assessor?
Kent Meyer, Ventura County Assessor. Yeah, the applicant actually called us last Friday asking us what these were about, so I don't think that they're even going to show up.
Okay. Any questions from the board?
No.
I have none.
Okay. Probably looking for a motion to deny due to lack of appearance.
And so moved.
I'll second that motion.
Okay. Moved by Ms. Little, seconded by Mr. Crow. And motion carries. Okay, next item 53, application 13-11085. Applicant is International Paper Company.
Good morning, board members.
Good morning.
My name is Renee Daza. I'm here on behalf of Versatax Consulting.
Morning, welcome back.
Thank you.
The clerk this is a request for reconsideration. The clerk of the board will be presenting. We'll probably need 5 minutes to present our case.
Okay, and Mr. Daza, before we go ahead with the actual bones of the case, are you prepared to move forward in terms of, looks like we're dealing with a reconsideration of application denied due to lack of appearance?
Correct.
Okay, and how long about do you think it'd take to present your info?
I said 10 to 15 minutes.
Okay, thanks. And any comments from the assessor without getting into the details?
I was just notified that he did not check in with the clerk. I'm not sure if he was here for the oath.
Did you get sworn in, Mr.
He was here
Daza?
during the swearing. Yes.
Yes, it was.
You did. Okay. And any questions from the board before we? I think what we'll probably do is trail your item, come back and hear it, and get through the rest of the items. But any questions from the board first?
No, that's fine.
Okay. So we'll come back to you shortly. Okay, next items 59 through 65, applications 13-12004 through 13-12010. Applicant is New Albertsons, Inc.
This is a amendment hearing. I believe we have copies of the applications that the clerk will hand out. The agent filed applications in numerous applicant names, but the authorizations were all executed by the New Albertsons Incorporated. And so there became a mismatch with the agent authorizations and the applications, wherein the applications weren't for the applicant that authorized the agent to file. So this is a pretty easy correctable issue. The agent has made a request to amend the applications with the applicant name to correct them all to New Albertsons Incorporated, which will make it match the agent authorization. And once that issue to amend is approved by the board, the applications will be valid, and we can schedule them for a evaluation hearing in the future.
Okay.
All right. So as far as I know, it's just a request for the board to approve amending the applicant names from various to New Albertsons Incorporated.
Okay, thanks. Let's hear from the applicant.
Camden Schubel, Ryan LLC. Thank you, Mr. Chairman. And Brendan's right. It's a request to amend the applications to the name of New Albertsons.
Okay, and any comments or objections to that from the assessor?
No objections to that, just request that Mr. Schubel provide the data to us within 30 days.
I will advise them.
Okay, any questions from the board? Okay, so let's see. We are looking, I guess, specifically, go ahead.
Yes, so we need the board to approve the amendment of the applications to the name of New Albertsons Incorporated.
Okay. So looking for a motion.
So moved with the proviso that
We'll second that motion.
Okay, and just
within 30 days, the information be supplied to the assessor.
Yes, it will be.
So we still need to, now that the amendment's approved, so if we could just address the amendment. So
okay,
the
let's
board
all
can-
just vote for, or are you, I'm sorry, Mr. Vlahakis, something else with this
No.
motion?
No, that's fine. Just for the amendment for now, and then we need
Okay.
to discuss the continuance.
Okay, so that
Does
motion
this need
carries.
a 2-year waiver also?
There's the time period which I don't think it does because they weren't technically valid before, so that extends the toll. But we can look that up. I think these were filed late in 2013, so it might not be required yet. Sorry, give me just a second. I was looking up on the portal.
Perhaps it'd be best just to have Mr. Schubel execute to your waiver on all the applications to remove
Yeah,
that
it does-
impediment.
It does appear a waiver would be required on these, so
Okay.
to continue.
So we're now looking at a motion to continue. Is December 7th still the date that the assessor is looking for?
Christopher Horn for the Assessor's Office. Good morning.
Morning, Mr. Horn.
Yes, December 7th with the proviso
Okay.
attached to all the other.
Okay, and Mr. Schubel, is the applicant okay with December 7th?
Yes, the applicant is, and the
And-
data will be provided within
Okay.
30 days as requested.
Great. Any questions or comments from the board?
Aye.
Okay, so looking for a motion to continue these same items. Do we need to restate the items, Mr. Vlahakis?
No.
Okay, to December 7th.
So moved. With the proviso of the information within 30 days.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Thank you.
No, it's on the ballot.
Oh my gosh, we still have like 5 pages. Wow. Okay. Moving forward, item 79, application 13-12113. Applicant is Joan Roberts.
The assessor is requesting a correction to the stipulation. If Mr. Meyer, you could give the board an overview of what happened.
Yes, on this particular application, there was an error on the stipulation. We had mistyped the parcel number, so we had to get a new stipulation. The applicant has sent us an electronic form, and we request that the board approve the electronic form.
Okay. And
So there'll be two motions required. The first is to vacate the stipulation approved. Well, actually, the board could do it as one. Vacate the stipulation approved on December 8th, 2014, and approve the corrected stipulation.
okay. Any questions from the board?
I have none.
Okay, so we're looking for a motion to that effect.
And so moved.
I will second that motion.
Okay, moved by Ms. Little, second by Mr. Crow, and the motion carries. Next, item 82. Application 14-10023, applicant is Santa Paula Airport.
Good morning. Kevin McAtee on behalf of the applicant.
Morning, welcome back.
Thank you. We will be seeking a continuance.
Okay, and any other info other than looking for the continuance? I'll go to the assessor, see if there's any info we need from either one. Any comments from the assessor?
We still have not received the data from the applicant, so we would like the data within 30 days of today.
Okay. And Mr. McAtee, is the assessor looking at December 7th again in terms of a requested?
December 7th would be fine.
Okay. And is the December 7th date acceptable to the applicant?
Yes.
Okay. And there's a question about submitting data within 30 days. Is that
Not a problem.
doable? Okay. Thank you. Any questions from the board?
No.
Okay. Looking for a motion to continue to December 7th.
So moved with the proviso that information will be supplied to the assessor within 30 days.
I'll second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Thanks. Next, items 84 and 85, applications 14-10373 and 14-10374. Applicant is Chuck Kane.
Good morning, Chuck Kane.
Morning. Are you prepared to move forward today?
I am prepared to move forward on the facts that I currently have. I understand the assessor may modify the existing packet, and depending on what that modification is, I may have to change that.
Okay.
At this time, I'm prepared to move forward, and I need about 45 minutes for my presentation.
Okay. Any comments from the assessor?
The assessor is prepared to move forward. We estimate about 15 minutes for our presentation.
All right. So, Mr. Kane, we'll get through the rest of the agenda and come back and move as expeditiously as possible.
Thank you.
Okay, thank you. Next, item 86, application 14-10418, applicant CLP Anacapa Marina, LLC.
Mr. Chair, also, I believe item 87 is related, application 14-10419, CLP Ventura Marina, LLC. So if we could handle these all at once.
Sure. Morning.
Good morning. Good morning, Mr. Chair, members of the board. Patrick Tao with Independent Tax Representatives. Actually, item 87, we're going to go ahead and withdraw. These are two separate properties. 86, we've been in discussions with the assessor's office. We'd like to request continuance to work out a potential stipulation.
Okay. So first, item 87, no action required by the board. The applicant has withdrawn that application. So item 86, any comments from the assessor?
We believe we can come to a resolution without going before the board, so we'd like to continue this to 12/7.
Okay, and is December 7th acceptable to the applicant?
Yes, that is.
Okay, any questions from the board? Okay, so looking for a motion to continue to December 7th.
So moved.
Second that motion.
Okay. Moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Okay. Next, item 88. application 1410437, applicant ASN Thousand Oaks Plaza LLC.
Mr. Chairman, also related is item 89, application 1410438, Tishman Spear, Archstone Smith. These are all, I guess, sister applicants. They're all related.
Okay.
We could address these all at once. And so these were continued from July 13th, pending receipt of original stipulation. I believe the assessor's office discovered an error with the original stipulation and now needs additional time to process the proper stipulations. Is that correct, Mr. Meyer?
That is correct.
Right. Since it's just a paperwork issue, we'd recommend continuing pending stip again to October 5th, 2015.
Okay, and is the assessor in agreement?
The assessor is in agreement.
Okay. Any questions from the board? Okay, so for items 88 and 89, looking for motion to continue to October 5th.
Pending stip.
Pending step, thank you.
So moved.
Okay, moved by Ms. Little.
I'll second that motion.
Okay. And seconded by Mr. Crow, and motion carries. Next, items 90 and 91, applications 1410441, 1410443. Applicant is Macerich Oaks LLC.
No one has checked in for this item this morning. The clerk of the board would recommend denial due to lack of appearance.
Okay, any questions from the board? Any feedback from the assessor first?
The assessor has had no contact with the applicant since his continuance in May.
Okay, any questions from the board?
Move to deny based upon lack of appearance.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries. Next, item 93, application 1410568. Applicant is Alan Avakian.
Morning.
Morning.
I amended the application on June 9th, and I'm ready to move forward today.
Okay, and could you state your name for the record, please?
Alan Avakian.
Okay, thanks, Mr. Avakian. And you are ready to move forward today?
Yes, I am.
Okay.
The clerk has scheduled this as a request for amendment. This was originally scheduled for the hearing officer meeting on June 9th, 2015, and the applicant stated they wanted to amend their application, which is why it was continued to the full board today. So we only have this calendared for the board to consider the applicant's amendment. And I'm not sure exactly what their amendment request is, though.
It was for the base year value.
Okay.
And do you know the date your base year value was established?
When I purchased the home, it was December 6, 2013.
Okay.
But I requested that amendment at the last meeting.
Right, and it was rescheduled today because the three-member board has to approve that.
Okay.
So, the applicant is, in essence, do we have applications? They're requesting to amend the application to include box, in section 6, box B2, for the change in ownership date that he stated. So, I guess we don't have copies of that application. I thought we do? Okay. Sorry, the clerk will hand out copies of that application.
Okay. And while we're doing that, Mr. Avakian, does that sound consistent with what you're here for? In terms
I was
of
prepared to go forward today, but I can come back another time.
Okay. Sounds like the application would need to be amended today and then rescheduled in terms of the hearing.
That's
any comments from the assessor?
Yes, we were aware at the hearing officer that he was going to request the amendment, and we know that the board typically does allow it, so we have a case prepared so we could move forward today.
Oh, okay. So, realizing that, and we heard that the applicant's ready to move forward today.
Yes, I am.
Back to our clerk. Any reason why we should not do that?
No, if by law the parties get 45 days continuance as a right when there's an amendment, but if everyone's willing to waive those, the board could hear the matter today.
Okay.
We just need to, the board just needs to approve the amendment at this time, though.
Okay.
And for clarification, could we get the date that your purchase was recorded?
December 6, 2013.
Thank you.
Okay, any questions or comments from the board? Okay, so it looks like we need, at this time, to approve the amendment, requested amendment to the application, which would be, could you please clarify, Mr. Vlahakis?
Right. Approve the request to amend the application to include a selection in section 6 of box B2 for the change in ownership established on December 6, 2013.
Okay, and that sounds, is that consistent with the applicant's desire?
Yes, for the property base year value.
Right,
Yes.
okay. And any other questions from the board?
Would we need to also change box number 9 regarding hearing officer, changing to the 3-member board?
No, the applicant, that's a good, I have on my notes that if it was continued, it would be continued to the hearing officer meeting on October 6th. So once the board approved the amendment, I planned on continuing it to hearing officer. But if the applicant is willing to be heard by the 3-member board today instead of the hearing officer, that's okay. The applicant just has if the applicant wants to go forward today, that's fine. That part of the application doesn't need amended.
Okay. And it does sound like the applicant wants to move forward today.
That's fine with me. Yes.
Okay, so looking for a motion to approve that requested amendment to the application.
So moved.
We have a motion from Ms. Little, and Mr. Crow had asked that the assessor agrees with that.
You need us to waive?
Terms of the amendment.
Yeah, we agree with the amendment. Well, we have no authority over the amendment.
I was just relaying a question, Mr. Crow. I'm not sure if I...
You want us to waive our 45-day right for continuance?
That'd be good
that
to
wasn't the
clarify.
question, but it sounds like that might be appropriate, actually.
Yeah, we waive.
Okay.
Is the assessor prepared to go forward today?
The assessor is prepared to move forward. We estimate about 10 minutes for the presentation.
Okay, so we have a motion from Ms. Little.
Yes.
I'll second that motion.
Okay, and Mr. Crow seconds, and the motion carries. So, Mr. Vacan, we'll come back to you as quickly as we can.
Good, thank you.
Thank you. And we'll go next to item 102, application 14-10688, applicant Gregory Florescu.
We do not believe anyone has checked in for this item this morning. Therefore, the clerk of the board would recommend denial due to lack of appearance.
Okay. Any feedback from the assessor?
No comments from the assessor.
Okay. Any questions from the board?
No.
Okay, looking for a motion.
Move to deny based upon lack of appearance.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries. Next, item 103, application 14. Sorry, I'll slow down. But it is 103. If you're coming forward for 103, you can keep going.
David Shimoy on behalf of the applicant.
Okay, thank you. We'll just get caught up with our process here and okay, item 103, application 14-10723, and the applicant is, I'll spell the first name Homayoon, last name Shimolian, and
David Shimoy.
David Shimolian.
Applicant.
Welcome. Are you prepared to move forward today?
We are requesting a continuance. We've been in open dialogue with the assessor, and if we could have the hearing date on December 7th, provision to exchange all the information within the 30 days.
Okay. Thank you. Let's go to the assessor. Any comments?
No comments. We're in agreement.
Okay. Any questions from the board? Okay. Looking for a motion.
Move to continue to December 7th with the proviso that information be exchanged within 30 days.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries. Thanks. Okay, next, item 106. I see also on our screen item 160 noted, and Mr. Vlahakis, these two are probably together.
Right, it's the same applicant, so best if we
Okay.
just address it all at once.
Okay, so we'll look at items 106 and 160. First application 1410775. Applicant is Samuel Sadov. And item 160, application 1411465 with the same applicant, and I'm not sure if I pronounced the name correctly.
It's close enough.
Okay, morning. Could you state your name, please?
Samuel Sadov.
Okay, and Mr. Sadov, are you prepared to move forward today?
Well, I understand from meeting with the assessor, and correct me if I'm wrong on this, on one of these, I believe it's the 160, we have an agreement, that's the fuel dock, and everything's okay, and we don't, I agree to what your assessment is on the fuel dock.
Yeah, I don't remember which application that was, but I know you said you'd probably withdraw one of them.
Yeah, that's the
But
Dave's fuel dock. I think that's 160, but I'm not absolutely sure of that. And then the other one, what I discussed with the assessor to do is, and I'm not, I'll wait for them.
Okay.
Just, I show item 160 is for 1404 Anchors Way Drive in Ventura, doing business as Dave's. Is
That's
that what
fuel. That's the one. That's the fuel dock. Yeah.
Okay, so you are withdrawing that application?
That should be withdrawn because we have an agreement, I think.
Well, I think we should just keep them both open for now.
Oh, okay.
Because we have an open dialogue with Mr. Sadov, so we would like to wait a little while and just continue this to December 7th, and I believe we can resolve everything prior to that date.
Again, I think we're at a close point of not having to come back here again.
Okay, so Mr. Sadov, for both items 106 and 160, continuing to December 7th is acceptable?
I hope I don't have to come back.
You sure you don't want to come back? It's a lot of fun. Okay, any questions from the board? Okay, so looking for a motion to continue to 12/7.
So moved.
I will second that motion.
Okay, moved by Mrs. Little, seconded by Mr. Crow, and motion carries. Thanks. Okay, next items 108 through 110. Applications 1410869, 1410871, and 72. Applicant is Caneo Business Park LLC.
The assessor is requesting a correction on these stipulations. Mr. Meyer, if you could please explain to the board. Oh, and this will require vacating the stipulations approved on May 18th, 2015, and approving the corrected stipulations.
This was another administrative error. Basically, we had stipulated with the applicant on a value, and when we did the stipulation, we were not aware of an assessment roll correction that was in the works. So they basically had to reallocate the values in order to get the stipulated value correct.
Okay. And is there a specific, in terms of the new corrected stipulation, is there a specific stipulation we should be approving?
It was provided to the board.
Is it in? It's in the included in the others that we
right.
have?
Oh,
And these were already sent to us in advance, right?
Right, they were distributed to the board on Friday morning, I believe. So
Okay.
they've been emailed to the board.
Okay, so first we'll ask if the board needs to take time to review the corrected stipulations, which apparently were included in the ones sent to us previously.
Correct.
Okay.
It came over email.
Okay. So then we're asked to make two motions. The first being to vacate prior stipulations, and the second to approve the corrected stipulations. Is that correct, Mr. Vlahakis?
Yeah, that can just be included
All in
as
one
motion.
Oh, okay, great. So looking for a motion.
So moved.
I will second that motion.
Okay. Now moved by Ms. Little, seconded by Mr. Crow, and motion carries. Next items 111 and 112, applications. Oh.
No, you're right.
Okay. 14-10884 and 885, applicant LQ Thousand Oaks LLC.
Sorry, as note, same applicant is also items 219 through 220, applications 14-12242 and 14-12243. They're all for applicant LQ Thousand Oaks LLC.
Okay. Mr. Schubel?
Good morning. Kenneth Schubel, Ryan, LLC. This is a case of, correct me if I'm wrong, there's an assessment roll correction is going or needs to be done. So we were advised by, I'm handling this for somebody else in my office, but we were advised that these 4 applications can be continued pending the resolution of that business, and then we would, I guess, address it after that.
Okay. Any comments from the assessor?
Yes, basically, as he said, we have another assessment roll correction in the works. So before we can go on with these hearings, we need to go ahead and get that completed. So we're recommending December 7th.
Okay. Any questions from the board?
Is there any data to be exchanged?
I'm sorry?
Any data to be exchanged between the parties?
Actually, we were working on a stipulation with this application already, so we had that prepared. Then we found the error, administrative error that we need to correct.
Okay, so.
Okay. So looking for a motion to continue to December 7th.
So moved.
I will second that motion.
Okay. Moved by Ms. Little, seconded by Mr. Crow. And motion carries.
Thank you.
And that was, just to clarify, that was both for items 111 and 112.
And 219 through 220.
219 through 220. Thank you. Next item 113, application 14-10960. Applicant is American Investment Group.
Good morning. My name is Carlo Oshani.
Good morning. And Mr. Oshani, are you prepared to move forward today?
No, we would like to get an extension. I spoke to Mr. Horn, and we would like to ask for more time to get the data together so we can get it to Mr. Horn.
Okay, and yes, any comments from the assessor?
Again, Christopher Horn for the assessor's office. I talked to Mr. Oshani today, and he was here previously on May 4th and provided some documentation. At that time, he was given a copy of the 441D letter. Somehow along the way, that letter got misplaced, and he is interested in providing more documentation to our office. I see no reason why we shouldn't allow that to happen. So he and I will be in better contact. I have his card, his email, and I will send him a copy of the 441D letter either at the end of business today or sometime during business tomorrow.
Okay, and so Mr. Horn, is a continuance to December 7th is my guess?
That would suffice. Thank you.
Okay, and Mr. Oshani, is December 7th acceptable?
That would be fine, sure.
Okay. Any comments from the board?
Nope.
Okay, so looking for a motion to continue.
Motion to continue to December 7th.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries. Okay. Next items 114 and 115, applications 14-10964 and 65. Applicant is Howling Nurseries, Oxnard, Inc. Morning.
Good morning. Gilbert Arceba with Property Tax Assistance.
Okay, and Mr. Arceba, are you prepared to move forward today?
No, we'd like to schedule a continuance. I've been working with Mr. Arnold Greenberg from the assessor's office. He's had all our information. There was some transition between Arnold and the prior appraiser, but these appeals have always been resolved. I anticipate they should get resolved. Just with the transition with the new appraiser, we would need a little bit more time from the
Okay.
assessor.
Thank you. Any comments from the assessor?
A continuance would be fine at this time.
Okay, December 7th?
December 7th I believe we have all the data, but if there's any missing data, we'd like that within 30 days, please.
Yes,
Okay, and December 7th acceptable to
that works.
the applicant? And I'm sorry, did you just both agree on the 30-day
That's fine.
submittal? Okay, so looking for a motion.
Move to continue to December 7th with additional information, if required by either side, be within 30 days.
Okay.
I will second that motion.
Okay. Moved by Ms. Little, seconded by Mr. Crow, and motion carries. Thank you. Okay. Okay, next item 116, application 1411003. Applicant is Mission Bell East LP.
No one has checked in for this item this morning. The clerk of the board would recommend denial due to lack of appearance.
Okay, any comments from the assessor?
No comments from the assessor.
Okay. Any questions from the board?
Move to deny based upon lack of appearance.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries. Next, we'll go to item 117. Application 1411018. Applicant is James Keefe.
No one has checked in for this item. The clerk of the board would recommend denial due to lack of appearance.
All right. Any comments from the assessor?
No comments from the assessor.
Any questions from the board? Okay. Looking for a motion.
Move to deny based upon lack of appearance.
I will second that motion.
Okay. Moved by Ms. Little, seconded by Mr. Crow, and motion carries. Next, item 118, application 1411074. Applicant is, I'll spell it, first name Jens, last name Reupsch. Hi. Could you please state your name for the record?
Jens Wilkes.
Okay. Thank you.
It's the clerk's understanding that the applicant wants to amend their application to include their base year values, but there's not. The applicant has several base year values, so we're not exactly clear which ones are within the 4 years eligible to be appealed, and which ones the applicant wants to appeal. So I'd recommend coming back to this so we can go over with the applicant exactly what they have rights to appeal and figure out what they can amend their application to include, because we didn't have all the information until this morning, and so it's not completely clear. I haven't had time to examine what they're eligible to appear, nor have I discussed with the applicant what they want to appeal. So if we could just trail this and come back to it.
Okay, any questions from the board first?
No, maybe.
Any comments from the assessor?
Our comments will be reserved for when we trail this.
Okay, so then Mr. Roach will probably come back to you shortly, and we'll keep moving forward. Okay, thank you. Next, item 119, application 1411103. Applicant is IMT Capital Westlake.
Kenton Schubel, Ryan LLC for the applicant.
Hi, Mr. Schubel. Are you prepared to move forward?
We are not, Mr. Chairman. The 2013 Prop 8 on this same property was continued at the last hearing. We'd like to get the 13 resolved and then the 14 after which. So if we could continue the 14.
Okay, any comments from the assessor?
Do you happen to know what date that was continued to?
I want to say December 3rd. Does that sound right? For only 7?
Well, we have either November 2nd or December 7th. Do you know what the application numbers are?
I can tell you, just a minute, please.
And Mr. Velakis can go ahead and check that.
It's the same applicant name?
Yes, it is. I'm sorry, I don't have it in front of me, the
I can
application.
find it real quick.
All right, thank you.
IMT Westlake Capital IMT Capital Westlake Village LLC 13-12105 is calendared for December 7th, 2015.
Okay. And December 7th, acceptable to both for a continuance?
For the applicant, it is.
Okay. And so no action today, just a continuance? Is that where we all are right now? Sounds like it's a yes. Okay.
That's our request,
Any,
yes.
any questions from the board? Comments?
Any information need to be exchanged?
It will be, yes.
Okay. Move to continue to December 7th with the proviso that any information be exchanged within 30 days from today.
Second that motion.
Okay, moved by Ms. Little and seconded by Mr. Crow, and motion carries.
Thank you.
Thank you.
And I have the next one as well.
Okay, item 120, application 14-11104, applicant IMT Cap 2000 Oaks.
And Kenton Schubel Ryan LLC for the applicant. In this case, the 2013 was withdrawn. I'm assuming that the 2014 should be withdrawn also, but we would like to request a continuance to confirm, and then we can withdraw administratively.
Okay. Any comments from the assessor?
Christopher Horn for the assessor's office again. More than likely, these will end up being withdrawn. The base year value was resolved, but the corrected factor base year values didn't get on the roll. So we're in the process of having ARCs processed. So in continuing these to a later date, the corrected values will get put on the roll and the taxpayer will be notified, and then Mr. Schubel can do the administrative withdrawal of the paperwork.
Okay.
So December 7th would be sufficient time.
Okay, is that acceptable to the applicant?
Yes, it is.
Okay, any questions from the board? Okay, looking for motion to continue to 12/7.
So moved.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Sure. Okay, next.
One as well.
Okay, items 121 and 122, applications 14-11114 and 15, applicant MEF Realty LLC.
And it's my understanding that the
Oh,
you were
God,
talking
sorry.
about this one, I
Yeah,
think. That's
sorry.
all right. Doesn't matter.
It doesn't matter. Sorry, Christopher Horn. I thought we were handling 119 and 120 together.
Oh, okay.
So my previous comments were in essence for 121 and 122. It's definitely a day.
Okay.
So
12/7?
So December 7th across the board.
Okay, and Mr. Schubel?
That's fine.
Okay, so translated, we're looking for a continuance to December 7th. If there's
So
motion.
moved.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Next item 126.
No one has checked in for this item this morning, therefore the clerk of the board would recommend denial due to lack of appearance.
Okay, and that's application 14-11132. The applicant is 108 North Robertson LLC. Anyone here representing that application? No. Any comments from the
No
assessors?
comments from the assessors.
Okay. And any board comments?
Move to deny based upon lack of appearance.
I will second that motion.
Okay. Moved by Ms. Little, seconded by Mr. Crow, and motion carries.
We get 123.
123 through 125 was on the agenda review. Yeah, thank you. Okay, next item 127, application 14-11137, applicant Ohana 9 LP.
Good morning. Robert Slavin on behalf of Ohana 9 LLC.
Welcome back.
Thank you. Mr. Chairman, member of the board, I'd like to request a postponement, or actually a continuance on this case. I believe if it's possible, if we could do the November
hearing date that would work for my client who needs to testify here in front of the board. There's some evidentiary issues here regarding a Rule 2 issue, and it would be helpful. I've cleared that date with him. He is an arbitrator and a city councilman, and he's got a very busy schedule, and I've nailed him down to that particular date. So if we could do the November hearing, that would be fantastic.
Okay, and any feedback from the assessor?
We currently have over 200 cases scheduled for November 7th, and we're certain, we believe, with some relative certainty, that at least 4 cases are already going forward that day. We prefer December 7th.
Okay, and so that was November...
I guess November 2nd.
2nd. Yeah. And is November 2nd the date, Mr. Slavin?
Well, that was the date that I cleared.
That you had requested?
Yes. I guess my request would be, if he cannot do December 7th, I would be able to find out within 24 hours and contact the clerk of the board. It would be possible then to switch that to the next meeting date.
Okay, any questions, comments from the board?
No, just wondering about a 2-year waiver as we start pushing it out.
Okay.
Be happy to sign a 2-year waiver.
Okay.
2-year waiver is not necessary on this application, I believe.
Okay.
That's correct. We don't need a waiver.
Okay.
Okay, so it sounds like the applicant can confirm appearance November 2nd, cannot at this time on December 7th. Any comments from the board on that?
The clerk would also note that this agent already has cases scheduled for November 2nd, so it would be the clerk's preference to schedule this for November 2nd.
Okay. We've heard from the assessor. So any?
Well, my concern is if he is not in contact with the applicant to confirm
Right.
December 7th,
Then can't confirm it.
then it's kind of open.
Right.
Mr. Chair? I'm sorry.
Go ahead.
The assessor is willing to give to the November date.
Okay.
But there needs to be an understanding on the part of Mr. Slavin's client that he may not be heard that day because it's such a full schedule. So I'm just, we'll agree to it, but, and we appreciate him clearing his schedule and making sure he's available, but due to the already packed agenda, and I know I have anywhere from 2 to 4 cases that I'm going to have to present besides this one, I am, there's no guarantee that the November date is going to be the resolution date. I think that's the point that needs to be made.
Would it be possible for me to make and I apologize here, if I could make a telephone call or send a text and find out about the December date?
Why don't you do that? We'll trail your item and come back.
Thank you very much.
Okay. And our next item will be 129 and 130. Okay. Okay, items 129 and 130, applications 1411277 and 278, applicant Century Theaters, Inc. Morning.
Good morning, Mr. Chairman and the board. Vincent Brown for the applicant.
Morning, Mr. Brown. Are you prepared to move forward today?
No, we're not. We'd like to request our first request for a postponement or a continuance. This is kind of a special use property, closed movie theater, and we've decided to we have engaged a third-party appraiser, an MAI, to do a full appraisal, and we didn't have that in time for the hearing today, so we'd like to request a continuance based on that.
Thank you. Any comments from the assessor?
No comments from the assessor. We are willing to continue this to December 7th.
Okay. December 7th, acceptable to the applicant?
It is. One thing, 30 days isn't going to be possible. It's going to take about 45 to 50 days. It's a full-blown appraisal. They started last week, so we'll get it the day we get it. We'll give it to the assessor's office. It's a full-blown appraisal. So.
Okay. In that case, we would like that appraisal no less than 30 days prior to December 7th.
That won't be a problem, yeah.
Okay. Any questions from the board? Okay, so looking for a motion to continue to December 7th with the notes.
With the proviso that any information be exchanged 30 days prior to the hearing.
Okay. And so moved by Ms. Little.
I will second that motion.
Okay. Thanks, Mr. Crow. Seconded by Mr. Crow, and motion carries. Thanks.
Great, thank you.
Okay, next items 131 and 132. Applications 14-11279 and 14-11280. Applicant is Kasdan Oxnard Vineyard.
Kenton Jubal, Ryan LLC for the applicant. Mr. Chairman, this is a 2014 Prop 8. We had a delay in getting information from the taxpayer regarding the status of the property, its land for development. So we'd like to request a continuance in order to provide information to the assessor. In the event that there's nothing to support a reduction, then we will withdraw administratively.
Okay, December 7th, agreeable?
Yes, that's fine. Thank you.
Okay, any comments from the assessor?
Just that we receive the data no less than 30 days from today.
Okay, Mr. Schubel, is that acceptable?
Yes, it is.
Okay, any questions from the board?
No.
Okay, looking for a motion.
Move to continue to December 7th with the proviso that any information be exchanged within 30 days.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Thanks, Mr. Schubel. And next, item 133.
Also, Kenton Jubal, Ryan LLC for the applicant.
Okay. Let me just, I was just waiting for us all to catch up, so I'll just state the info. Application 14-11290, applicant Winco Foods LLC. Okay.
Should I repeat myself? Yeah.
Your turn.
Okay. So I'm apologize to the board. I know this. My company has agency. I'm not familiar with this. I might ask the assessor if they're aware of anyone's agreement to continue or withdraw on this case.
Christopher Horn for the assessor's office. There was no agreement to continue or withdraw, but we're happy to withdraw.
Sure.
Agree to a withdrawal at the moment. The last we understood was that one of your colleagues was going to try to procure construction costs.
Okay.
And as of yet, they haven't been provided, and that's a very important piece in the puzzle.
Okay. My apologies to the board and to the assessor that wasn't taken care of before today, and I was not apprised of the situation. On behalf of the applicant, I'd like to request a continuation, and I will get the information for the assessor or a withdrawal so that we don't trouble the board with this again for no reason.
Okay. Acceptable to the assessor, or any other comment?
It is acceptable. Please do not take my comments, Mr. Schubel, as a reflection on your colleague. It may very well be the applicant who's lax in providing the information.
Okay.
December 7th is fine.
Okay. Any questions from the board? Okay, so looking for motion to continue to December 7th.
So moved.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Thank you. Okay, next items 140 and 141.
Excuse me, Mr. Stern, did we skip 135?
I had 135 crossed off my list. I thought, was that on the agenda review? Or did we?
We removed that from our agenda review. I don't think we actually handled it.
Oh, we removed it from the agenda review. Okay, so let's, thank you.
Mr. Chairman,
Mr.
before you proceed, may I comment? I was the one who brought up, I misspoke because I had already crossed it off myself. It's actually item 136 I was discussing, not 135. We don't have any representation for the applicant of 135.
Okay, so then 135 originally was on the agenda review, so I guess let's just go back and cover that one. Application 14-11295, and applicant is Mayland Enterprises Property Tax. Mr. Vlahakis, this was originally on agenda review. Is it?
So,
what's the status?
Mr. Schubel, you're saying this is for Ryan LLC. Is it a different subsidiary of the company?
So, to make a further mess of it, when I spoke up during agenda review, I was referring to item 136. I see now that item 135 does have Ryan on it. May I ask, did the clerk receive any communication regarding that from anyone?
No, they did not confirm appearance, so other than us mailing them notice of hearing, nothing has happened on that item.
What I could request the board, besides asking their forbearance, is that both items 135 and 136, if I may request a continuance, and then I'll make sure that we get it addressed immediately and a withdrawal if there's no case to go forward, administrative withdrawal.
Okay, any comments from the assessor?
December 7th would be the best date for continuance with information provided within 30 days of today.
Okay, any questions from the board?
If the board could just apply their motion only to 135 at this time, because we have a separate issue with 136 now, which I'll address in a second. But so we could just do 135 first.
Okay. So looking for a motion.
Move to continue to December 7th with the proviso that any information be exchanged within 30 days from today's date.
I will second that motion.
Okay, moved by Ms. Little and seconded by Mr. Crow, and motion carries. Now, 136 was not included in the agenda review, Mr. Vlahakis?
136 was denied due to lack of
Right.
appearance, so the board needs to vacate and then continue because they already denied the case due to lack of appearance. So,
Okay, so
that's
that-
why this one's special.
Is that what is being requested by the applicant, Mr. Schubel?
It is, yes.
Okay, any comments from the assessor on this one? Or is it same?
Same issue.
Okay, so any questions from the board? Okay, so I think it takes two motions, and the first would be to vacate the prior decision to deny due to lack of appearance.
So moved.
Okay, moved by Mr. Crow.
Sorry. Okay, now you should be able to push it. Mr. Crow, you should be able to push the button now.
Oh.
Sorry, I wasn't caught up.
Okay.
I'll second.
Lots of buttons.
Okay.
Okay, seconded by Ms. Little, and motion carries. So second motion would be to continue, I believe, to December 7th with the other notes about information.
So moved.
And just to clarify, Mr. Crow, that was with the 30-day requirement of submission of information? Okay.
You seconded.
Oh. Okay, so moved by Mr. Crow, seconded by Ms. Little?
Are you gonna second?
Okay. Yes. I saw your name up there
Oh.
on the screen.
There was an error.
Okay.
fixed it.
I'll second.
Motion carries. Okay, on to items 140 and 141, I think.
You're still up, Mr. Schubel.
Okay, you're not getting off that easy. Applications 14-11318 and 19, applicant is Simi Entertainment Plaza.
Okay, Kenton Schubel, Ryan LLC for the applicant. Mr. Chairman and members of the board, we provided income and expense information for this property to the assessor, but it was very late. So we would like to request a continuation so the assessor may have time to review the information and ask for any further data they may need.
Okay. Any comments from the assessor?
Christopher Horn for the Assessor's Office again. Yes, Mr. Schubel did send us data late last week, I believe it was.
That's correct.
We haven't gone through all of it yet because we were amping up for today's journey. As soon as we do, if there's anything missing, we'll let Mr. Schubel know, and if there's any additional information, we'll request it. So if we can, I'll try to get to that within either at the end of today or tomorrow.
Okay.
And then if we can get any additional data, if so needed, within 30 days, it would be wonderful.
Definitely, we will do that.
So continuance to December 7th?
Sorry, continuance for December 7th.
Okay. And any questions from the board?
No.
Okay, so looking for a motion to that effect.
Move to continue to December 7th with the proviso that any additional information be supplied within 30 days.
It will be.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow. Motion carries.
Thank you.
Next, items 143 through 146, applications 14-11334 through 14-11337. Applicant is Thomas and Arlene Lutzak.
Good morning, Mr. Chairman.
Morning. Could you state your name, please, for the record?
Elliot Kimmel, agent for applicant.
Welcome back, Mr. Kimmel.
Thank you.
Are you prepared to move forward today?
We will actually be requesting a continuance. We were having issues as far as supplying the income and information to the assessor's office. I have given hard copies of all the information, and if anything is outstanding, be more than happy to be able to provide that information.
Okay. Any comments from the assessor?
Christopher Horn for the assessor's office. Yes, Mr. Kimmel showed up this morning with a nice envelope of not only this, but some of the subsequent appeals. We haven't had a time to go through, or the opportunity to go through what's here, what isn't, but we will be in contact with him should there be anything missing or anything more required. So if we can do the proviso of 30 days, that would be wonderful, with a continuance to December 7th.
Okay. December 7th, acceptable?
Yes, sir. Thank you.
Any questions from the board?
No.
Okay, looking for a motion.
Move to continue to December 7th with the proviso that any additional information between the parties be exchanged within 30 days.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank
you. Next, let's see, we were trailing 160.
150.
So I think, are we at 161 or we're
No, there's a
150.
Sorry. So 147 through 150, only 147 was withdrawn, and 148 through
thank you.
150 are open for the same agent.
Got it. Thank you. Items 148 through 150, applications 14-11338 through 41. Applicant is Ojai Oil Company.
And Mr. Chairman, same reasons. The information has been at least provided. If anything is missing, be more than happy to send it over to Mr. Horn.
Okay.
Christopher Horn for the assessor's office. It's the same song, different verse as the previous cases. Continuance December 7th until we can go through the data that's provided today and find out if there's anything additional, and then proviso within 30 days.
Okay. December 7th, acceptable?
Yes, sir.
Mr. Kimmel? Okay. Any questions from the board?
Yes,
Comments?
yes. Before we go forward, 147 was taken care of on the agenda review, so I don't know if application 14-11338.
Oh, you're right. Thank you. So if we could, thanks, Ms. Little. So if we could just clarify from our clerk
Right,
the applications associated with 148 through 150.
Correct. It's 14-11339 through 14-11341.
Okay, great. Thank you. Thanks, Ms. Little. So looking for a motion to continue to December 7th.
So moved with the proviso that any information additionally be exchanged within 30 days.
Okay.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Question for the chair. Did we skip 143 through 146, or was that handled previously?
We did that.
We skipped 142, but since we can go back to that.
Okay.
This agent, I think, still has some more cases.
Okay, so thanks, Ms. Porsche. Mr. Vlahakis, could you just clarify which item we should be?
We skipped
reading?
142. I believe we're now on item 152, though.
Correct.
Okay, so 143 through 136 already resolved.
Right. The board continued those to December 7th.
Okay, and now 152 through 155.
Correct.
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 Okay. Tierra Rajada LLC. Okay, applications 14-11343 through 14-11346.
Again, we would like to request a continuance to that December 7th date, and if any additional information is needed, we'll be happy to provide within a timely manner.
Okay, any comments from the assessor?
We'll be happy to agree to that.
Okay, December 7th?
Yes, sir.
Okay, and December 7th still okay with the applicant, I
Yes,
assume?
sir. Thank you.
Okay, any questions from the board?
No.
Okay, looking for a motion to continue to December 7th.
So moved with the proviso regarding the exchange of information.
I'll second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow. And motion carries. Okay, I think we're at item 161, but I'll let our clerk...
No, that's correct. I just want to confirm that 156 through 157 were proactively withdrawn.
Right. 156 through 157 were covered on agenda review this morning and have been withdrawn.
Excellent. Thank you.
Okay, thank you.
Chairman, if we could go back to item 142, there is someone present for that item.
Okay. So let's revisit item 142, application 14-11331. Applicant is Sam and Vera Menlo Trust. Morning.
Good morning, board members. My name's Ricky Dennis. I'm agent for the applicant.
Okay. Good morning. Are you prepared to move forward today?
No, we were substituted agents for the prior agent that filed. We'd like to request the case be continued to December 7th. Also, on that particular day, we'd like to have the properties is one of, looks like about 8 properties on one shopping center, eight parcels on one shopping center. And those parcels are ending in 095, 085, 225, 045, 215, 205, and 015. They're all part of the same shopping center as this particular parcel that's up for hearing today. We'd like to, on the postponement, we'd like to consolidate all those other parcels with that same hearing on that same date. At this point, we have not been; those other parcels have not been scheduled for that date.
Okay. Thank you. Let's first go to our clerk with any comments.
The clerk has those were applications filed. This application, subject application, was filed by a different agent, and then a bunch were filed later by this new agent.
Okay.
And so the clerk has those set aside. We plan to schedule those for whatever date that this item is continued to today. So we have them all set aside, and we will be scheduling for the same date. If for some reason the clerk messes up the paperwork and doesn't get them scheduled for the same date, the agent will have a right to postpone or make a consolidation request to have them on the same date. So I don't anticipate that happening, but one way or the other, they'll end up on the same date.
Okay. Thank you. Any comments from the assessor?
Christopher Horn for the Assessor's Office. We have no problem in looking at these. We noticed that there were some outliers that hadn't been scheduled. I think it's smart on the part of the clerk to try and consolidate everything on, to one day, December 7th, so we can look at it as an appraisal unit. We're agreeable to that with the proviso that we get the information within 30 days.
Okay. And so do we need to, Mr. Vlahakis, do we need to first vacate a...
No, we had removed this one from agenda review.
Oh, it was removed.
It wasn't addressed during agenda review.
Okay. Any questions from the board?
Was all of the applications timely filed?
Yes. I don't remember the exact reason why. I think they might not be regular applications. They might be escape assessment appeals or supplemental, something like that. But everything's timely. They were just filed. They were like some of the very last applications filed for 2014. So they are in our group that hasn't been scheduled yet. But we have them set aside. We'll schedule them. They just hadn't got scheduled for today because they came in so much later.
So is the amendment going to be to have a December 7th hearing with all the parcels, or are you going to...
So the board can't take any action on the cases that aren't scheduled for today.
I see.
So the clerk is just telling you, we'll schedule them for the same day.
I
For
see.
some reason, it doesn't work out that way. You can make a consolidation request,
Okay.
and we'll put them all on the same date.
Okay.
One way or the other, they'll all end up on the same date.
Okay. Our only request then is we haven't, because we're a new agent, we haven't received the request for information from the assessor on the other parcel. So, we'd like to present the appraiser all the requested information. We just haven't received that, so we'd like a copy of that request or have it sent with the other 7 other parcels that are being scheduled.
The assessor wouldn't have sent a 441D request to you when there's a change in change in agents.
Right.
We expect all the paperwork to slowly move along.
Okay.
We can provide you with another copy.
Yeah,
that would be helpful.
Yeah, there's no problem if you will collect my card and then send me an email. I'll be happy to send all 441D letters to you.
Perfect.
Okay, thanks. So without any other comments, we're looking for a motion to continue to December 7th.
So moved with the proviso that any information be exchanged between the parties within 30 days.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Thanks. Okay, to our clerk, I think 161 should be next. Okay, so item 161, application 14-11479. Applicant is Farzin Daneshnia.
Okay. They called in this morning asking where the hearing was, so he submitted a withdrawal. Can I examine that real quick? Okay. So it was originally a request for reconsideration, but the applicant has withdrawn their application. So the board just needs to take no action. The application has been withdrawn.
Okay. Thank you. Next, items 165 through 180, applications 14-11690 through 14-11705, and the applicant is Fresh and Easy.
Hello again.
Mr. Daza?
Rene Daza, yes. For these appeals, they should all be real property appeals, is that correct?
I have no idea what these applications are for.
Okay. We have 2 sets of appeals for Fresh and Easy. One's real property and one's personal property. Just want to confirm that these are all real property cases.
Application 14-11690 is for real property at 4473 Alamo in Simi Valley. Application 14-11691 is for personal property located at 4473 Alamo Street. Application 14-11692 is for real property located at 5101 Telegraph Road in Ventura. Application 14-11693 is for personal property located at 5101 Telegraph Road in Ventura. Application 14-11694 is for real property located on Los Angeles Avenue in Moore Park. Application 14-11695 is for personal property located at 144 West Los Angeles Avenue. Application 14-11696 is for real property located at 1750 East Channel Islands Boulevard in Oxnard. Application 14-11697 is for personal property located at 1750 East Channel Islands Boulevard. Application 14-11698 is for real property located at 1710 East Gonzales Road in Oxnard. Application 14-11699 is for personal property located at 1710 East Gonzales Road. Application 14-11700 is for real property located at 1710 East Gonzales Road in Oxnard. And last, no, not quite, 14-11701 is for real property located at 144 West Los Angeles Avenue in Moore Park. 14-11702 is for personal property located at 2260 East Thompson Boulevard. 14-11703 is for personal property located at 2249 Las Posas Road. Application 14-11704 is for personal property located at 632 Lindero Canyon Road. And application number 14-11705 is for personal property located at 727 North Windy Drive.
Okay. So we'd like to withdraw all the real property appeals that were read by the clerk.
Okay. And does that cover everything within this group, Mr. Vlahakis?
No, so that only covers, that covers the ones application numbers that I said were real property. So anything I said was, did I say personal property? Unsecured property are not covered by that withdrawal.
Okay, so noted that the real property applications are withdrawn. And Mr. Daza, what's the status of the others?
On the personal property, I'd like to ask for a continuance.
Okay.
We have been in talks with the assessor's office, and we shared some information, but there was a bankruptcy issue back in 2013, so it's a little difficult to get all the documents, and the assessor's office request for information also has additional information that's not easily available to our clients.
Okay, thanks. Any comments from the assessor?
It continues to December 7th would be in order.
Okay, December 7th, okay, Mr. Daza?
As of right now, yes.
Okay. Any questions from the board?
Is there any information that needs to get exchanged?
Yeah, we'd like all the information within 30 days of today.
Okay, Mr. Daza, is that doable?
Yes, we're working on it.
Okay. So, Mr. Vlahakis, do we need specific application numbers that we're continuing?
I would say the clerk is going to figure it out and specify in the motion. So if I've read into the record what application numbers go with each. I wasn't keeping track as I was reading them. So
maybe a motion to continue the items that include personal property?
Correct. That I can work with that.
Okay.
Move to continue the items that only for personal property to December 7th with the proviso that any information between the parties be exchanged within 30 days.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries.
Thank you.
Thank you. Next, items 181 through 183. Hold on one second. We get caught up with our.
I don't know what's going on with my equipment.
Oh, okay. We'll do it the old-fashioned way. Applications 14-11706, 07, and 14-12170. Applicant is Sue Mathis. Morning.
Hi, Steve Calandra.
Okay.
I'm sorry. Go ahead.
No, go ahead, Mr. Calandra. Are you prepared to move forward today?
I am, but I'd like to request a continuance in effort to continue working with the appraiser assigned to this, Rick Denham, to resolve it without going before the board.
Okay.
I requested information on it going back, I think, to March originally, and there were a bunch of different files, and there was some confusion as to which ones we were doing. And we got it resolved, but I didn't get the data until mid-July, and I was out of the state for 2 weeks, and then we haven't had time to fully try and address it between then and now.
Okay. Any comments from the assessor?
We were prepared to move forward today, and the agent indicated he was prepared to move forward today.
Okay.
I can say right now, we're not going to come to any resolution without the board's intervention.
Okay, so Mr. Meyer, the applicant has requested a continuance. Looks like there have not been any so far with these applications. Is that correct?
That is correct. They were originally two of the applications. So 14-12170 is for a supplemental assessment, and that was originally scheduled for today, I believe. But applications 14-11706 and 14-11707 are the subsequent years' role changes for adjustment of the supplemental, and so that it was consolidated so that from June 22nd to today, so that the supplemental could be decided before the role changes, because if they're successful in the supplemental, it automatically lowers the future years. So that's why it's all been consolidated to today, but there were no continuances issued on these cases prior.
Okay, thank you. Any comments from the board? Questions? Okay, and just to confirm, Mr. Calandra, the applicant is asking for a continuance?
Yes.
Okay. And back to the assessor, if the board grants a continuance, would December 7th be the date that would be
December 7th
best?
is our date. So,
Since I haven't heard any other dates all day.
He already gave us all of his information, though. I don't
Yeah.
think he can give us any other information that would be relevant.
Okay. So to the board, if there's any discussion, that's fine, or if there's a motion.
Move to continue to December 7th.
Okay.
I will second that motion.
Okay, moved by Ms. Little and seconded by Mr. Crow, and motion continues. So we're continued to December 7th.
Okay, great. Thank you.
Okay, thank you. Okay, next items 184 through 189, applications 14-12048 through 14-12053. Applicant is Dale O. Shelton Trust.
I believe stipulations were submitted to the board for this morning. I'm not sure exactly what we received.
Oh, it's this. There we go.
Yeah, so if the board wants to quickly review these.
Okay, Mr. Crow.
So if the board agrees with the stipulations, we'd recommend that the board approve them today so that the applicant isn't delayed in receiving their refunds if we had to continue to the next hearing, which is in
Okay.
October.
Okay, any questions or comments from the board? Okay, so looking for a motion to approve the stipulations for items 184 through 189.
So moved.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow. Motion carries. Next, items 190 through 193. Applications 14-12164 through 14-12167. Applicant is Citibank N.A.
Kenton Schubel, Ryan LLC for the applicant. I just received a communication. We'd like to request to withdraw these applications.
Okay, so the applicant has withdrawn the applications. No action necessary from the board. Thank you. And we'll go next to items 194 and 195. Applications 14-12168 14-12169. Applicant Pleasant Valley Venture LLC.
And Kenton Schubel Ryan LLC for the applicant. And Mr. Chairman, members of the board, we've provided some information to the assessor as well as had some questions for the assessor regarding this base year assessment. So the applicant would like to request to continue so that we could discuss further with the assessor.
Okay. Any comments from the assessor?
December 7th, 30 days from today, we'd like the information, please.
Okay. Mr. Schubel, December 7th, acceptable? Yes. And is the applicant able to provide requested information within 30 days?
Yes, we are.
Okay. Any questions from the board?
No.
Okay. Looking for a motion, please.
Move to continue to December 7th with the proviso that any information be exchanged within the next 30 days.
I'll second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow. And motion carries.
Thank you.
Thank you.
Oh, yes, sorry. Missed it.
Yep.
Thank you.
Okay, I believe next up is number 215, is that correct?
That's what I have.
Okay.
We're good. Okay at keeping track, so.
Yep. Okay, item 215, application 14-12219. Applicant is Brian Delegan.
No one has checked in for this item, therefore the clerk of the board is recommending denial due to lack of appearance.
Okay, any comments from the assessor?
The applicant called us last week and said he was going on vacation.
Okay. Probably a smart thing to do. Okay. Any comments from the board? Okay, so looking for a motion.
Move to deny based upon lack of appearance.
I'll second that motion.
Okay, moved by Ms. Little and seconded by Mr. Crow, and motion carries. Next, item 217, application 14-12226. Am I waiting for us to catch up, or should I just keep going? Okay.
I don't know what's the problem statement here.
Okay. I'll spell the first name Xuan and last name Shunro.
Yes, Sunro Xuan.
Good morning.
I have the document for the 6 documents.
Okay. Before we do that, let's just find out what the status is of your application, and then we'll make sure we go through the right process.
Okay.
Could you please state your name for the record?
Sunro Xuan.
Okay.
First name is Sunro.
Okay.
Hello.
And so it sounds like you're prepared to move forward today with your your appeal? Okay, so let's hear from the assessor with any comments.
Yeah, we are prepared to move forward. We estimate about 15, maybe 20 minutes on this one.
Okay. And to the applicant, any estimate of how long it might take to present your information?
Yes, that's my husband. And he is most talking, but I hope that because I have a short brace, very difficult talking.
Okay.
He were talking, but he have a hearing problem. So I hope that maybe he will ask again. You just speak a little bit loud.
And I know we also have.
I have hearing aids, but I say even with the hearing aids, I could hardly follow any conversation so far. So
okay, we'll make sure that we communicate clearly and get through the process. Do you know about how long it would take to present your information?
Probably 10 minutes or so.
Okay. So we are almost to the very end of the agenda, and then we'll come back and hear all the items that are moving forward. So we'll be back with you as soon as possible.
Okay.
Okay?
Thank you.
Okay, thank you. Okay, the last item on our agenda before we move forward with the hearings is number 218, application 14-12241. Applicant is Bold Enterprises, LLC.
No one has checked in for this item this morning, therefore the clerk of the board is recommending denial due to lack of appearance.
Okay, any feedback from the assessor?
No information from this applicant whatsoever. Before you go on after this, we're done with this item, I have a few comments I'd like to make.
Okay. Any questions from the board on item 218?
No.
Okay. So looking for a motion.
Move to deny based upon lack of appearance.
I'll second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries. Go ahead, Mr. Meyer.
We trailed a few items, and I'd like to recommend that we do item number 127 first. It involved a phone call. And then after that, I'd like to recommend that we go on with items number 14 through 50 and 107, which are the Rasnow cases. These are going to be continued, but we have to get some groundwork done prior to that.
Well, let's start. Thank you. Let's start with number 127, which we did trail, and this was related to the date, Mr. Slavin,
That is
right?
correct. Thank you very much.
Okay.
Appreciate your patience here. December 7th will work.
Okay. Great. So item 127, application 1411137, applicant Ohana 9 LP, and we had discussed, I believe everyone agreed on a continuance. Now confirmed that December 7th would be okay. Any questions from the board? I assume no comments from the assessor? Okay, so looking for a motion.
Move to continue until December 7th with the proviso that any information be exchanged within the next 30 days.
Okay, moved by Ms. Little.
I'll second that motion.
Okay, and seconded by Mr. Crow, and motion carries.
Thank you very much.
Okay, thank you. And so let's just confirm, Mr. Meyer, did you mention the items that Mr. Daza was representing that we had trailed?
No, I'm talking about the ones that Ms. Macri Ortiz had trailed.
Okay,
items
which
14
items?
through 50 and 107.
14 through 50 and 107. Okay, thank you. So let's go back to those items, and for everyone who's here, the purpose of what we're doing is trying to work through the easy administrative things as expeditiously as
And I've
possible.
prepared a brief on this one. There are multiple issues involved. I'd like to give this to the clerk of the board to hand out to the board members to read through really quick.
Okay. Before we continue, I'd like to take a recess, if we could, for 10 minutes. And
10-minute
then
recess?
Pardon?
Okay.
So we'll come back in 10 minutes. Okay, we're back in session. It is 11:50. We have essentially 6 items that need to be resolved today. What I think we'll do is take the first 3 that are administrative in nature and try to get those resolved, and then have the 3 evaluation hearings go after that. So the first 3 we'll deal with are items.
Excuse me. I'm not sure if Ms. Macri Ortiz is aware we're talking about your cases right now.
Okay, no, that's what I thought, but...
I think we'll actually probably hear number 118 first, because just in the interest of moving through it expeditiously, and then go to items 14 through 49, and then item 53. And then after that, the 3 valuation hearings would be applicant Chuck Kane, and then item 217 and item 13, Green Energy Holdings. So, I did not say 93. Okay, so in the interest of moving forward, let's first go to item 118, which is Mr. Reich.
Yep.
Okay, and
so during the break, the clerk discussed this matter with the applicant. They're requesting to amend their application so that their appeal includes their base year value. The base year value appeals will only apply to 2014 forward. We can't go back to the original assessments for reduction. We can apply a reduction if one's warranted to 2014 forward on the base year. So the applicant is requesting to amend his application in section 6 to checkbox C2, which is for new construction. New construction value base years, and his dates of value for new construction are October 1st, 2011, December 1st, 2012, and December 1st, 2013. The subject application was filed within 4 years of all of these assessments being placed on the roll, so the applicant is eligible and has rights to prospectively appeal the base year values on these. And so the clerk is recommending that the board approve the amendment to the application.
Okay, and for clarification, Mr. Vlahakis, today, our decision today is just for an application amendment, not moving forward with the hearing, is that correct? Or is that?
I believe so, unless the parties have changed their minds, but
Okay.
for now we're just discussing the amendment.
Okay, and before we get to that, and sorry for shuffling things up a little bit to our assessor's representatives, would the assessor be prepared to move forward today with a hearing, or just?
Yes, Andrea Rotar with the assessor's office. I am prepared to move forward if we decide to.
Okay.
And if the applicant agrees to.
Okay, and so let's go back to our applicant. We've heard about the desire to amend the applications.
Yeah.
Do you agree with what our clerk,
Yeah.
Mr. Vlahakis, said?
Mm-hmm.
Okay, and then would you also be prepared to move forward with a hearing today with the actual hearing of the valuation? All right, well, since we're all here, let's first talk about the amendment of the application, which involves, Mr. Vlahakis already stated the changes. Are there any questions or comments from the board first? Okay.
I'll just clarify, there's multiple dates because there's multiple phases of construction on the property. So his base year is a combination of all 3 dates. Additional improvement value was added to his base year, and so that's why there's 3 dates. But technically he has the right to prospectively appeal them all on this one application. Normally we don't have multiple dates of reassessment, but for this case all 3 dates can be appealed on the 2014 application.
Okay.
So we'll just go forward with the amendment at this point.
Yes, so let's, if we have a motion to amend the application as requested, that'd be a good place to start.
So moved.
I'll second that motion.
Okay, moved by Ms. Little and seconded by Mr. Crow, and motion carries. Okay, so in terms of the valuation hearing, I'll just ask real quickly, in terms of the assessor's presentation, about how long do you think?
Probably about 20 to 30 minutes.
Okay. And to our applicant, about how long do you think it'd take to present your
Probably the
information?
same.
Okay. So, in the interest of being efficient, unless the board has any other comments, we might come back and hear this valuation hearing after a couple of our administrative issues. So, thanks for your patience. So then what we'll do is go back to items 14 through 49.
Mr. Chair, just to clarify, the same discussion applies to items 14 through 49, 50, and 107.
Okay, thank you. So items 14 through 49, the applicant is Eleanor Rasnow. Item 50, applicant is Tina Rasnow. And Mr. Vlahakis, could you tell me again the third?
Item 107.
107. Applicant is Harmon Rasnow and Eleanor Rasnow Trust. Okay. And sorry again to the assessor's staff for making people go back and forth. So let's start, if we could, with an overview from the assessor of what we're looking at, and then we'll figure out how to move forward.
I'm assuming that everybody has read the little brief that I handed out. In essence, we need some resolution prior to continuing this hearing as to what we can continue to.
Okay.
We need to determine exactly what the board has jurisdiction over.
Mm-hmm.
Then we also need to determine what the appraisal units are, and I'm recommending that we set a new hearing date for that in and of itself. And then once we determine what the appraisal units are, we go ahead and set another date for the actual valuation hearings.
Okay. And let's just go back to our applicant. Well, it's just right at noon, so I'll say good afternoon. Could you state your name for the record, please?
Thank you. I was wondering whether it was good morning or good afternoon.
Right.
I was debating that one. Sharon Stern, my name is Barbara Macri Ortiz, and I'm representing the Rasnows.
Okay. Thanks, Ms. Ortiz. And so I want to make sure we're all on the same subject in terms of amending or clarifying jurisdiction and not proceeding with the actual valuation hearings
Did
for
you
today.
get a...
We do have a one-page
Okay, I don't know if you got a chance
submission.
to read that.
We have a comment, I think, from our clerk first.
Yeah, it was my understanding that on March 9th, 2015, the board already ruled on these jurisdiction on these applications and determined that they can only determine the total market value of the properties as of January 1st, 2013 for a temporary Prop 8 reduction. So it was my understanding that the board already discussed and determined jurisdiction and informed the parties that the next hearing would be only to consider the January 1st, 2013 value for the properties, a total market value.
Well, that's not the understanding that I have. And what my client is asking for is, a determination that's in writing that can be used to exhaust administrative remedies. Because with respect to the issue of jurisdiction, she came requesting that the special assessments for the water be removed because she has no water, and the Callegas and Metropolitan that are assessing say they will not give her water, but they continue the assessments. So that's why that was probably the main reason she filed the appeal. Okay. At the time, she was also speaking with the Open Space District in Thousand Oaks. I think it's called Casca, because her intent, there's a trail that goes through, a public trail that is being used that goes through her land.
Excuse me for a moment, please. I'd like to try to address these issues kind of one at a time, and you're getting more into the valuation issue when you start talking about costs.
Actually not, because, see, I don't think there was any intent on her part to do an evaluation issue at the time that she was coming in terms of value, because she fully expected to donate the land. And there were discussions, and it looked like the land was going to get donated. And then I guess the council or whomever decided, well, we'll accept the donation, but you have to keep the liability. And, of course, that's not really a donation. So that's where they're stuck now, because the district doesn't want to take the liability for the road.
Okay. Let me just interrupt for 1 second. Thank you. Is there, and I'll welcome our council to give us any input along the way, is there an issue that we can tackle first in terms of resolution for today? It sounds like there's a jurisdiction question that the assessor brought up about special assessments. Is that right?
Special assessments. Bottom line, one of the reasons we can't make any headway is because they are constantly talking about the special assessments.
Okay.
And they want something in writing that the board does not have jurisdiction over special assessments.
Okay. And Mr. Vlahakis?
Right. I believe the board, from my records, didn't formally make a motion, but I believe this question did come up on the March 9th, 2015 hearing, and I believe the board made it very clear that they didn't have jurisdiction over this without pulling up the tapes and reviewing it right now.
Is there a minute order that in writing explains
So the board
that?
didn't make a motion to it. I know the board discussed it, but the board didn't include anything in their motion, which would put on the minute order that they didn't have jurisdiction. So I just want to, since the board didn't make a formal motion, but I just want to caution this sitting board that a prior board may have already directed the applicant as to what their position on the jurisdiction was. Without pulling up the video, I can't exactly say because the board didn't make a motion on it, but I know the issue was already discussed.
If the chair wishes to inquire of council, it would be council's view that the board does not have jurisdiction under Property Tax Rule 302 to consider the issue of the water assessments, irrespective of the merit of the issue, that relief would need to be provided through another forum than the Assessment Appeals Board on that issue. And if the chair wishes, I think that we can direct that the board can request that the clerk issue a minute order if the board agrees with council's assessment and its view on the jurisdiction issue.
Okay, thank you. We generally have an application or at least a clear path related to what we are considering, whether...
Did we give you the applications? The board should have the applications.
Okay.
And, let's see.
Do you have the application?
No.
We don't have the application.
Should be a big packet.
We just have these two small attachments.
I have a procedural question, first of all.
Yeah, okay.
Because of a comment that she made.
Thank you. Are these duplicates? Is it one for each? I think I have 4 of the same thing.
Okay, sorry for giving you too much. It was a lot.
Okay. And if this isn't what we need right now, that's
Right. No,
okay.
No, it's appropriate to ask for the applications. I think we just
it's got a big thick
forgot to
staple.
give them to you.
So it's a little, I think we're a little confused about what we are passing.
Okay, I
around.
have a big, it's all stapled as one.
Okay.
These are 4 of the same packet.
Oh, okay. No, that's what happened. Okay, so everyone should have one that says Eleanor Masno on it, on the front, and then another one underneath that says Tina Masno.
I have Tina.
2 sets. This is the second set.
So we just have one of these so far.
I just have one.
Eleanor.
I need another.
Right, and so that's a couple. Okay, so there. Now the board has everything. So they all go.
I'm the only one that has this one.
They're all. There's
They're in.
multiple
Oh, they're all.
applications. So all the applications for that applicant are together.
Should we have more copies of this packet or just one for all of us?
There should be one for board. No, all board members should have that now.
So we own, this is the only one. Yeah.
So
Oh no, there's one. So maybe we're just missing one for Miss Little.
I just have Tina.
There you go.
Oh, okay, awesome. Thank you.
Well, we got that then. Okay.
Mr. Chair?
Miss Little.
As I'm quickly looking at the applications here, I noticed findings of fact have been requested and a comment that the applicant's representative made as far as exhausting her administrative remedies. She may need those findings of fact as opposed to like a minute order. So I think we need to clarify that first, if there are
Okay.
findings of fact.
Okay, so to our clerk and the applicant, findings of fact checked yes. It sounds like we are proceeding with that, is that correct?
I do not believe findings of fact have been paid for.
Okay. And
Are you requesting findings of fact for this
Well-
discussion?
I believe that's what we need. Now, I wasn't aware that, what are we talking about in terms of the, so I don't have my checkbook here.
$150.
Huh?
$150?
Okay, can it be paid,
Before the board...
before you actually produce them? I don't know. I mean, I don't have my checkbook here. So I'm at a loss here. I didn't realize that was an issue. I mean, that...
Mr. Vlahakis,
I just started on this, okay? I mean, I'm the late to the party here and trying to help
the rule says that they have to be paid for before the conclusion of the hearing, so I'm not really sure the technicalities on when the conclusion of this hearing is going to be, because it sounds like the findings are going to be on the jurisdiction issue.
Right.
So the board will probably rule on the jurisdiction issue, but leave open the Prop 8 valuation. So technically...
So we're good for right now, and the findings can, I guess, we can proceed as if we're preparing findings. Is that correct, Ms. Porsche? Since
if we're doing a multi-phase hearing, where today we're considering some of the issues, such as the jurisdiction issue, and we're setting a future date, for example, to consider the definition of the appraisal unit, and then once that's set, we're setting a future date for the consideration of all the valuation questions, the board actually deciding value. It would be council's determination that the fee for the findings would be due before the conclusion of the multi-phase hearing. So the applicant's attorney can provide them, as soon as possible to the clerk, but
so we're okay for
she
now.
won't be prejudiced by not having them.
Thank you.
Today.
Okay.
Answers my question.
Okay, thanks, Ms. Little. So let's go back to, and what we want to have is a clear path on what it is that the board's being asked to rule on. And it sounds like there's an agreement that issue number 1 is jurisdiction related to special assessments. Is that, sounds like everyone agrees on that, including the assessor? Okay.
Christopher Horn for the assessor's office, yes.
Okay. And our counsel has told us that according to Rule 302 that we don't have jurisdiction to decide on that. Is there any discussion from the board?
Nope.
Okay. So if we don't have jurisdiction, then I don't guess that we would need to take action confirming that other than stating that fact. Is that correct?
The board can make a motion stating its view of the jurisdiction issue.
Okay.
Right. The clerk was, that's, I think, part of the issue we have is the prior board that heard this case determined they didn't have jurisdiction but didn't take a motion on it. So the clerk can only put in the motion in the minute order what the board motions. So in order for us to put in writing, the board needs to take a formal action determining, I'd say that the board makes a motion to determine they do not have jurisdiction to hear special assessments. That way it's clear and we can put it in the minute order.
Okay, so unless there are any other questions or comments from the board, looking for a motion to that effect.
I'm waiting for the screen.
Oh.
Based upon this board's opinion and council's advice, this board does not have jurisdiction to address the special assessment.
Okay.
I'll second that motion.
Okay, so moved by Ms. Little, seconded by Mr. Crow, and motion carries. So that has been resolved. So let's then, if we could, and we'll start with the assessor and go the applicant, understand the next issue, and we'll work through that.
The next issue would be the valuation unit. The applicant filed on approximately 38 parcels. However, they actually own closer to a little over 100 parcels in that area. So there's been some disagreement as to what the actual appraisal unit is. Is it the entire ranch, or is it the legal lots, or is it each individual parcel? So we need to prepare a case for the board to actually get that determined. Once we have that determined, we can go ahead and present a valuation issue.
Okay, so that's something that cannot be addressed today, is that correct?
That's correct.
And so from the perspective of the assessor, you're looking for
a continuation to have a hearing to determine what the appraisal unit or units are.
Okay. And is there a date that you would request?
December 7th.
Okay. So let's go back to our applicant and see if that's something that, in terms of the principle of what we're talking about, and is agreeable.
Okay, well, I am confused.
Okay.
Because when we met, we had said there were a number of parcels that were low value. They should put them in the low value. One of them actually was like $988. So, I mean, they were low in terms of the assessed value. I was told, well, we can't do that because they're in appraisal units. Okay? So I was trying to get my head around that one. And now we're going to have a hearing to figure out what the appraisal units are. At the meeting, I asked, well, if you can give me the appraisal units. So I think the problem stems from something that happened, I think it was 1984, 1985. The board, I guess Board of Supervisors, did an involuntary merger. And this is properties that, you know, they've been on the books a long time, but they did an involuntary merger. But they did never, it doesn't match what's on the assessor side and what's in the tract map, I guess. And then I said, okay, well, tell me what is what. And that's what I think we're trying to get. I was expected to try to get my head around that. You know, I know Mr. Horn had said, you know, when we started looking at the description for the merger, then it had one description, and he said, oh, that's 108 parcels. Or, right?
Excuse me.
Assessed
Specifically,
parcels.
this would be addressed in item number 5.
So, well, I just, to say we're going to have a hearing on December 7th about appraisal units, when I was under the impression that the reason they couldn't low value any of the parcels because of appraised units, to me that seems like we're kind of in a catch-22 here. It's like we're here but we're not here.
Okay.
And I'm not even sure what that would be to litigate. I have asked for information with respect to what it is. And I fully anticipate that once I get that information, we look at it, we figure it out, and hopefully we don't even have to come back on that.
Let me just step in 1 second. So 2 quick things. Number 1, we're going to work through this issue and then probably take a lunch break. So for those who are here in the room, we would come back somewhere between, my guess is if we take a break by 12:30, we'd be back here between 1:15 and 1:30. So, and just so you know, you're welcome to stay or come back either way. Number 2, I want to make sure that we understand what it is that we can rule on today. And I'll ask guidance from our council too, any comments from the board. I'm not sure that it's clear what it is that we would be deciding. It sounds like there needs to be more definition before we're able to hear something.
As I understand it, the assessor has indicated that there's difficulty defining the parameters of the appropriate appraisal unit, and that there needs to be a hearing on information so that the boundaries of what is it within the appraisal unit is defined, and then we can proceed from valuation.
I'll
Is that
give you a little
accurate?
bit of an example. She was talking about this involuntary merger. What happened was there was a zoning change. Originally, these were all parceled out to be cabins back in the 1920s, so they were very small lots. The county forced a merger on these properties, so you cannot build on these little tiny lots anymore. Instead, they have multiple parcels on what they define as legal lots. Now, what we want to find out, or what we need to go to the board for, is are we going to appraise these legal lots as an appraisal unit, or the entire ranch that contains these legal lots as the appraisal unit? Where this comes in is the fact that she has not appealed roughly 100 of these parcels, or I guess 80 of these parcels. But if we have to determine that they are part of the appraisal unit, then they would be subject to the reassessments.
So, Mr. Meyer, sorry to interrupt. What, from the assessor's perspective, what's the next decision that you're asking the
We're asking that we
board
have
to
a
make?
continuation for a hearing to determine what the economic units are.
Okay. And
If I could ask a question, is that driven by what the realistic economic purpose of the property is if you can't divide and build little home lots on it?
That would be a good way to put it, yes.
So the question is, given that you have a property with 38 parcels appealed on and the other larger portion not appealed on, some of which don't have water service, you're trying to find what's the economic utility of the parcels?
Correct. And the other issue is on some of these legal lots that include multiple parcels, the Rasnow family does not own all the parcels within the different legal lots.
And Mr. Meyer, if the board were to continue as the assessors is recommending, you think that we still past that have other decisions to make today before that point, or is that?
In order for us to continue communications, yes.
Okay. So, are there any other questions from the board as of right now before we push forward?
Are these lots that are, can they be developed, and do they have water and all that good stuff like that?
The ranch itself has somewhere between 2 and 4 wells on the property. They are not serviced by the water district, but they do have wells on the properties.
Okay. So, let's go back to our applicant, unless, Ms. Little, you have a
Yes,
question?
if I have one more clarification. So basically what we have is taxable lot, but within that we have some old lots that have zoning restrictions on them that you cannot subdivide down to these little lots.
The whole ranch.
Okay, so I know we've dealt with this before on properties that were currently zoned for commercial, but they wanted to do residential, so it's similar to that. So there's a zoning restriction on this parcel.
That's correct.
It's open space 20 acres.
Okay.
And we've got bills for parcels that are .06 of an acre.
Okay, but not a quote-unquote legal lot.
Correct.
That's right.
Okay, that's just, I wanted to clarify.
Okay. So, thank you. Let's go back to our applicant. If we continue this so that the parties can hopefully make some progress, so that we can have a clearer path to make a decision, is that something that is agreeable to the applicant?
Well, if we can get a reasonable date, and at this point, I mean, in terms of this is not your typical case, and I've really am booked up through October, so if we could get it into, maybe January or February of next year, that would be much better, because all the work on this has to happen before.
Okay.
And I'm really tied up for the next few months.
Okay. Mr. Meyer?
We can go with either January 6th or February 8th.
Why don't we do
or February 29th.
February 29th, how's that?
You want this
Only
late as
happens
possible?
once every 4 years.
Sure. I mean,
cannot schedule this for February 29th.
Okay.
You don't want leap day?
oh, is it leap year next year?
The what's it called? The February 29th is going to be the date for the new Assessment Appeals Board number 2. So this needs to stay with Assessment Appeals Board 1.
Okay.
So January 11th or February 8th. But
Are you sure it was January 11th?
We don't have any official schedule. We just have blanket dates. But I could do January 11th or February 8th. But a 2-year waiver is required for items 14 through 49. They waived the 2 years on items 50 and 107, but not 14 through 49. So I would need a waiver.
Yeah, I could get that.
Okay. Is there a date of those two?
Can we do the February, did you say February 8th?
Okay.
Yeah.
And so let's move through that. February 8th, Mr. Meyer?
Pick a date out of the hat, we'll be there.
Okay. Any questions from the board on?
Do you have an appraisal on the property?
I'm not sure if there's I don't think there's a current one that I know of.
You probably will need one, if you're objecting to some of the values and such. Yeah.
Well, see, this is the whole thing. It's like the value was not really the issue because they were trying to donate a good chunk. and that when, that didn't work, and perhaps we can turn that around. But with that, now it's like, okay, now we got to deal with this. We've got to deal with the value if we can't get it, 'cause
Okay, so
Clerk would just like to ask the board if they could clarify. It sounds like that February 8, 2015 will only be to determine the appraisal unit, and then subsequently there'll be another continuance and there'll be a valuation hearing at a later date. I just want to make sure all parties are on the same page as to whether or not there's valuation on February 8th. It sounds
Okay.
like there's not. But
assessor says yes, and applicant.
appraisal unit.
Right, correct.
Once we figure out what the unit is, then we go get an appraisal.
Right, so all parties are expecting another continuance after February 8th. I just want to make sure that's clear.
Okay, so looking for a motion to that effect.
Move to continue to February 8th for appraisal unit evaluation.
I will second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow, and motion carries. Okay.
There is one thing that one of the items in there, appeal number 13-10952. They no longer own this parcel, so we could probably take that one off.
Did they own the parcel January 1st of 2013? Because this only applies to who owned it in 2013.
Okay, yeah, I'm sure they did at that point.
Okay, so it looks like from the...
Okay.
Ms. Porsche?
The clerk had indicated that we will need a 2-year waiver, and I assume the clerk has the paperwork so that Ms. Marcus Ortiz can fill it out today.
If that's something that I can sign, we can do it right now.
Yes, the
Otherwise, I'll
representative
get it
can sign
tomorrow.
it. I had sent it to the applicant. When this was continued prior, it was continued due to a medical emergency, and I required waivers on everything, but they didn't send one back for this case. I'm not sure why, or this 14 through 49. But the
I've got 2,
attorneys can assign it at this time, and it won't be a
I'll take care
problem.
of that.
Okay. So according to the assessor, I believe there's further action that you think the board needs to take? Could you explain what you think the next step is, and then we'll hear from the applicant?
One of the issues that the applicant brought up was the low value ordinance. Of her roughly 110 parcels, she does not receive bills on about 80 of those parcels. The reason is because of the low value ordinance. Low value ordinance is designed so that if a tax bill is going out to a property owner and the income that's generated or the revenue generated from that bill is less than what it administratively costs to actually issue the bill, we won't send those out. And that includes special assessments, etc. Roughly 80 of those parcels are involved with this. She did not appeal those because she's not getting bills on them. If that appraisal unit were to be determined to include those parcels, the board would make that distinction. And the low value ordinance does not cover parcels that are part of a greater appraisal unit. So they would all come off of the low value exemption. Also, Ms. Rasnow requested that we just lower these low value parcels that are between $5,000 and $10,000 down below $5,000 to put her on the low value ordinance. And we tried to explain to her that the low value ordinance does not apply to temporary reductions. It only applies to those that have factored base year values below 5,000. So she would not get any benefit from that either. And we were accused of having our cake and eating it too. But the fact remains that that's the way the ordinance is written, and that's what we have to comply with.
So are you asking...
What I really want the board to realize or to express to the agent is that you do not have any jurisdiction over exemptions.
Okay, so the assessor is asking the board to make a statement that it does not have jurisdiction over exemptions. Is that correct?
Is that, you mean low value exemptions?
I don't know that.
That would also apply to this board here. We don't have jurisdiction.
Okay, so I'll ask if there are any questions or comments from the board, and also ask for our counsel to make a comment. I'm not sure if it's
Would
a
it be
requirement that we
sufficient
make a
for the
statement.
purposes of the applicant if I read the pertinent portion of Property Tax Rule 302, which talks about the very limited jurisdiction that the board has with respect to exemptions when it involves a classification issue? But doesn't otherwise
Okay.
have jurisdiction.
So just a question for this is not what I do for a living, you know. Who would have, if there was a challenge to that, who would hear that? Is that Board of Supervisors? Or it's an ordinance, right, of the county, so would it be the Board of Supervisors?
Unfortunately, I can't advise the applicant on what the appropriate form from that issue is. I haven't studied that. I don't know the answer for the applicant.
Okay.
So I can just tell the applicant that I can advise the applicant to look very carefully at property tax rule section 302.
So, Ms. Porsche, what do you advise, if
All right.
anything, that the board does about the assessor's request to express the...
I would advise the board that when we prepare the findings of fact, that I make a reference to the pertinent portion of Rule 302. And today I would advise the board that the functions of the board are laid out in 302. 302A4 talks about to determine the classification of property that is the subject of the hearing, including classifications in the general classifications of real property improvements, real property improvements, and personal property. Such classifications may result in property being so classified being exempt from property taxation. Then when you look at Rule 302B, it says, except as provided in subdivision A4, the portion I just read, the board has no jurisdiction to grant or deny exemptions or consider allegations that claims for exemption from property taxes have been improperly denied. So this board can't address that issue for the applicant. We would make it clear in the findings that relief would need to be sought in another form, but I can't give the applicant the legal advice of the path to proceed.
I understand.
Okay, thank you. So I believe we've covered that issue. Are there any other issues that the assessor believes the board needs to rule on or act on today?
The next issue would be parcel maps. Again, they want us to draw the parcel maps according to the current legal descriptions. We cannot do that completely because the legal lots do contain some parcels that are not owned by the Rasnow family, and therefore not necessarily included or not all encompassing within those legal lots for the Rasnow family. I don't believe that this board has jurisdiction over how the parcel maps are drawn, and I don't believe that this is the proper forum for it.
Okay. Back to our applicant, is there a request that the board is does something, acts related to parcel maps?
Well, my understanding from the meeting we had, it wasn't an issue for the board. I thought it was an issue with mapping.
Right.
Right? And that was the discussion we were having. I don't think I was expecting a ruling on the maps.
We're just going through administrative stuff.
We can incorporate it into the findings of fact, all the pertinent issues regarding jurisdiction, and that the board's jurisdiction doesn't extend to parcel map issues. We can include that in our findings.
Okay. So any other outstanding issues? And we'll start with the assessor and then ask if the applicant has any.
The other issue was the fact that the applicant was willing to withdraw a number of these appeals. I'm recommending that that is somewhat premature until we actually have the hearing regarding what the actual appraisal units are, because it might include some of those that she's offering to withdraw.
Okay. And Ms. Ortiz, do you have does the applicant have a comment related to that?
I guess we'll have to
Are there applications?
figure it out in the wash.
Are there applications that the applicant wishes to withdraw at this time?
Well, actually, in terms of with respect to, if we get the jurisdictional thing done, then I think my client would be prepared to withdraw the ones that she listed that have improvements.
Okay, so then that's something that would happen as you determine other factors?
Well, we've got the jurisdictional. Maybe that's one we look at in the next hearing, so I can consult with her too and see where we're at in the other.
Okay. Are there any other issues that the applicant would like the board to consider today?
No, thank you.
Okay, and anything from the assessor?
I'm looking over my brief really quick.
Okay.
I think I covered everything.
Okay.
I think you did.
Okay. Any other comments, questions from the board?
No.
Okay, so it sounds like we've resolved what we can for today, and hopefully it can all get resolved easily and expeditiously.
Yeah,
Okay, thank you.
that would be nice. Thank you. Thank you for your time.
Mr. Stern, before we break for lunch, could you run through really quick what items we're going to cover the rest of the day and in which order?
Sure. My understanding is that we'll next finish the administrative non-valuation issues related to numbers 118, which is...
118 is now valuation.
Oh, you're right, 118, okay. So then...
It's just 53 on the...
53 then would be the next, which is represented by Mr. Daza, and that's International Paper Company. And then after that, we still have 118, 84, and 85.
I'm sorry, what was that?
First was item 118, which is that's Mr. Reich. Items 84 and 85, Mr. Kane. Back, let's see, item 13, Green Energy Holdings LLC.
Telling us the order that you're going to hear.
Number 93, Mr. Avakian. And number 217, and I apologize again for the spelling of the name, but X-U-A-N, and then I believe the first name is S-C-H-U-N-R-U-O. Okay, so we're all on the same page, and so we'll be in recess, and thank you everyone for your patience until...
Just to clarify.
Yes,
So
go
we got
ahead.
53, 118, 84 to 85, 19, 93, and 217 in that order.
19 or 13?
Did you say 19?
13.
13.
13. I'm glad I asked.
That's the plan.
Thank you.
Okay, so is 1:30 agreeable time to everyone? I mean, I'm happy to just to go faster, but okay, so we'll be in recess until 1:30. Thanks everyone for your patience. They're going to make a dramatic entrance? Okay. We're back in session. It's 1:30, and we are hearing item 53 on the agenda, application 13-11085. Applicant is International Paper Company, and we have a request for reconsideration of denial due to lack of appearance, I believe. And Mr. Vlahakis, you said that the assessor staff does not need to be here for this?
Right, the clerk of the board will be presenting the facts of the matter, and then I'm not sure, I don't believe the assessor has a position on the matter.
Okay, why don't we start with an overview, if we could, from the clerk, and then we'll make sure we get the information also from the applicant, and we'll go from there.
All right, so I've provided in your application packet the application, the authorization, notices of hearing, and correspondence with the agent. And so some of this will be referenced in what we're presenting today. And so let me do a overview. So this is for item number 53, application 13-11085 for International Paper Company. This is request for reconsideration of the Assessment Appeals Board's decision on May 4th, 2015, denying appeal 13-11085 for lack of appearance. A hearing notice was mailed on September 11th, 2014, for a hearing on November 3rd, 2014, to both the agent and the applicant. On October 2nd, 2014, agent Peter Kochedoff of Versatex Consulting Incorporated exercised their right to postpone the hearing, and the hearing was postponed to February 9th, 2015. On January 22nd, 2015, the agent and the assessor's representative submitted a stipulation for continuance, requesting the hearing be rescheduled to August 3rd, 2015. The August 3rd, 2015 date was not approved by the clerk of the board in advance of the stipulation for continuance being executed by both parties. On January 28th, the clerk of the board's office rejected the stipulation for continuance due to the stipulation not meeting the Assessment Appeals Board's rules on continuances adopted July 16, 2012. This rule requires the hearing date for a stipulation for continuance to be a date approved by the clerk. The clerk of the board determines acceptable continuance dates for each hearing and usually makes two options available. The clerk of the board's policy is that all postponements and continuances are not to be made more than 90 days later than the originally scheduled hearing date, unless arrangements are made in advance with the clerk's office, in which the assessor's office or the applicant makes a special request for a hearing more than 90 days out and provides specific reasoning. This requires the clerk of the board's management's approval prior to the date being offered to the applicant, agent, or assessor. After reviewing this case and consulting with my supervisor, we emailed the assessor and the agent and informed them that we were rejecting the request to reschedule to August 3rd. I've distributed an email for the board to review. So in this, there should be about halfway back. Sorry, I didn't have time to mark these. Okay, so in front of one of the legal size sheets of paper, there's a letter dated January 28, 2015, with my name at the top. The three reasons why the request was denied were clearly stated on the notification as follows. The date of August 3rd, 2015 was not approved by the clerk of the board as an acceptable date of new hearing. The printed date of August 3rd was crossed out by an unknown party and indicates a date which the Assessment Appeals Board does not convene of August 6, 2015. This makes it unclear as to what the actual agreed upon date is. And the last statement, a 2-year waiver is required for cases that are continued to less than 120 days from the expiration of the 2-year period. There's currently no waiver on file. And so that's the end of the statement in the email. Additionally, options were provided to both parties. The parties were both notified a new request was required and that April 6th or May 4th, 2015 were hearing dates approved by the clerk as dates the parties could execute a stipulation for continuance to. Both parties were also notified that they would be required to appear on February 9th, 2015, which was the originally scheduled hearing date, unless the clerk of the board received a new stipulation for continuance request. A stipulation for continuance rescheduling the hearing to May 4th, 2015 was submitted on February 2nd, 2015. This request complied with the clerk's scheduling requirements and is therefore approved and processed, setting the new hearing date to May 4th, 2015. The executed stipulation for continuance clearly states no further notice of such continued hearing will be given to either party, and all future requests for continuance will be made in person to the Assessment Appeals Board or hearing officer. The agent agreed to these terms by signing the stipulation for continuance. The agent did not appear at the May 4th hearing, and therefore the application was denied due to lack of appearance. On June 17, 2015, a request for reconsideration was submitted to the clerk of the board by Renee Daza of Versatex Consulting Incorporated as agent. Today, the board must determine whether the applicant has good cause for reconsideration. Property Tax Rules 326 and 313A and the Assessment Appeals Board's policy titled Reconsideration of Denial for Lack of Appearance, which states, good cause shall be defined as one of the following. 1, the applicant or agent failed to appear because of circumstances that were beyond the control of the applicant or applicant's agent, and the applicant or agent could not appoint someone to make the appearance on their behalf, or option 2, the applicant or agent had no knowledge prior to the hearing that he or she would be unable to appear as scheduled. It is the agent's burden to prove their good cause for reconsideration. The board believes the agent has not met the requirement for good cause for reconsideration. The board can deny the request for reconsideration. The board believes the agent has met the requirement of good cause for reconsideration. The board can motion to vacate the May 4th, 2015 Assessment Appeals Hearing Board's decision to deny due to lack of appearance and to determine a continuance date for the future evaluation hearing. So just to review, the key documents we're discussing is the stipulation for continuance with the clerk of the board stamp of January 22nd, 2015, the email January 28th, 2015, and the stipulation for continuance stamped February 22nd, 2015, which scheduled the hearing to May 4th. So that concludes the clerk's statements.
Okay. Board have any questions so far from the clerk?
No.
Okay. Let's hear from the applicant.
Okay. Before I start, I have a question of the board and county council. And when I'm speaking in front of this board, am I speaking to a local board, or am I speaking in lieu of the Board of Supervisors?
This is a assessment appeals board created by ordinance by the County Board of Supervisors.
Okay, and does the Board of Supervisors then grant you, under that ordinance, all authority to handle every aspect, assessments and adopting rules, or does that fall under the Board of Supervisors?
Pursuant to ordinance, this board follows the property tax rules and state laws, constitution.
I think, if I can clarify, I believe he's asking about the board's adopted rules, which are adopted by the Board of Supervisors for the appeals board to follow.
The rules at issue regarding continuance were adopted on November 25th, 1991, signed by John K. Flynn, Chairman of the Assessment Appeals Board. And the title of those is Procedure Authorizing Reconsideration for Denial of Lack of Appearance.
Chairman of the Assessment Appeals Board.
Signed John K. Flynn, Chairman, under the heading Assessment Appeals Board.
So not the Board of Supervisors?
That is correct. I'm reading what's on the procedure authorizing reconsideration. John K. Flynn, I believe at the time, was also a member of the Board of Supervisors.
But they didn't act as one at the time he signed?
He was signing as a chairman of the Assessment Appeals Board.
Okay. I think that's important. If I could start off a little dialogue here. The Assessment Appeals Board manual itself even indicates that there's a lot of confusion with all of the local rules put in place upon the taxpayers, particularly taxpayers or agents who represent properties in multiple counties, because every county has come up with its own rules, and some of them call them local rules, some of them call them procedures or policies. And we have found in certain circumstances where not everything was approved per the R&T code to the T. So it's a little difficult for consultants such as ourselves that represent taxpayers in every single county to follow every small detail of a local rule or a procedure or a policy. And I'll give you an example of this. If I may ask the clerk's office, is your policy available online for the public to view? Assessment Appeals Board.
Oh, you're asking it?
Yes, if the local rules are available online to view.
No, we do not have it available, but we do have it available if a records request is made.
Right. So if I go to your website, at the bottom of your page, preparing for your hearing, for complete information, review the Revenue and Taxation Code State Board of Equalization rules at www.boe.ca.gov. It doesn't really lead you to another local rule. And this is all going to just kind of tell you the story as to why we're here today. So we file appeals in virtually every county in California. So we get hundreds of correspondence back and forth all day long. And for the most part, in this particular situation, when we postpone or agree to postpone a hearing, we get a confirmation letter back from the clerk of the board stating such. Now, this is particularly the case when you're not at a hearing and you're agreeing, like we do in Los Angeles County. We agree, just like I did here, but in Los Angeles County, it's a little different. Say I agreed to a hearing in 30 days from now. We agreed to the time and place and the amount of time that we're going to dedicate to the hearing. So at other cases, we have notification from the county indicating such time and place. So there's a little bit of a little anomaly here, I guess. If the clerk can also clarify for us that this stipulation of time, we were talking with the assessor's office about this case. And we did share information on the case prior to the May 4th date. So there was dialogue. The dialogue then stopped from the time that we're discussing this stipulation that was that's in front of us today to the day of the hearing. There was no dialogue any further. We were, A, one, waiting for a new hearing notice, and B, there's complex issues behind the case where the assessor's office asked for 441, and it's a slew of items as well behind it. And it's not simple documents to find or even get the client to approve, because we're talking about, in their client's eyes, confidential information, tax records, and so forth. So that takes some time to get approval to share in front of this board. So in doing that, we did everything with the assessor's office as normal. We then got, I believe it's in the clerk's package as well. Let me see if it's in here. I don't think these are page numbered, but there's a page that looks like this in front of you all. Is the consent to continuance of hearing, and it's signed by the assessor's office. It's signed by myself, and then we got this back from the county indicating that no 2-year waiver and bad hearing date. Now, the date of August, I believe that's August 3rd, that was originally there on my page and the assessor's page. August 3rd is there. I mean, no one knows, I'm sorry, why that was, August 3rd was crossed out. No one can answer that as of today. There's neither one of our copies. August 6th is placed on there, and I think the clerks have already admitted to that. We received a denial notification from the clerk. And then I get the email from the assessor's office saying, look, it's been denied by the clerk's office, so we need to resubmit. Sign the form. He said, sorry, sign the form and send it back. I did send it back to the assessor's office because I got it from the assessor's office, not from the clerk's office at that time. And then we never heard back. So it only has my signature, and that is in my exhibit. If I could pass that out. Because I don't think you have that in here, right? I don't see that. Oh, yes, you do. Sorry, it's the second to the last page. Oh, I'm sorry, third to the last page. Third to the last page. You can see my signature's on there, and that was it. We never received confirmation of a hearing. Now, I believe the clerk's position is that once you sign that, then it's a valid hearing date and you're supposed to show up. Well, most agreements are signed by two parties and shared by two parties, and it's not a one-sided signature. Then that's almost like we're calling the shots and not the clerk's office. Again, we don't see this in any other county. I particularly went back and tried to go through my memory box and any files to see, do we sign this, and just never hear back. And we have emails from virtually every clerk that we deal with saying that this is the hearing date, this is your confirmation, we accepted your postponement. In this particular case, there was no such communication.
Mr. Daza, can I ask you a question?
Yes.
In terms of the specifics with your situation, what was your understanding of when you had a hearing scheduled?
Well, it was either as we received the denied correspondence on the same type of form from the clerk's office, we thought we were going to get a new form, and that's how we track our hearings at our office, is receiving correspondence and confirmations. We have to plan travel and personnel and copying, and what are we going to do?
Are you saying you didn't know about the May 4th hearing?
I know about this form and the date of the May 4th being available. So we're not disputing that I didn't sign that. I did sign that. But it's a one-sided, again, correspondence. I've never seen that before. And I've been doing this 20-plus years. But if I could also, I believe the clerk's office, we had a discussion, and I believe the clerk also concurred that the form typically comes and goes back through the clerk's office, not through the assessor's office. Because here's another issue, I guess, that we're finding out. We're learning now your local policies here, because this part is policy, not rule. That the form was sent from the assessor's office, and I returned it back to the assessor's office, not to the clerk's office.
I'm sorry to interrupt you. Are you asking for a new hearing date?
Well, we're asking for a reinstatement so we can have the opportunity to have our client come,
Okay.
and us on his behalf, for due process. That's all we're asking for.
And was there a misunderstanding in terms of when is your understanding that there was no confirmed continued hearing date?
That's correct.
There was the August date?
That's correct. But we had other hearings on August 3rd here. And we have the paperwork to show that we have all those hearing dates, and we postponed them and so forth, whatever we did with them.
Okay. I'm just going to try to, I'll make sure that we get all the information. I just want to expedite the process a little bit. Mr. Vlahakis from the clerk's office, it sounds like that both the assessor and the applicant wanted to continue to August 3rd, but the clerk denied it. Is that correct?
Correct. So that's what the
Why
January
was it-
28th email is. As we said, we aren't rescheduling this for August 3rd. You can have April 6th or May 4th.
Why was it denied?
Because for the three reasons. It was more than 90 days from the currently scheduled hearing date. So we always, the board gets to continue however length the board wants, but with the clerks doing it, we restrict everything to a maximum 90 days. Unless there's a special request and they state their reasons, like say there's pending litigation or there's, a certain thing being prepared that takes a certain amount of time. And then that goes up to my managers, and then they'll approve a date beyond 90 days. But at the beginning of the year, once the board approves their calendar, we go pick 2 dates for every hearing that are acceptable for continuances, for postponements and stipulations for continuances, and those are the dates. So we had decided long before this that the acceptable dates for continuing from February were April or May. And so that's where we came up with it. So that was one reason. It was denied because the date was more than 90 days. It was also denied because there was no 2-year waiver on file. So part of the thing is if any, I'm not sure exactly what the property tax rule is, but it says if it's less than 120 days from the expiration of the 2-year period, no continuance is allowed unless there's a waiver on file. So there's no waiver. And I believe there was one. Oh, and just then that the cross-debt date, because it wasn't crystal clear as to what the date was, we were also rejecting it for that reason, because August 6th the board isn't meeting in 3 days from today. So.
Okay. Mr. Daza, we'll get right back to you, and then first I'll ask if the board has any questions. But I'd like to ask the assessor a question. I know, Mr. Vlahakis, you said the assessor wouldn't be involved, but I do have a question for the assessor. Is that acceptable?
I do whatever you tell me, sir.
Well, I just have a question. Is the assessor disagreeable with reinstating and establishing a new date?
Provided he provides the data, because we still have not received the data from you, sir.
Okay.
Actually, some data.
Okay.
Yeah, I just want to make that clear. Just some data, because that was actually an issue at the other hearing, prior hearing. I have the clip on my computer, the video, where I think Mr. Crow asked the question. He was a little confused with what was in front of him. Was it a stipulation of value? The clerk then clarified it wasn't. I believe Ms. Little then asked the question, was just about to ask the question of the assessor's office about communication, and then Mr. Stearns jumped in and asked the question of the assessor's office, was there communication between the two parties? And I have the clip. I could show it to all the board members. It's about a minute long. But the assessor's office didn't have the appraiser, I believe, present that we were talking to. So, of course, the assessor's office representative said no communication. But I have the email to the assessor's office with
Let me
the data.
just
I'm just wondering if
interrupt for a second. Does the board have any questions so far from either the clerk or any discussion?
Yeah, not quite yet. I
I
haven't grasped it.
If our board has jurisdiction, and if we have both the assessor and an applicant who is willing to continue to a new date, I would be of the mindset of allow them to do it. I believe it is within our
It was within the
authority
board's
to do that.
purview.
but we could continue to hear more information.
Sure.
Is there more information that we haven't heard yet that either the clerk or the applicant would like to present? I guess I did interrupt you, so there's more.
Please. There was just one more little, again, this is the nuances of dealing with this kind of a detailed level of policies and procedures. But when we do get notification from the other counties, virtually at any time we ever stipulate to a new hearing date, we are given the time and place because of all of the administrative issues that the other counties deal with. And I'm not sure anymore about this county. I haven't been here about a year now. But, for example, Los Angeles County, I think, is every third Monday of the month. The hearings start at 10 a.m.
I'm sorry, Mr. Dawson, let's just stick to what we're doing here. With
well, no, I understand that, but I want to pass out the section that I just wanted to add, again, what we're dealing with here, if I could, to the clerk's office.
No, not at all. There was miscommunications.
Thank you. I mean, this could be useful maybe for other hearings or another adoption of correction of policy or rules. But it does say that under 1605.6, the clerk, the County Board of Equalization, shall notify the applicant or the applicant's designated representative of the new time, date, and place of the hearing, not less than 10 days to the new hearing date. So maybe the Form 2 should also have the time and the place and the date kind of situation. I'm just adding that to our contention.
Okay. Is there anything else you'd like to present?
No, that's it.
Okay. Mr. Vlahakis, is there anything else from the clerk?
Just that we made it clear that if it didn't get rescheduled, that they would have to appear on February 9th, and since it's February 9th, right? Yeah, and since no one appeared on February 9th, we think it should have been assumed that the case was rescheduled to the date they wanted. Otherwise, it would have been denied several months before it was actually denied on May 4th. So we think we made it pretty clear that they should have been present at the hearing, and we would request that the board deny the reconsideration.
I'm not sure how the 4th plays into the February date plays into this. But.
Okay. So let's have a discussion and maybe make a decision. Any comments from the board?
I think the applicant has further discussion.
I wanted to add again, the reason why I asked about the board and the adoption of the rules is because I thought if the R&T code said the time and the place and the date, I thought that's supposed to be on every form, regardless of the policy.
Okay, thank you. It's not very, so in discussion with the board, it's not very often that we have both the applicant and the assessor willing to continue, and then it gets denied. In my opinion, and I applaud the clerk's office for following the rules, although I'm not totally clear on what happened, so I guess there's a possibility that there could have been some ambiguity, but I would be okay with reinstating the application and allowing it to be at least scheduled.
The bottom line is I think there was some miscommunication, and I'd like to correct that. So,
okay.
Do we if we do go forward, I guess we would vacate the motion to deny. Or
we would the procedure I think would be to first vacate the decision to deny due to lack of appearance and then to continue to a new date. I don't know if those could both be handled in the same motion. Mr. Vlahakis, do you know?
Because we preferred separate motions since the case is currently closed. We would like it reopened before we can continue, so 2 motions would be preferred.
Okay. Is there, since the assessor's here, well, all of the parties, is there a date that, first with the clerk and the assessor, that...
Let me think, December 7th, does that sound okay?
So December 7th.
Are we going to have any time on that day?
Mr. Vlahakis, does the clerk have any
No, I just check we have a waiver on file, a 2-year waiver on file, which was a condition of their continuance. So there's no time restrictions. We would prefer, since it's a 2013 case, we'd like it resolved sooner rather than later. So December 7th.
Okay. And is that date acceptable to the applicant?
Yes, it is.
Okay. Any other discussion? Okay. Is there a motion in any direction?
I'll move to vacate the prior motion to deny for lack of appearance.
I will second that motion.
Okay. Moved by Ms. Little and seconded by Mr. Crow, and motion carries. And then we would need a second motion to continue to December 7th. And is there information, we'll ask the assessor, is there information that needs to be?
My files still show that we have not received the personal property information. So we would like that within 30 days.
Okay. Is that, Mr. Dawes?
We do owe them information. That's correct. We can do it. Yes.
Okay. So looking for another motion.
Move to continue to December 7th with the proviso that additional information regarding personal property be supplied to the assessor's office within 30 days.
I'll second that motion.
Okay, moved by Ms. Little, seconded by Mr. Crow. And motion carries.
Thank you very much, Board
Okay,
members.
thank you. And thank you to the clerk's office for the information as well. Okay, let's move to item 118. That is Mr. Reich. Application 1411074.
I did mine. Yeah.
International paper. Oh, is this our pile of? We don't need them.
That gets many of them around.
Okay. Welcome back. Let's start. Let's see. Let's make sure we all have the applications first.
You've got your collection.
Did we get this one?
Yes, we've got
They
this
were
one.
amended earlier, so.
Okay.
I have one.
You have an extra one?
You do have one?
Yeah.
I seem to have lost mine. Well, maybe I will share. I'll share. That's okay.
It's okay. We're fine.
That's okay. We're good. I'm sure it's here.
Yeah.
Okay. So if we could start, we're looking at a single-family owner-occupied residence. If we could start with a brief overview from the assessor,
Okay,
and then we'll take it from there.
Kent Meyer, Ventura County Assessor's Office. This is an appeal that's just been amended to include the base value of several items of new construction, which includes garage conversions, a man-made lake, a stream, and a new SFR. Get back on track. First thing that needs to be determined is who has the burden of proof on this case. It is the opinion of the assessor's office that the burden will fall on the applicant. I believe that you do occupy the property, and it's technically a single-family residence. And Revenue and Taxation Code Section 167 states that the burden of proof is in the favor of the assessee on an owner-occupied single-family dwelling. This is provided the assessee has supplied all information as required by law to the assessor. The assessor has mailed several new construction letters that have not received any response from the applicant. Also, we've tried to make 2 field checks out to the property, and the applicant refused to allow us on the property. So it's our opinion that the burden of proof falls on the applicant.
Okay, thank you. So before we move forward, unless there are any comments from the board, we'll ask our counsel if you could verify that, although it does seem to make sense.
In Revenue and Taxation Code Section 167, it says in Subdivision A, notwithstanding any other provision of law to the contrary, and except as provided in Subdivision B, there shall be a rebuttable presumption affecting the burden of proof in favor of the taxpayer or SSE who supplied all information as required by law to the assessor in any administrative hearing involving the imposition of a tax on an owner-occupied single-family dwelling, the assessment of an owner-occupied single-family dwelling pursuant to this division, or the appeal of an escape assessment.
Okay, thanks, Ms. Porsche. So in terms of the as required by law, I assume that the items requested by the assessor are deemed to be required by law if they weren't?
The assessor hasn't detailed what he's demanded, but I imagine that the assessor has presented a 441D.
We send out new construction letters under the provisions of 441D. It's in order to gather information as to what the new construction is, what kind of quality class it is, how much they're building, et cetera, in order to discharge our duties.
Okay.
We should probably hear also from the applicant to get the full information on that. But
thank you.
Based on what the assessor has stated, and not yet having heard from the applicant, it would appear the assessor is correctly citing Revenue and Taxation Code Section 167.
Thank you. So, Mr. Reupsch, in terms of info requested by the assessor for construction,
I never got anything.
Didn't receive anything?
No, I got the first time when I got my tax bill in 2012. I applied, that's why I was here also.
Do you know what address the assessor has?
This is the first time I've seen this stuff.
Okay.
No, I don't have the address that was mailed to. I don't have a copy of that new construction letter. They are automatically sent out with permits when they come into the office.
Okay.
And also, Brook Hill, with the assessor's office, they would automatically be sent to the same address that we send the tax bills to.
Okay. And so the tax bills were received? Or
my taxes are paid by my bank, so I don't know if I get them or not.
Okay. Okay.
The applicant will still receive valued notices. And in this case, I believe you took out 3 or 4 permits total, and we would have sent out an NCL for each one.
I did a guest house first. I did a guest house, 2 garages, then a main house, a garage. There's no permits on the pond, no permits on the stream, so I don't understand how it has a value. I mean, this has been done in 2013. So you guys just walk on the property, and if I do something, you just keep assessing it?
Okay, so
the building process was done in 2012.
Yes.
Before we get into the details, let's just determine where we are in terms of the order and the burden of proof. Ms. Porsche, any other input for us so we can move forward?
It's at the board's discretion if they wish to proceed solely on the testimony of both disputing parties, or if the board wants to ask the assessor for a document to show that the assessor indeed sent out this new construction request for information.
Okay.
It's up to the board.
We do not actually keep copies of the new construction letters because they go out in mass.
Okay.
We scan them when they are returned.
Okay. So to the board, I think the testimony of the assessor has been is that they did send the new construction letters to the designated address. So in terms of the burden of proof, unless either of you find something different, I think we would need to follow what appears to be the case, which is that the burden of proof would fall with the applicant, so that the applicant is responsible for providing a preponderance of evidence to overcome the assessor's evidence presented. Is there any objection to that?
None. If we could just check the address on the application, make sure that this is the proper site.
This the mailing address or the site?
With both of them. Let's just check all the addresses that we have.
Okay.
I think they're all on the...
So Ms. Little asked just to verify from the application the addresses, and we show the notices from the county to the applicant being mailed to 1220 South La Luna Avenue in Ojai, and then the application completed by the applicant, same address, 1220 South La Luna Avenue, Ojai. So it seems that in terms of the addresses, there's not a mix-up. There's also the property address. The property address appears to be 1210
That's what it is.
South La Luna.
That's the one it is, 1210.
Okay. And then the application says 1220 as the applicant's mailing address. Does that make sense?
Not really.
Yes?
It's two addresses.
Okay.
They're right next to each other. So whatever goes there, I get it. Or whatever doesn't come, it doesn't come. So.
Okay. So then let's proceed. Unless there's an objection, we'll move forward. And the first presentation will be by the applicant with whatever info that you have. And then we'll have a chance to ask questions. Then we'll hear from the assessor. Okay?
Okay.
So you get to go first. And if you have any information.
Why don't I just let them go first?
Well, that's a good question. That's the discussion we just had related to the burden of proof. And if the burden of proof is established with the applicant, then the applicant would present information first, and then also be able to have the last word with the last summary closing before we close the hearing as well. So that's the answer.
Maybe. I don't know. Okay, well, let's start.
So if you have any information you'd like to present to us,
I give it to the assessors.
Okay.
They have it. They have 6 copies of the appraisal. I got proof of mailing that it's got there.
Okay.
You know, I've been working with them from day one on. Then I talked to my attorney, and it turns out, because I don't want to be here every year, so he recommended, I didn't understand the whole process, and Brandon explained it to me, I have to apply for a base value. I thought when I come here one time, that takes care of it, the number is set, I can go home, and then the 2% increase every year, that's it. So I didn't understand that part.
Okay, so let's just
now
start
because
with...
I changed it to base value, now the rules change. I mean, this is the first time I heard that I'm supposed to come up with, I give them what they want, but there's certain things I've never been asked for to today or at Science Friday.
Okay, let's just start with information. The applicant said that information was submitted to the assessor that he'd like to have considered here.
Well, actually, he did submit an appraisal for a decline in value for 2014, which is what his actual application stated. Mm-hmm. He amended that application to include base value of new construction today. With that amendment, we are requiring more information. He said he was prepared to go forward on that today. Perhaps he was not really prepared to go forward.
Well, I really don't know at this point. What do you need?
Okay. Is there, so just to establish, is there any more info that you have for us related to the construction that you'd like to give to us right now?
The only info I got in my head right now is I know what I put into place. It took me 5 years to build it. I didn't hire no contractor. I did it myself. That's why it took 5 years, and I don't see no reason why I have to pay taxes on the equity I basically worked for.
So we can either, right now, we can either move forward with verbal testimony of the applicant, and it sounds like there is no additional info, probably. Or there could be a continuance if there's more info that gets exchanged and something happens. So I'll start with the applicant, or do you prefer just to move forward today? And
if it's I try to make it as easy as possible. If it's easier for everybody, we can postpone it, and maybe I get.
It really depends on if you have more information that you don't have here.
I don't have much more, honestly. I mean, what I have is in my head. It's going to be a speech, and that's about it. Believe it or not.
Okay. Any input from the assessor?
At this point, we prefer to just go forward. If he's willing to go forward, we'll listen to his verbal testimony.
Okay, so just so you know, there are two. I think there are two directions you could go. It sounds like you don't have a lot more information that hasn't been submitted.
No,
and so if that's the case,
maybe I just ask for continuance and talk to my attorney about this, if that's possible.
Applicants, we could clarify, the type of information the board would be looking for is construction costs. How much each phase of your construction costs.
That means you want bank statements and stuff like that. I don't have that with me, honestly. So I would be.
Would you be able to gather that information, though, if the board gave you more time?
Yes.
I think that
answers
the question.
Okay. Are there any questions or comments from the board before we do anything else?
You recognize that under tax rules, we have to include labor that you put into the project because
the value,
it's part of the evaluation process. If you sold the property,
if I sell it, but that's when I sell it, right?
Pardon?
If I sell it, obviously the new owner gets the valuation whatever he paid for, but I only put so much in it, so how comes I pay tax on money I never had? Maybe I'm not familiar with the rules, but...
The rule is that you're taxed based on the value of the labor, even if you didn't pay anything for it.
Then my question is, who sets the value? Is an official licensed appraisal not able to set the value? Because that's the number I'm actually shooting for, the appraisal value. That appraisal shows everything on the property, including the stream and the pond.
That's where this hearing comes in. We hear information from both sides with their opinions of what the value is, and then the board collects all that information and makes a decision. So if you feel that you have more information that you'd like to gather before you present to the board,
I do.
That you could request a continuance, or you could continue right now with what you have.
No, then I'll request a continuance.
That appraisal you're talking about, does that include all this, the new construction?
Yes, everything.
Mr. Crow, just for clarification purposes, that appraisal was done for the 1/1/14 lien date, not for the new construction items as they occurred. So it has to do with the decline in value, not with the base values. Because the completions of the constructions all occurred between 2012 and 2013, I believe.
2007 to 2012.
That's when the construction was ongoing. But there were different stages of
completion. The construction was completed in 2012.
Yes, that's what I said.
The appraisal from 2014. So it's all on there, everything.
However, that appraisal deals with the value as of January 1st, 2014.
Yes.
It doesn't deal with what the value was as of the date of the completion of construction, which is when we are required to value the property.
Mr. Meyer, let me step in for a second. Is the assessor opposed to a continuance? I might have already asked that.
We've requested the data on several times. As far as his costs and his construction. He never provided it.
Okay. Okay.
Would an on-site visual inspection be helpful to the assessor's office if he would allow it?
There were 3 attempts made. The first 2 times he asked us to leave the property before we could inspect it. The third time, Ms. Rovtar made an appointment and he called and canceled under the advice of his attorney. So we have never been able to get onto the property.
Okay. Mr. Roach, are you willing to allow the assessor to visit the property and inspect it? No. Okay.
No, I mean, why? That's why I hired an appraisal.
Okay. So
the law says I don't have to, right?
I'm not sure.
So the question is now, if the assessors never showed up on my property, how do they know about the pond and the stream?
Okay. So. You have the ability to request a continuance, or we can continue now. The continuance wouldn't necessarily be granted, but I'm just helping you understand what your options are. And any other questions at this point? If you're not willing to send information or allow the assessor to visit the property, then I guess you'll have to
send them more information, but I'm not willing to let the assessors on my property because I was always on the assumption property taxes goes by permits. Every time I pull a permit, the paperwork goes to the assessors. So there is no reason to get on my property. Does that mean every time I plant a fruit tree, the assessors can raise the appraisal?
Okay, understand.
And what's the difference between a county appraisal and my appraisal? My appraisal wouldn't lie. It's losing its license. It's a livelihood.
Okay. Any discussion or direction from the board in terms of moving forward with, in terms of discussion, other board members opposed in favor of a continuance to see if the process can move forward at all?
I think that would be best so that the applicant's due process is protected. I'd like him to have all the opportunity to bring as much information as he can, if it's even just a handwritten note, my plumbing costs this, my framing costs this. Those are hard numbers that this board can evaluate and put more weight on that.
Okay, no problem.
I'd like you to have the due process.
I'll do that, thank you.
Mr. Crow, any comments?
Well, I don't think the applicant has cooperated at all with the assessor's office, and so I would not be in favor of continuation.
Okay. And thank you. Ms. Porsche, I assume that you would tell us if you had any direction for us in terms of what we're doing.
I would just echo the comments made by Board Member Little that it's to the board's benefit that it affords the applicant full due process and
Okay.
the applicant and the both parties will have greater confidence in the board's findings. The board has broadest possible information base.
Okay, thank you. Do we have a motion either, there is a request from the applicant to continue. Is there a motion either to accept or deny?
Mr. Stern, if I may?
Yep.
I'd also like to hand out a court case that kind of mirrors this case. It's an appellate court case. Sims versus Pope 1990 regarding applicants that refuse to allow assessors onto the property at the time.
Okay.
And for everybody's review, if we do a continuation, we can review this also.
Okay, thank you. We'll call this Assessor's Exhibit A. And we'll have a copy for the applicant as well.
Thank you.
Is there Mr. Meyer, do you have a summary of what you're presenting so we're not reading the entire
This was a
case?
situation where a taxpayer did an addition on their property, took out a permit, and the assessor went out to measure it while it was in frame stage. And then when it was completed, he went out to try to measure it again, and he was thrown off the property. Under Revenue and Taxation Code Section 401, the assessor is required to assess all property in the county. And under Section 501, if we ask for information and is not provided to us, the assessor is required to make an estimate of the value based on the evidence that we do have or the materials that we do have with us.
Mm-hmm.
We had plans. That was it. So we made our estimates of quality, size, construction, based on the plans that were available to us. And as far as the pond is concerned, we did that via air photos. We do what we can with the information that we have at our disposal.
So basically, you're telling me from now on, you just fly over my property every year, just keep increasing the base value because there's just something new on there.
Okay.
There's no permits required for these things at all.
Actually, if somebody were to do some new construction without a permit, the assessor is still required to value that. Even if there are permit processes available, but a property owner builds without using it and utilizing it, we are still required to value it.
Well, yeah, I don't have anything illegal on the property.
Okay.
But like I said, there's no permits required for a stream. If I take the water out of that stream, what is it worth?
Okay, I think we've heard as much specific information as we can and enough to make a decision. And so we'll ask if there is a motion in either direction.
I'll make a motion to sustain the assessor's valuation.
Okay. And let's see. I think the question before us, Mr. Crow, was continuance versus moving forward. Is that based on lack of information provided by the?
Correct.
Okay, thank you. Okay, is there a second?
No second.
Okay, and I will not be able to second the motion, so motion dies. Any other action? Proposed motion? I think
I'm waiting for the screen. There we
the
go.
first request was related to the continuance.
Yes. I move to continue this matter to a later date, especially noting the fact that the applicant did amend his application today to include the base year, so enabling him to collect more information to supply to the assessor's office regarding value.
Okay. Is there a second? No. Okay, I will second the motion.
And we would like that information within 30 days, please.
My motion is so amended, 30 days.
Okay, so Mr. Vlahakis, could we have a roll vote, or do we just do it? We already have it, right?
We will record whoever says no
Okay.
or abstain.
Okay. So the motion does pass, However, I just realized as I said that there was not a date,
Right.
a continuance date in the motion. So
Right.
let's take a step back. December 7th, I'm just going to guess, is something that's been acceptable before to our applicant. Is December 7th acceptable?
Yep.
Okay. Motion so amended to continue to December 7th.
Okay, and I will second. Okay. So in terms of communication, there will be a minute order or communication from the clerk's office, I believe, to the applicant.
Thank you.
Okay, thank you. All right. Next, items 84 and 85. Applications 14-10373 and 14-10374. Applicant is Chuck Kane. Mr. Kane, you're welcome to use the desk area to your right if you'd like, if you need more room than you have here.
I'll take you up on that.
Okay. And you can just push the door open.
Possessory interest case.
Mm-hmm.
You heard it.
Means we can hear you, so just push down on that button before you speak, alright? Stay on. Yeah, no, just push it on. I don't know which one you're going to sit, but once it's lit up, you can hear me.
Okay. Well, we'll wait for Mr. Kane to get ready, and so we'll just wait one more minute. Okay, we'll move forward. So it looks like we have either a possessory interest or personal property type of case, and so we'll begin by asking the assessor just to provide a brief overview on what we have.
Kent Meyer, Ventura County Assessor's Office. Mr. Kane purchased an airplane hangar at the Camarillo Airport. There's two types of hangars out at the Camarillo Airport. There's those that are owned by the county and leased, building and land. And then are those where the county leases the land and the buildings themselves are actually owned by individuals. Mr. Kane purchased one of those that's owned by individuals. He paid $100,000 for it on January 15th, 2013. We accepted the sales price. In the case where we accept sales price, the burden of proof lands on the applicant.
Okay. Thank you. Just to clarify, purchased the hangar on leased land?
Correct.
Okay. Great.
And I believe findings of fact are requested by the applicant. Is that correct? Are you requesting findings of fact still?
Yes, findings of facts, please.
All right. And do you have payment for this?
Fill it out.
Okay. Just make sure I get it before the hearing's over. So, just for the record, findings of fact are requested and in the process of being paid for.
Okay, so the burden of proof will be with the applicant. We'll start with the applicant's presentation, and then the board and assessor will have opportunities to ask questions, and then we'll do the same with the assessor's presentation. So, Mr. Kane, whenever you're ready. Okay, go ahead. Okay, so we have packets of information from the applicant. I guess we'll call the whole thing Applicant's Exhibit 1. Which has a table of contents on top.
Okay.
Whenever you're ready.
All right. We did cover the facts, so I'm requesting a finding of facts. My name is Chuck Kane. I'm the owner of hangar number 70 at Camarillo Airport. I'm a resident of Thousand Oaks, California. So I provided you with a packet, and I guess the best way to do this is just to go through the packet from the beginning to the end and cover the various items that are in the packet. And then I'll try and touch anything I think is important after that. So the first page of the packet is a picture of two pictures of the same steel hangar. That steel hangar belonged to EAA Chapter 723. That hangar was taken down because the CAF wanted to build a larger hangar on that site. So that hangar is identical to mine, except it's 30% larger and 15 years newer. And that hangar had no value because it had no place to live. So that hangar, even though it was newer and better than my hangar, could not be sold. We could not get any money for that hangar. It had no value. So the second, page 2 is additional pictures, and page 3 is additional pictures. So page 1 has the picture of the hangar from the outside. Page 2 has the picture of the hangar from the inside. Page 3 has the picture of the site after the hangar slab was removed and the property was bulldozed. So that hangar was larger and newer than mine, and and that's what I own. I don't own the property. I own the same tin building by the same manufacturer, except mine was in much worse shape, and that hangar had no value. Okay. The next group of pictures, marked 3A with a sheet behind it, 3B and 3C. This is a hangar number 58. This hangar is a brand new hangar, which doesn't happen often at Camarillo or any of the airports out here because the county is very restrictive in what they allow you to do. It's a brand new hangar, and the guy came to you after he built the hangar, came to the assessor, and he brought all of his construction costs. And I'm sure the assessor did everything he could to create all the value for the county he could. So page 3B is his assessment for hangar 58. And under improvement value, that hangar is worth $80,580. So when he took all the money that he spent on that hangar, including whatever else they added in, they valued that hangar at $80,580. That hangar is 20% larger than mine. It's brand new. It has a bifold door, which you can see in the lower picture. It is a much improved hangar compared to mine, which we will discuss here in a moment. And its value is only $80,000.580. So that is a new hangar built. Now we're going to get into the assessor's values of supposedly my hangar based on replacement cost, and it's going to supposedly be much higher than this hangar. But here's an example of a hangar that was built in the last 3 or 4 years. And the guy brought all of his paperwork, and the assessor evaluated it just like the case before, except he probably provided that information. And they came up with a value of $80,580. Okay. Picture 3C. Picture 3C is a hangar that's about 30% smaller than mine. This hangar doesn't have a home anymore, and this is what I own. I own a hangar. I don't own the ground. All I have is a 35-year-old rusty tin building. Here's another older tin building, and this hangar doesn't have a home anymore. I'm guessing this hangar has to be moved because the person's got permission to build a bigger hangar on the site. So he's trying to sell that hangar. So that hangar, he's hoping to get $4,000 for that hangar. So my hangar is 30% larger, so let's just say my hangar's worth $6,000 using this evaluation. All right. Pictures 4, 5, 6, 7, and 8 are my hangar. All right. So page 4. This is my hangar. My hangar is sitting on the tarmac with no foundations. The top picture A, you can just barely see it. It's all rusted out there. That's a 2x4 underneath there. Basically, it's spiked to the ramp setting on 2x4s. Because it's setting in water on 2x4s, you can see the whole lower rail has rusted out. That's page 4. Page 5 is another 2 photos. The top photo is more rusting along the bottom, and you can see that it's caused by the fact that the hangar sets directly in the wet ground. Picture B is the total extent of utilities that I have at my hangar. Electrical. I have no water, I have no sewer, I have no HVAC system. I have electrical, that's it. Page 6. The top picture, and this is primarily provided to show that the hangar does not set on a foundation. It's setting on 2x4s. So you can see the 2x4 underneath the metal beam in picture A and in picture B. The hangar it's a 35-year-old building. It's not in very good shape. Now, page 7 is pictures of the rusted roof. At the top, picture A, you can actually see daylight showing through the rust there. Picture B is a little further back, so you can't see the daylight. Page 8 shows the door assembly, and this is the most basic, simplest door assembly as compared to the hangar I showed you earlier with the bifold door where you just push a button and the door goes up. This one requires you to manually roll the door open, and then if you take the plane out, then you have to manually roll the door back. So, and you do that again when you come back. So it takes about 10 minutes. So basically, if you fly for an hour, you've got about 20, 30 minutes of door manipulation. All right. And the bottom picture is just a picture of the front of the hangar from a distance, so you get a feel for what it looks like. The hangar is 35 years old. It was built at a time you couldn't build probably that hangar similar to that now because the standards have apparently changed. It was built, it's an inexpensive, light gauge, 35-year-old tin building setting on no foundation with a minimalist door assembly. It hasn't been especially well maintained over the years. So the roof leaks, the beams are rusted out like I showed you. Okay, so I'd like to get into the cost approach to the value of this hangar. So the Assessor's Handbook, section 534, has the ability to cost steel buildings and things of this nature. So I've provided you with 3 pages from that handbook. The first is a basic farm building shops. The second is the pictures of the buildings, which are very similar to my hangar. And the third is the evaluation of those buildings out of the assessor's handbook, which is what I guess something that they use all the time. So on the third sheet of those 3 sheets, I circled the value of $16.45 a square foot. I have 1,920 square feet. When I multiplied that out, it gives you a price of $31,584 new. I did a straight line depreciation using a 39-year life and came up with a value of $32.39, considering the hangar is 35 years old. I also did a percent good after reviewing the assessor's handbook. It says in the assessor's handbook that you should use the 40-year life table, which I did, and for non-residential buildings or other than residential, OR, that gives you a 43% good, and if you use that factor, you end up with $13,581 for the value of the building. Okay. Additionally, I called 7 hangar builders, and I asked them what they would charge to put a hangar up on this site. And I provided you the numbers they gave me, and the bottom's 33 and the top's 48, and that's the new price for a new hangar. So if you depreciate the largest number, you're going to get a number quite a bit smaller than that, depending on which depreciation method you use, straight line or percent good. So that deals with what I have to offer you with regards to the cost approach. I used the assessor's own handbook and went through it, and I also did another workup, which I will give you in response to the assessor's presentation, because I looked up a different thing. When I was in the assessor's handbook with regards to cost per square feet, I could not find a cost for any kind of building like this of any kind that exceeded $30 a square foot. Now, when the assessor makes his presentation, he's going to give you a different number, and it's going to be over double that. So I can't find anywhere where the Board of Equalization in its handbook thinks that this building is worth any more than $30 a square foot. So that deals with the income approach. Okay, so I've got 2 sheets with regards to the income approach. I did the worksheet first, but actually the second sheet, which is the County of Ventura Department of Airports sheet, that's where I derived the numbers from. So it talks about private hangar and county hangar. So I took, the principle would be that my hangar is the same as the county hangars. Now that I own a hangar, so I don't pay rent on the hangar, and I pay rent on the ground. The county owns an inventory of hangars where people rent both the hangar and the ground. So I did an income approach using the value that people pay the county for identical hangars in age and size of mine. So what I did is I subtracted the value of the ground off the value of the total price that they pay to rent the hangar, and I ended up with a monthly cost of hangar only of $0.184 a square foot. I then multiplied that times the 1,920 square feet and came up with $353.28 times 12 for an annual return of 4,239. I then used a 10 gross rent multiplier and came up with a value of 42,394. If you don't like the gross rent multiplier, then I took that same number and used a cap rate. I used the formula that will be in the assessor's presentation, and I came up with a value of 46,582 for the hangar. Either way, it's $42,000 or $46,000, so it's nowhere near the $100,000 that the assessor believes it's to be. All right. The next sheet is what is constituted in a hangar purchase. Now, when I say I buy a hangar, I'm not just buying the tin building. It's like if I said I buy a house, that doesn't mean I didn't get the garage. It's the same with a hangar. When you buy a hangar, I'm buying the building. I'm buying what I perceive to be the value of the land that the county is going to be leasing me. And in the case of the airport, I'm buying what's essentially a right to position. Because there's a limited number of licenses issued by the county, just like there's a limited number of liquor licenses issued by the state, they've created an artificial environment. That artificial environment essentially creates intangible value. All right? So the third thing I buy is the right to the position to have that license, and that's intangible. But it's in there along with the value of the hangar, which we're trying to establish, and the value of the land, which the county has established to be at $16,300 through their possessory interest formula. So there's three things you get when you buy a hangar, not just the tin building, which is what the assessor would have me believe. All right. The next sheet here is a sheet I worked up with regards to values included with a hangar. All right. And I likened it to the situation with a liquor license. The state of California limits the number of liquor licenses available. Because they limit the number, there's an artificially high value to that. It's an intangible value, it's not taxable. The county, another governmental agency, limits the number of licenses they'll allow at the airport. They don't have to do that. They especially do it with regards to private hangars because they've decided their business model, they would rather have county-owned hangars. They never get around to building them. That's why there's a waiting list of 150-odd people. But they will not issue any more licenses, even though they have the land and they're parking Kias all over it, for private hangars. So by doing that, they create an artificial environment. That artificial environment creates unrealistic prices, and it consequently creates an intangible value to the right to the position to hold one of those licenses. So there's an intangible value here. When you sit down and you establish the value of the land, which is $16,300, and you establish the value of the hangar, which is, just for a ballpark figure, $25,000, and you add those two together, there's a number that doesn't equal what the purchase price was. And that's because there's an intangible value created by the artificial shortage of licenses created by the county because of their policies with regards to these hangars. The next sheet deals with position rights, which is essentially the right to be the number one person and hold the license. This thing's a little bit not well represented, but the argument I used on that page essentially is if someone waits in line at a popular housing tract to buy a piece of property at the housing tract, and he waits there a week, and when he goes back to work, his boss docks him $1,000 because he skipped a week of work. Does that change the value of that property? I would contend it doesn't. Say, for example, he didn't want to get docked $1,000, so he paid a neighborhood kid to sit in line to buy that piece of property. Does that change the value of the underlying property? No, it doesn't change the value of the property. The property is worth what the builder and the developer believes it's worth. If he had to pay $500 to the neighbor kid to sit there, then he paid $500. If he lost $1,000 at work because he didn't show up at work, he lost $1,000. Intangible items. So that's pretty much, the next pages are my tax bills. All right, so I just included 2 tax bills. This page here, the one that shows the original assessment, it's got Camarillo Airport sales, okay? This was the original appraisal done on the property, okay? 3 of the 4 comps don't meet the rule with regards to 90 days. They were outside of the 90-day rule. So the original appraisal really didn't exist as far as its legitimacy because there were no comps for it. And that's the appraisal that I'm actually, and the value I'm actually appealing. Now, there's going to be a subsequent appraisal here that the assessor's going to present, and I'll debate the merits of that. But the original appraisal to support the evaluation was basically severely flawed in the fact that it only had one comp. Three of the four comps were out of date. The next piece of paper is a copy of the possessory interest workup. I find the possessory interest workup interesting. Possessory interest is a three-legged stool. You have to have three things in possessory interest. I have to dig back here to get the specifics, but the bottom line is at the airport, we don't have those three things. We don't have any guarantee of exclusivity. We have exclusivity. We don't have independence, and we don't have durability. Now, I'm not going to debate the possessory interest, but I'm just saying it's a weak argument. We do not have independence. If we will get into the rental, the rules that you have to follow, that's the next group of things. But the bottom line is, if you don't follow those rules, you're out of there. And they're their rules. You don't get to set any of your own rules. Basically, you follow the rules or you're gone. We don't have any durability. We are on the weakest of contracts you can have, a license. Okay? That license is 30 days at the most. You don't break any rules, your check gets in on time, you get to stay 30 days. Okay? You don't break any rules the next month, your check gets in on time, you get to stay another 30 days. Now, the possessory interest workup is worked up as if I was guaranteed to be there for 10 years. There's no guarantee I'll be there in 10 years. It's quite likely I won't be there in 10 years because I'm 71 years old. And I could lose my medical tomorrow and they would kick me off the airport because I can't fly. And if I can't fly, I can't have an airplane. And if I can't have an airplane, I can't have a hangar. So the possessory interest, again, I'm not debating the possessory interest. It's the way the county wants to value the land. My argument would be is if you're going to value the land under possessory interest, then, and I valued the land in the purchase price of the hangar, you can't have it both ways. It's essentially double dipping. When I paid the money for the hangar, there was a value I perceived in that purchase price for the land. And you're taxing that. Okay? And then you come back and you do this possessory interest workup and revalue the land again. A possessory interest workup in this form is no different than essentially a income approach to value for the land. So you use a comparable sales approach for the value of the land and value the land once, then you turn right around and do an income approach to value a land and value it twice and then charge me for both values. You're double dipping. That's my opinion, again. So the next group of papers are the hangar license agreement. 1, 2, 3, 4. 4 pages of rules, 25 different paragraphs of rules. Again, this deals to the independence with regards to possessory interests. There's no independence if this exists. I do have exclusivity. I do get to lock the hangar door. So to that degree, now I can't lock it on a permanent basis. The airport reserves the right to come on the property at any time and check to see if all these rules are being followed, and they've made it perfectly clear that that's what they're going to do. They feel that the FAA forces them to have these rules, which is another governmental agency, and that they're required to impose these rules on us in order to protect their right to get federal money at the airport. So the idea that we've got some kind of wide open situation at the airport, rent a hangar, do whatever you want in your hangar as long as your airplane's in there. That's not what's going on over there. So after the rental agreement, which is also, I believe, in the assessor's presentation, this is a 2-page letter I wrote back. The assessor wrote me a letter asking me how to value my hangar. So I wrote back a letter explaining to him different ways he could value the hangar. And I wrote back 9 points about the condition of the hangar. It's 35 years old. There's no foundations, footing setting directly on the ground. The lower metal portion of the hangar is rusted away due to contact with ground. Roof leaks many places, is rusted through. Built with light gauge steel. Old manual sliding door that hangs up. No water, no sewer. Limited use as per airport rules as to store aircraft only. So in the first page, the body of the letter, I essentially described different ways that they could value the hangar. At the time, I hadn't researched your methods of evaluation with regards to cost, income, and comparable sales, so I suggested that they find out what a hangar costs new and do it that way. I suggested they maybe bring a hangar, find a used hangar and find out what it would cost to put it on site. And the last one was, I knew the value because I knew the gentleman who built the hangar back in 1979, that they maybe used the numbers that he had. The rest of the packet is essentially sections of the assessor's handbooks, 501 and 502, that I've highlighted mostly for my own reference, but also because there's certain aspects of it. And then the last portion is some case law with regards to cases with regards to possessory interest, cases with regards to intangible values, cases with regards to misapplication of approaches to evaluation. So that pretty much covers what I have here.
Okay, thanks, Mr. Kane. We'll go next to questions from the assessor to the applicant based on that presentation.
Mr. Kane, how much did you pay for the property?
The number you have is correct, $100,000.
What did he say? If you were to sell that, how much would you sell it for?
I don't know what you could get for it. The market's all over the place. You have to wait. It's hard to know what you'd get for it because what people ask for them and what they accept for them after 2-3 years of waiting are quite a bit different numbers, and nobody talks about them. You folks probably know better than anybody because you actually have some way of ascertaining these values. No one at the airport talks about what they paid for their hangar, and there's no way to know what you could get for it. But probably a couple of years down the road, my hope is I could get my money back.
There's also why did you purchase it as opposed to actually rent one?
Okay. I'm 71 years old. You presented in your presentation a hangar waiting list. It's got 150 some odd people on it. The part that you don't show there is that makes the list somewhere between 3 and 5 years long. To fly, you have to have a current medical. If you haven't got a current medical, you can't fly. At my age, it's quite likely that I won't be able to keep my medical for some reason that happens when you get old. So a 3 to 5 year waiting list is not practical, just like projecting the possessory interest out 10 years for me is not practical. So I waited for a while, and then I finally just could not bear to watch the airplane deteriorate on a tie-down.
Do you understand the concept of supply and demand?
Yes.
Because of the fact that there's a low supply and a high demand of these airport hangars, Don't you agree that that's what drove the sales price?
No. I agree that there's a supply and demand, but the idea that it's an open market and that supply and demand is set by the market conditions, that's what a supply and demand market is, not when you've got a contrived, restricted market where the county limits the number of available spots and creates an artificial value. This hangar on another airport where there's not the restrictions that this county places, and the hangar is what I own, would be worth more like the numbers I'm presenting to you. So the hangar itself, again, the debate I'm having here with you is the value of the hangar, not what I paid for the total package, which includes, as far as I'm concerned, the 35-year-old rusty tin building, the value I placed on the land and the right to use that land, and the intangible value that the airport commission creates, or the airport authority creates by creating an artificially limited market, just like liquor licenses. If liquor licenses were everywhere, they wouldn't be worth $100,000. But they're not. The state controls the availability of liquor license, creating an artificial, intangible value to a liquor license. It's the same thing here. When you've got the value of the land, which you own, and you tell me it's $16,300, I'll accept that. I can prove that the hangar is not worth a dime over $25,000. There must be some other value here. And I'm saying it's an intangible value created by an artificial market, created by policies at the airport. So,
amongst the issues as far as value are concerned, the things that drive value are desirability, utility, scarcity, and transferability. The transferability is somebody buying and selling. The scarcity of the property also drives the value. You're basically saying that because it's scarce, it's intangible. You do understand that the scarcity is what's driving the value up.
I'm saying if it was scarce in a real open market, then your hypothesis would be correct. But this is not a real open market. This is a limited, contrived, controlled market. And all of your printings in your handbook say that it has to be an open market, a viable market, a market with willing buyers and sellers that is not controlled by an outside force. Scarcity in itself, if it exists without an outside controlling governmental agency, yes, then your premise is acceptable. I find that. But scarcity created by the very county who is now wanting to tax me on the artificial value that they created by creating a scarcity, I have a problem with. Yes.
And were you a willing buyer?
Did I write check? Yes.
And was the seller willing to sell?
He's gone and I'm there. Yes, that's what happened.
That's an open market.
It's not an open market.
If you had not purchased it, would somebody else have purchased it?
Now, how would I know that?
In theory, are there other people waiting to buy hangars in that airport?
Well, you've got in your presentation, you seem to indicate that 3 or 4 of them change hands every year, so I guess there are.
This owner
sat on this hangar, I think, a number of years waiting for somebody to come along.
Mr. Meyer, I think you made your point on that question.
Right.
Do you have any questions? No further questions.
Okay, thank you. Are there any questions from the board to the applicant?
No.
If you're dealing with a property located up on one of our beaches here, it sells for, way over what the thing is worth as far as construction of the house, isn't that a kind of a similar situation?
I would say yes and no. The difference there would be if I owned a piece of property at the beach, sure, the house isn't worth that much, but the land is. In this case, I don't own the land, but the land would be worth quite a bit of money. Even without the house, a lot on the beach is a very expensive piece of property. And if I owned both of them, then yes, I would have control over that. But in this case, I own a rusty 35-year-old tin building, and that's all. And I get the privilege of paying a monthly rent to the county for the land that's underneath that building, but I don't own that land. So if I had a 35-year-old tin building sitting on $1 million beach lot that somebody else owned, but that's not how the values are done at the beach. I mean, the owner owns the house and the land. In a lot of cases, the houses are tear downs. I agree with you. The land is the value, and the land may be the value here, but I don't own it. And if it is, then that's fine. It was in the purchase price. Then then the assessment should be the purchase price without the possessory interest, or the assessment should have the possessory interest reduced out of the purchase price because the land value was in the purchase price. So to the degree that I valued the land, it's in the purchase price. I mean, I'll put it another way. I think someone's essentially asked here, could I sell it or whatever? The question I would say is, I think I vastly overpaid for what I got. If I'd have known the airport rules, and if I'd have known the condition of this building, and if I'd have known some of the stuff I currently know, I wouldn't have done this deal. It's not worth it. The taxes are equal to about half the rent on the property the way it's set up right now. So I wouldn't have done this deal. I wouldn't have paid this kind of money for this property if I'd have known the rules and if that the airport was going to impose on me and the limitations, and if I'd have known that the condition of the building and the fact that the county was going to say it's worth $100,000 even though it's a rusty old tin building, and that that was going to be and then they were going to add possessory interest land value above the value that I had already placed on the land internally when I bought the property. So.
Okay, thank you. Ms. Little, you said you did not have any questions?
Correct.
And Mr. Crowe, any other? Okay, I don't have any questions right now. So let's go next to the assessor's presentation.
Under Property Tax Rule 321, in a case where the applicant has the burden of proof, he first must provide that burden of proof. It is the opinion of the assessor that that burden of proof has not been met. Under 313C, the board must make a determination as to whether or not the burden of proof has been met before requiring the assessor to present their evidence.
Okay, thank you. Any discussion from the board on that fact, that statement?
I understand where the assessor's coming from.
I understand where the assessor's coming from as well. I think that the primary point of contention is what the definition is of the complete value and the open market, the nature of an open market transaction, which I can appreciate from the applicant's perspective. However, I think that in this case, the applicant's perspective doesn't comply with the law that regulates the taxation and the rules that our board is required to follow.
And the applicant carries the burden.
Correct. Mr. Crowe, any comments? Okay. Without any further discussion, is there our options are either to make a motion and take action at this point based on what the assessor has provided, or to ask for the assessor's presentation. So I'll ask if there is a motion to any effect, and if there is, then we'll take it from there. If not, we'll keep going.
In fairness to the applicant, I think we should have the assessor put a presentation on.
Okay. And so I don't think we need to have a formal motion in order to keep going. I think that the assessor made its request. Any other comment?
I'm at the other end of the spectrum. I am seeing that I don't have enough information to show that the applicant is carrying his burden of proof at this point.
Okay. And is there a motion that you'd like to make, Ms. Little, or you don't have to? Just.
Yeah. I'll move to sustain the assessor's opinion of value.
Okay. And is there a second?
I'll second that motion.
Okay, so we've had a motion and a second to sustain the assessor's value based on the information already provided by the applicant
and his lack of providing information to show he's met his burden of proof.
Okay, so we have a motion and a second, and motion carries, and we'll all vote electronically. Carries unanimously. So I'd like to thank the applicant for the obvious considerable time that you put into your assessment, and I'm sorry that didn't work out.
Just to clarify, council, there's been findings of fact requested. The board is not meeting for the next 45 days, so what we'll do is we'll get the board's approval on those by email, and then we will mail a copy to the applicant within 45 days. And then we'll put it, just for public acknowledgement, we'll put the findings of fact on a future agenda just to acknowledge on the record that they were issued, and just so that's clear.
And just to clarify, 45 days from the clerk's issuance of the minute order regarding today's hearing.
Correct, and it'll be probably a week or so. So 45 days from when the minute order is issued, there'll be findings of fact made available.
Mr. Kane, do you want your information back?
I think for the findings, we actually, well, we have one copy that the...
Yeah.
I have a set.
So, it's okay. Okay, so in terms of the findings, it sounds like we do not need to take a specific action to request a date. It's just...
No, I'll prepare the findings
Okay.
and circulate them to Brendan to circulate to you all
Okay.
for your review.
Thank you.
Mr. Stern, I'd like to request a short recess.
Sure. Let's take a recess for, is 5 minutes enough? Okay. And then we'll come back and hear item number 13, Green Energy Holdings, LLC. Assuming I can find out which one I'm looking at. Wait, which one is this? 13. Okay, we're back in session. It is 3:16, and we are hearing item 13 on the agenda, application 13-10777. Applicant is Green Energy Holdings, LLC. And thank you for your patience. I know it's a long day. Let's see, it looks like we are dealing with a commercial owner-occupied property and a change in ownership. So let's, why don't we just get a brief overview, if we could, Mr. Meyer, from the assessor, and then we'll go from there.
This is a gas station property that was acquired through foreclosure process. It is the opinion that this is not an open market transaction. We enrolled a value based on market evidence. The applicant feels that our value was too high and that we should have accepted the amount that she enrolled as, or she presented as, the foreclosure price. Therefore, burden of proof does need to be decided by the board. I have a letter that I'd like to hand out that is to the Amador County Assessor from the State Board of Equalization in regards to foreclosures.
Just to clarify, findings of fact have been requested, and I believe you can, and paid for. I've gotten so many checks today, and paid for on this.
Okay,
matter.
thank you. And I'm sorry, I forgot the name of our app.
My name is Michelle Fate. Can I also have
Yes.
a copy of that letter?
And that's what I was just going to...
Thank you.
Mr. Meyer, do you have a summary you'd like to...
Basically, on page 2, there's a small yellow highlighted section of this, which basically states that foreclosure sales fall short of the meeting the listed conditions necessary to establish an open market transaction. Therefore, under 321, Rule 321, the assessor has done their job correctly, and we feel the burden of proof is actually on the applicant.
Okay. And any opinion from the applicant in terms of just burden of proof?
Yeah, I'd like to read this. Do you mind if I take a moment to read it?
Sure, go ahead. That's fair. Go ahead.
Thank you.
Just let the board know too. The board had ordered a subpoena on this matter, so I don't know if there's any formal procedure for ensuring the subpoena was complied with or not.
I think Mr. Meyer made a statement that
They were ready to proceed.
We're willing to continue without it.
Okay.
Okay.
Thanks, Mr. Vlahakis. While the applicant's reading the letter, I'll just ask our counsel if there's any opinion on burden of proof.
I'd like to review 321 and Rule 2.
Okay.
Under Rule 321, it's council's opinion that the applicant has the burden of proof in this proceeding.
Okay.
And there's a presumption that the assessor has properly performed his or her duties. And it's the applicant's burden to overcome that by preponderance of the evidence.
Okay. Thank you.
Would you like to see it?
I want to know how I can rebut the presumption.
Oh, I'm sorry. Push your red button.
I'm sorry.
It's okay.
If the presumption is back on me, then what evidence can I provide in order to rebut the presumption?
There was a foreclosure sale price. That's not to be accorded the same consideration that would be given to a open market sale price that's been independently negotiated by people with arm's length value. You have evidence, at least looking at the application, it appears that one of the boxes checked was I, and there's, according to the application, issues regarding underground contamination, vandalism, those might be, evidence regarding those issues might have some bearing on value. So it's your burden to prove by the evidence that you present today why you believe your opinion of value is supported. The fact that a price was paid in a foreclosure sale is not going to be given the same effect as an open market sale price that's paid. So
Okay.
you've got to present your evidence as to proof.
I understand. So basically, the fact that the value is based on a foreclosure, there's nothing I can do except rebut the presumption that there's other factors affecting the sale price, so that shifts the burden to me automatically. There's nothing I can do to rebut that presumption. Is that what I'm understanding?
Right. It's up to you to independently prove through the evidence you present what the market value of your property is, given all the conditions affecting the property.
Okay. So regarding the letter dated March 26, 1999 to Mr. Quinn of Judge Honorable Raymond Olivara, it's just an opinion letter by, the Board of Equalization. If that's something that you guys are going to use as...
This opinion letter, council would consider to be advisory in nature and not binding. But
And Ms. Portia?
the analysis in the letter...
On the front of the letter, up at the top, there's a barcode. Underneath it is 460.0031. This is actually part of an annotation.
Well, I think the board has enough information gathered to just make the determination to move forward in terms of the burden of proof, and based on the information from our counsel and what we've seen, I would feel comfortable with moving forward with the burden of proof being with the applicant, unless there's any discussion or...
No discussion. It's just we put the weight that the board deems appropriate on every document that comes before us.
Right. Okay. So without any discussion, otherwise we'll proceed. The burden of proof will be with the applicant, so the applicant will be first to present, and then we'll go through the process. And also, Ms. Fateh, you'll be the last to
Rebuttal? Yeah,
Thank you.
Okay, no problem.
So go ahead whenever you're ready.
Okay, so I have some documents to present. Am I handing it to you and then you hand it to the rest of them?
Yep.
Okay. So I'm going to keep one and give you 4, right?
You're supposed to provide us with 6.
The problem was I came to this session twice, was ready to move forward, and I gave already 2 copies of everything in 2 different occasions to the assessor's office. So I didn't make extra copies because I assumed they
That's
had
true.
the
There
copies.
was info submitted already before the continuance.
I was ready to proceed. So if you want, I can give you all of my copies, which is 5.
Sorry to interrupt, Mr. Vlahakis. Do we have the submittals from during the continuances, or were I remember that we've continued at least once or twice.
I'm not aware of what, I don't believe any...
I guess we never did proceed to the hearing.
Right, only when it's admitted to evidence does the clerk keep it. I think she's saying she provided it to the assessor's office.
Okay.
That doesn't count as formal hearing evidence, so she is required to have 6 copies. Do the board members mind sharing a copy or 2?
I don't mind sharing with Mr. Crow if he'll let me have them since I'm
we
at
just
the
have
end.
to have, when it comes down, we have to have a copy for the clerk for the record and a copy for counsel for the findings.
That's fine.
But as long as we get those.
Let's do that.
So I'll take everything but 1 copy and
Okay.
we'll figure the rest out.
Okay, so
Mr. Stern, could we just go on to the next hearing while she goes and makes copies?
I think we're okay with sharing it, and she does have them right here.
okay.
Thank you.
Actually, let me introduce the information. The reason, sorry, Brandon, it might be a little bit. The reason we are here today is because a foreclosure took place August 1 of 2012, and that foreclosure amount was $819,000. The assessor assessed an amount higher than that amount. The basis for the foreclosure was litigation that resulted in the debtor not satisfying the creditors, which then turned into a foreclosure on a trust deed dating back to 1995. Any creditor that had that particular trust deed was inviting themselves upon foreclosure to a world of litigation, because there was going to be claims by the title company, cross claims by debtors, creditors, other banks involved. The reason why the creditors decided to move forward is that the debtors were in bankruptcy. In June of 2012, it came to the creditors' attention that there was going to be a tax sale on the property as a result of almost, I believe it was $180,000 in back property taxes that were due. So the creditors had to step in and save the property by making arrangements and paying for and guaranteeing the $180,000. At that time, the debtors were in bankruptcy, which was controlled by a trustee. The trustee basically looked at the property, saw that there was no way to achieve any value, and therefore, as part of the bankruptcy estate, abandoned the gas station, which allowed for the creditors in a brief period of time to foreclose on that property. Basically, they had a 12-hour window to foreclose, and they wound up doing that. As a result of that foreclosure, the creditors and the various parties have created 3 cases in Ventura County, 2 federal bankruptcy cases, 1 in Santa Barbara and 1 in Los Angeles County, 1 criminal case in Los Angeles, and 1 related case in Van Nuys, which has resulted in over $1 million in legal fees for the creditors that foreclosed, in addition to the foreclosure and the amount that was lost. An additional $1 million was spent in legal fees, which everyone knew was going to be the result of this case. The foreclosure was at the courthouse steps, and there were a lot of banks, Citibank, Colonial Pacific Leasing, Key Capital, Fidelity National Title, Stewart Title. Basically, a lot of parties knew of the foreclosure. Some of them chose to be here, some of them did not. But none of them offered to come in and buy the property at the $819,000 foreclosure amount. And you may ask yourself why. These are the exhibits, Brandon. So in 2008, the property is located on Rice and 101 in the city of Oxnard. There was a street improvement project. Oh, yeah. And what happened was the gas station was closed from 2011 to 2012. And even from 2006, 7, 8, and 9, there were periods of closure because of the fact that the street improvements in the area did not allow for access into the site. I have more pictures, Brandon, I'm sorry. A couple months before foreclosure, I'll give you a couple of them so you don't have to walk back and forth, sorry. This was the condition of the site. For about 2 years, a year and a half to 2 years. And at time of foreclosure, I think there's 4 different pictures there.
We'll call these applicants' exhibits. Why don't we make this whole group of photos?
I have them
labeled. You do have labeled?
A, B, C, C2, C3. Do you see that labeling on there?
I do. We'll have to use numbers, though, for the applicant.
Fine.
So, what? How many photos are being circulated?
I go all the way to R. So, what is that, like 20?
So why
Not
don't we-
pictures, all documents and stuff.
Why don't we
so-
call this, this whole group applicants exhibit 1? And
Okay.
then as we need to, we can number the pages.
Okay. So, as you can see, the condition of the property at time of foreclosure was pretty bad disrepair. It did not have, it was not a functioning gas station. It was vandalized. There were, it was broken into many times and resecured. There was no inventory. In addition to that, sorry, Brandon, I have more. We have a letter from the State Water Resource Control Board, CUPA, at that time. This is a letter from our attorneys to the trustee and the trustee's decision to abandon the property. Sorry. And one more, Brennan, sorry. While he's handing those out, you know, the bankruptcy trustee basically looked at this property as a big white elephant, as she testified to in the bankruptcy court. This property, there was no way it could be opened without a significant amount of money being spent. There was no money that she had or could get funds in order to open this gas station to operate it. Permits were expiring. State Water Resource Control Board said that the land was contaminated, and therefore they were giving notice of violations as well as initiating one more copy. Which one is that one? I have this one. Basically, State Water Resource Control Board was initiating criminal action against those parties that were in control of the property for failure to clean up or abate the existing condition. So the reason why, in terms of valuation of this property being so bad at time of foreclosure, is because nobody wanted to touch this property within a 10-foot pole. They were running away from it because of the problems.
How would the chairman like to mark the letter exhibits?
Are these already labeled?
They are. I labeled them letters. I didn't label them numbers.
So we'll just use, are the letters on the documents? I'm just looking for the actual labels. I'd say we could use the applicant's letters, just make those all under Exhibit 1. A through R, I think, is what she'd said, but I don't actually see the letters. So, unless,
okay.
Are there any on that?
I gave the letters of the set I gave you are D, E, F, and G.
Okay. Why don't we just do this? The first 4 photos we'll call Exhibit 1. Then we have, it looks like another 1, 2, 3, 4, 5 documents that were just handed out. And let's call those Exhibit 2, and we'll refer to them each by the titles within the exhibit and go from there.
We're good to go?
Go ahead.
Okay. So with the condition and the bankruptcy trustee basically abandoning the property, the creditors were able to foreclose and did foreclose and wound up basically, after spending a couple $100,000 in back property taxes, as well as fixing what needed to happen, complying with all of the CUPA requirements, State Water Resource Control Board, getting the property out of, working with them in a plan to get it out of the hazardous contamination category. We're finally able to open the property in September of 2012. I have documents here that show that the property tax is paid. I have documents here showing the trustee's deed upon sale. Should I hand those to you? I'm sorry. That's okay. No, that's okay. Thank you. It didn't end there. What wound up happening is we basically wound up dealing with a debtor that was very unscrupulous, and because they are an attorney group, they basically dragged the creditor through years and years and years of litigation that we still have not resolved. They've asked to have the foreclosure set aside and open up a case in bankruptcy appeals all the way up to the Supreme Court. Or we have another bankruptcy case when they couldn't get their way under the entity. They opened up a case under themselves personally and dragged the property in personally. They did a lot of things in addition to catching the attention of the Los Angeles District Attorney's Office, who wound up going after the head person of this group and filing charges against them. And I have the counts by the LA District Attorney to show they defrauded paperwork to the court, they defrauded their clients, they wound up getting disbarred after much work on our part. To make a long story short, it's been a long battle. Now, we add this to the value because anyone going into this property would have known that some legal issues were going to happen, and that's what made it unattractive for anyone to approach it. Once Green Energy approached the property and basically started going along, it became a rabbit hole. At what point do you just basically walk away and cut your losses? However, we're still on the path. Brendan, I have some more documents for you.
Mr. Chairman, how would you like to mark the additional letters?
The last two that we received, which were the trustee's deed and the County of Ventura document, we'll call applicant's exhibit 3, and then this next group we'll call number 4.
There's one more you want to add to number 4. I'm sorry, Brandon, to make you work so hard.
I have 5 copies of these. Did you keep your copy?
Yes, I kept mine. I must have shorted one of the assessor's office packets from before.
Sorry. I think myself confused.
What number is this one?
This is 4, which includes the Superior Court document, the U.S. Bankruptcy Court document, and another USC Bankruptcy Court document. And then another one coming out from the Water Board. Number 4. Yep.
So what you have is you have the contaminated documents, you have the back taxes, the CUPA non-compliant, the abandonment by the trustee, the property taxes for the remainder of the years. And then when Green Energy got the property back, it was significantly affected. The existing site plan I have here, the property was actually even with the street on Rice Avenue, Santa Clara Avenue, and also Auto Center Drive. After the city did their street improvement, they raised the street 7.5 feet on one side and 3.5 feet on the other, which, because of the tanks being where they are, there is a 24% grade coming into the property, which is absolutely, no one would get permits for this except for the city.
Number 5. One page, number 5.
So if you look at the property, and this is the existing, there is a one-way entrance which is about 7.5 feet lower than the intersection. At a double-digit grade, trucks basically bottom out when they come in. So this was a truck stop, which can no longer be a truck stop after the street improvement. So when we got it back to open and operate it, we realized, there's bigger problems. It didn't just stop with, the foreclosure and all the agency satisfaction. When there's only one exit, which most of the time has a line going out, and that exit has a 3.5-foot ingress difference, which also limits trucks, transport vehicles, and this being, somewhat of a truck stop, it has high-flow diesel pumps meant for trucks, is hampered by the fact of in and out. So that has affected the volume as well as the customer base. In addition, the city took away the signs, and the signs they took away, now the property line to the street is different, so the city owns the land to where you would put a sign now. So we're in negotiation with them to try to figure out where we would put a sign, but right now we're approved for a 40-foot pole sign, but we have no place to put it. And if we do expense that, it'll be about $150,000 expense to put the pole sign. So right now we are operating with no signs for 3 years, for 2.5 years. As a result of the street improvements in that area. In addition to, this property has only one drainage in the multiple parking spaces in the center. And originally, this property was even with the street level. So if we have any type of significant rain, which is coming, although we're in a drought, we're probably the only people that are happy that we're in a drought, because if we get any type of rain, we're going to be flooded out. Because with the street being higher, the water can no longer drain out the driveway the way it was supposed to. It is now going to flood, and we will be down because it won't drain fast enough. And our business will be underwater. So with that issue, and as litigation continues, really, Green Energy Holdings should have never foreclosed and never gotten this property, because we feel that it's an upside down value. More so, when our original application said, what is it that you think our value is? And we put down 0, we should have put down negative $2 million, because that's where we will be by the time this is all done. Although I understand that you have to assess something, and the trustee's deed upon sale says $819,000. At a minimum, we're asking the assessor's office to just leave the $819,000 value and don't assess it higher, and we won't make an issue of going backwards on that value. What I will say is that we are working with the city of Oxnard and trying to come to some conclusion on how to fix the site. And I think the conclusion we've got to, after much spending, much expenses with Penfield and Smith, the city of Oxnard's engineers, as well as working with the city planner's office, that what's going to happen is this site is going to have to be knocked down, filled 8 feet, and rebuilt. This is the proposed site plan of the new development on how we plan to do it, as well as estimates by B&T service station contractors on how much it would cost, at least in the fixed values, to rebuild this gas station, not including equipment. So this is just fixed asset improvement.
Call this number 6.
With this new proposed site plan, the city is willing to give us an in and out on Rice Avenue, which originally they restricted the in and out to just an in. And when they give us an in and an out, that should help our volume, as well as allow bigger trucks that originally were customers of the gas station many years ago. Thanks. To be able to get in and out without restriction. Other than that, if you have any questions, off the top of my head, I can't think of anything else that can stress the fact that, I mean, at a minimum, $819,000 should be the value.
Okay, thank you.
Okay? Thank you.
Let's go to questions from the assessor to the applicant from that presentation.
Is it Ms. Fatah?
Yeah, Michelle Fateh, yes.
Fateh.
Yes.
You were talking about the contamination in the land.
Yes.
Has that been remediated?
There was a closure letter issued January 1 of 2014.
And how long had the ground been contaminated?
Well, my understanding is that it had been contaminated for a couple years. However, the way they found out is Joe's Texaco gas station, which is across the street, was negotiating with the city of Oxnard for an eminent domain value. They could not agree to anything. So the city of Oxnard decided to do a phase 1 and found that gas station was contaminated. Because it was down gradient from the gas station that we're talking about today, the underground contamination leaked from that gas station all the way under the gas station across the street, which is the subject property. The State Water Resource Control Board left that file in the Ventura District Office in order to work with the debtor to get the property cleaned up because they could not access it without their permission. They could not get any response through the Ventura District Office, so they transferred the file to the LA District, which had the authority to work with the District Attorney's Office and initiate charges against the party not cooperating. So for enforcement, they transferred it to the LA area. After transfer to the LA area, by the time it got to the LA area, the property was in the possession of the bankruptcy trustee. So it had been, I'm estimating, maybe we had it in 2012 to 2014. That's 2 years. So maybe a year or two before then, but that's just a guesstimate.
Okay, so it was basically considered clean about a year and a half after your ownership.
Because we worked with them to get it permission to go ahead and do what needed to be done, yes.
And how much did you spend to get it clean?
The State Water Resource Control Board, well, let me back up. Because there's ongoing litigation, I cannot disclose what conversations happened between us and the State Water Resource Control Board. However, what I can say is even up until this moment, at any moment, I could get a bill in the mail.
And with this cleanup, though, typically when an owner of gas station pays to have this remediation done, they submit all their bills to the state and they reimburse them almost 100%. Is that correct?
The previous ownership had a right to go back to the state of California under the state fund and collect out of the account. However, new owners are not entitled to that because you're only protected if you are the tank owner at the time of the spill.
But the prior owner is still responsible for the cleanup.
No. The new owner, let me back up. That's where you get into gray area, which I need to be careful about because of the current litigation. But what I will tell you is that at this moment in time, Green Energy Holding could still be liable for that potential cleanup if questions are asked.
Okay. Are you familiar with Revenue and Taxation Code Section 75.10?
I don't have it memorized. Can you let me know what it is?
Okay. Basically, it says that when there's a change of ownership, the assessor is required to assess all property at full cash value. and fair market value. Revenue and Taxation Code Section 110 and Property Tax Rule 2 define full cash value as an open market transaction between willing buyers and sellers, arm's length, etc. Do you have any evidence as to what the full cash value of the property was at the time of the change of ownership? In the form of an appraisal or in the form of any market evidence?
I was not asked to bring any market evidence, nor was I asked to bring any of that information. What I do have in terms of assessing value is this trustee's deed upon sale, which was $819,000, in addition to the documents provided today to support a value of that or less.
I have no further questions.
Okay, thank you. Any questions from the board to the applicant?
Did the city of Oxnard compensate you for any of the street widening in the period of time that you were out of business?
They weren't, we weren't the owners at the time. They worked out a deal where they did not compensate the previous ownership. What they did is worked out an ingress-egress agreement, which basically said for a 3-year period they're allowed X amount of ins and outs to the property. And for that period of time, they were entitled to X amount of dollars. And in the end, I don't know what the payment was to them, but it did not involve a payment. However, what I will say is Green Energy Holding on Thursday, July 29th, has sued the city of Oxnard as a result of inverse condemnation relating to this property and its current condition.
I'd like one more question. The gas station is currently in operation, though, is it not?
It is in operation. But we're here talking about the land value of Green Energy Holdings, not the gas station itself.
Clarification, is that correct that it's only land value that we're talking about? Because I see on the...
No, we have land improvements and personal property and fixtures.
Okay, so we haven't gotten
we
to your
are required
part
to
yet.
value the entire appraisal unit.
I understand. Okay. Any other questions from the board right now to the applicant? Go ahead.
Would you happen to know of any other gas stations in the area that had sold during the foreclosure period that you could take that value and then subtract all of the costs incurred from that to adjust it?
When a gas station is contaminated and the loans are not performing, you're not going to find any gas station bought and sold as contaminated because of the exact issue that we faced, which was you can't collect from the fund if you're a new owner. And so unless there's a huge multitude of agreements, there's even banks that say we can't even foreclose and take possession because we have bylaws that say if it's contaminated, we don't want to be ownership of it. So I don't know of any gas station that was contaminated where we could get comps to compare that in the area, and I am a licensed real estate broker.
Thank you.
Okay. Any other questions from the board? I don't have any right now, but I might in a few minutes. So let's go ahead with the assessor's presentation.
Under Property Tax Rule 321, the applicant, when they have the burden of proof, are required to present independent evidence as to the full value of the property. Ms. Fateh has not provided any evidence as to what the value of the property is. We feel that the burden of proof has not been met, so the board must decide under 313C whether or not the burden has been met prior to the assessor presenting any information.
Okay, thank you. Okay, any discussion from the board related to the assessor's request?
What is the total value on it at this point?
Is it 9?
I have, the application says
960.
960-200.
That's correct. We have 375 on the land, 280 on the improvements, 31,600 on personal property, and 273,600 on trade fixtures. The personal property and trade fixtures were taken directly off of the applicant's business property statement and given a reduction for depreciation.
Thank you.
In terms of our decision, it seemed, obviously there's
May
a
I
lot of
rebut?
information.
I'm sorry. Did I get a chance to rebut before you make your decision?
If you have any new information, sure, go ahead.
Oh, yeah, sure. So,
We're just, well, yes, the answer is yes.
okay, sorry about that. So regarding paperwork to provide full value of the property, there is none. There's nothing I can compare this to. The documents I've given you with the case of all the things that happened to the property, forget the legal stuff aside, but the contamination, the expiration of the permits to operate, being under curtilage of the bankruptcy trustee, and what that allowed, there's really nothing to compare, to give you comparative value. And like I said before, I'm a broker. If I had it, I'd show you right then and there, hey, this is the comparative value. Number two is, I have an email from the Scott Combs, Ventura County Assessor. Says, hi, Michelle. I discussed your case with my supervisor. We understand the complexity of it. He's willing to meet you halfway between the assessed value of $960,000 and the $819,000 foreclosed amount, which would be a reduction to $889,000. Please let me know if this works for you. If so, I will send over paperwork as soon as possible, and we can put this to rest. Our hearing is scheduled for 3/9/15. So they understand it, and I'm willing to provide this email, and I have copies. I don't know if you want it. Sorry, Brandon. But they even reduced their $960,000 value to $889,000 value. And all I'm asking is to go down to the $819,000, which is the foreclosure amount. But they know themselves that it's overvalued at this point.
And redirect.
Okay. Oh, right. Okay. Sorry. Wait, hold on one second, Mr. Meyer. I'll make sure you can get your info out.
Exhibit 7.
So I think, and Ms. Little, you're welcome to ask a question, but I think there's a question about whether this passed to offer something that the assessor is willing to still extend.
We often provide opportunities to get these applications stipulated. In this case, she refused to accept the stipulation, therefore it is off the table.
Okay.
We're defending our roll value. We've also done other research. We believe we actually went low on our original value.
Okay.
And as far as her saying that there is no value there and there's no way to determine what the value is, there are appraisers that do specialize in gas stations. So she could have hired an appraiser to come out and determine what the value of the property is.
Okay, thank you. So to the board, we need to make a decision about whether to move forward here in the assessor's case or to, I guess, alternatively accept the assessor's request to
Opinion of value.
To sustain their position due to lack of production of evidence. So any comments on that? I think what I was saying before was that obviously there's been a lot of information presented, not specifically to a value other than, I guess, a value of 0 or negative has been presented. So any comments on that?
No, this is a tough one.
Okay.
But
oh, my comment would be, I guess it wouldn't probably wouldn't hurt us to hear the assessor's presentation and get all the information and make a decision. It would probably I'd probably lean a little bit that way.
Okay. And we'll mark this as 7.
Sure.
So, Mr. Stern, are you saying that the burden of proof has been met?
Actually, it's the burden of production at this point.
Has the burden of production been met?
I believe there's a consensus of the board that the information presented is substantial enough for us to continue and hear the assessor's presentation. So let's go ahead and do that.
Question to the chair. Should we mark the last email that the applicant submitted as exhibit number 7?
Yes. Thank you.
You were talking about the evidence, but under 313C, only in the event that the burden of production has been met can the board require the assessor to present. So I ask again, has the burden of production been met?
I believe that our consensus is, in a short answer, yes, there's enough information that's been presented to proceed.
Question from the chair to the chair. There was the State Board of Equalization letter that the assessor's office had previously submitted. I see that the assessor has marked their exhibits, Exhibit A and B. Should we mark that letter as Exhibit C?
Yeah, let's do that. Thank you. So at the beginning of the hearing, the assessor did provide that letter, so we'll call that Assessor's Exhibit C, and go ahead with these as A and B. Mr. Vlahakis, I have a quick question for you.
They included that letter again in the presentation.
Oh.
Which one? That's
No, this
A. A and B are the two that we just received, and what we received at the very beginning was a letter from the State Board of Equalization, which we will call C.
I'm sorry, the letter is letter.
Pardon?
The letter is, this one is which one?
C.
C, okay, thank you.
I'm not going to bore you with all the particulars.
Okay.
If we could turn to Exhibit A, page 9. This is a valuation field form that we use to determine what the value of improvements are. So we used Marshall & Swift Valuation Services, made a determination as to what kind of each of the improvements were on the property, did a depreciation of roughly 28% on the C-store, 53% on the canopy, and 53% on the car wash, and ended up with a cost approach value of about $280,000. On page 10 is our land valuation, where we found vacant land, did a few adjustments, and came up with an overall value conclusion of about $12 a square foot on the land. Page 11 is an aerial of the subject property. Pages 12 and 13 are the land comps aerials. With comp number 3, the aerial was taken after improvements were placed on the vacant land, so originally it had been vacant when we did the when we were using it as the sale. And on page 14, we have our allocation of land at $375,000, business property, $320,000, and buildings at $280,000 with a total of $975,000. Page 15 is the property statement that was supplied by the applicant. And as you can see, personal property and fixtures came out to a total of about $320,000. We did not include the Mini-Mart store equipment and fixtures, but we did include the gas station pumps at the $233,700 and the $48,000 on the car wash equipment. And I'd like to skip over to page 18, where we have comparable sales. More often than not, the gas stations tend to sell in the marketplace at a per square foot ratio, either based on the land square footage or of the improvement square footage. Unadjusted, looking at the dollar per square foot based on the improvements and based on the land itself, in all cases, the value of the subject property would be substantially more than what we actually did enroll. And the most important sale to me is comp number 2. It's sold for $1,635,000. It's been contaminated since 1988 and is still undergoing remediation. And on page 19 is proof of that contamination, showing that the status is open. And the State Water Resource Board is still working on the remediation of this property. So the comment that contaminated property does not sell, contaminated gas stations sell all the time. As a matter of fact, when I used to work gas stations, when I drive by a gas station, I think right away it's contaminated. Most of these other comparables, if you look in the remarks, shows that most of these were remediated relatively recently, 2009, 2010, 2005. The oldest remediation completion was comp number 6, which was completed in 1997. And that's basically the assessor's evidence. We request that you sustain our value.
Okay, thank you. Any questions? Whoops. Turned off my mic. Are there any questions from the applicant to the assessor based on that presentation?
Yes, I do. Okay, so going to, I'm sorry I'm proceeding slowly, but I'm sure that I wish I had this paperwork beforehand so that I could really come one by one real fast and give you questions and give the assessor questions. So I'm going to beg for patience as I go through this on the spot and actually ask the questions that I think are relevant to your taking this information under consideration. So I apologize in advance. So on page 9, we started with the building value. If I'm understanding this correctly, page 8 is you input into this software the information on what the existing building has, correct?
It's basically just information as to the change of ownership,
Okay.
basic details of the property. It's for our internal use primarily.
Okay, so in this, then page 9 is the assessed value of the C-store, the canopy, and the car wash.
Yes.
Okay, so in the convenience store, is there any adjustment value for repairs that have to be made? For example, if the, drywall and stucco is cracked and has to be replaced, or the driveway repair had to be done, or different items like that are on this, or no?
Based on a site inspection, we determined that there was about 28% depreciation on the building. We had asked you for cost to cure, and you did not provide it to us.
we had a lot of conversations on what needed to be done. But I remember specifically having a conversation with the gentleman that visited the site. I gave him a 2.5-hour tour of all the problems that were with the site, and I pointed out the flooding issue, I pointed out the driveway issue, I pointed out foundation issue, I pointed out wiring that was cut between the car wash and the canopy. I went for 2.5 hours around the property with him and gave him specific details, but I don't know any of those informations in this valuation field form.
He made a determination that there is 28% depreciation. Other than that, there's no other adjustments.
Okay. So I'm not sure how to adjust the valuation field form based upon those items. In terms of the land value, I don't really know how to read this form, but I don't note that anything on this form gives an adjustment for contamination. And in the assessed value, if I'm reading it correctly, sale date 8/1/12, and they have a nominal sale price of $375,000. I don't know, they're comparing it to a property 3/9/12, 9/15/11, and 8/26/11. That my understanding is that the subject property, there's no adjustment for contamination on the left-hand column, and I don't know these sale 1, sale 2, and sale 3 if they have that comparison in there.
In the typical marketplace, especially with gas stations, and well, with the typical marketplace, we make an assumption that sales go on between knowledgeable buyers and sellers. With gas station properties, the typical buyer and seller are people that own and operate gas stations. Contamination in a gas station situation, when people buy and sell these items, know that there is contamination on the property prior to their purchase. They take that into consideration with their sales prices. And they also are aware that the state fund does reimburse those monies. If you look at Exhibit B, which we didn't really go over, it shows all of the remediation work that was done on this property since 2005, and the fact that the state reimbursed almost all of it. On the very first reimbursement, they did not reimburse the full amount, but on all subsequent reimbursements, they reimbursed almost the entire amount for the remediation purposes. Knowledgeable buyers and sellers in the gas station market are aware of how this works. Therefore, no adjustment for contamination is made.
Well, there's something that the assessor's office is leaving out. Number one, try getting a loan on a contaminated piece of property.
Ms. Fattah, let's just, I want to remind you that this is a time to ask questions of the assessor's presentation. So.
Yeah, asking the question is the property being contaminated and trying to get a loan. Do you have any information on whether properties that are contaminated can get loans and that those have to be mostly cash transactions?
In the case of most gas stations, once they're on the contamination websites and the remediation is going on, gas station owners typically can finance under those situations.
If there's an agreement between the buyer and the seller that the state fund agrees under the previous ownership to reimburse the cleanup fund under the program provided by the previous ownership. In this situation, you don't have the same. You have hotly contested parties that never would have gotten to an agreement in order to seek reimbursement. They were doing everything that they could to not agree. So there would never have been an agreement, which means anyone purchasing this particular property would not have been entitled to state fund reimbursement at foreclosure, at time of foreclosure. So whatever they had done or didn't do until the time that is issued foreclosure is the responsibility of the new property owner, unless the old property owner says it's okay, which would not have been possible in this situation. So given that you're bringing these comps in, are there any comps where the state fund, what happens on a sale? Do you have any comps that provide if the state fund would not have been able to cover this cleanup, what are those comps that are in your package of information that you provided to the board?
We have one comp that is contaminated. I can't say that we have any comps that there's not provisions for the state fund to reimburse them. However, in Exhibit B, if you take a look at the disbursements by the state,
What page?
let's look at Exhibit B, page 30. There are reimbursements here that are being made by the state after your purchase.
They weren't made to Green Energy Holdings. What happened is there was the State Water Resource Control Board set up a ghost claimant, and therefore the ghost claimant processed the funds on behalf of the property owner at the time of leakage as a requirement of the previous property owner, or they were going to throw the previous property owner in jail. So that was an agreement. So it's a ghost beneficiary that was set up that as long as the previous owner agreed, they would have provided those payments to the Reynolds Group, which was the company that was assigned by the State Water Resource Control Board to clean up. However, after 8/1 of 12, there is still question who pays for the cleanup because now there's new ownership. And so your comps don't put that into consideration. You have to understand the backstory.
The only evidence that I do have is the fact that the state did make reimbursements. I think I've answered your question.
Okay. Where does it say that Green Energy Holding received reimbursements on
It doesn't.
this one?
It's actually, however, in one of your documents, you signed it as being, what's the name of it? As one of the executives of Gazprom, Inc.
No.
On one of your papers in your evidence, you did sign it as Gazprom, Inc., and that's who's getting these reimbursements.
No,
that was the previous owner, and
I'm going to step in for a second. Thank you.
I know what document he's talking about. Can I refer to that? Can I answer his question so he doesn't assume that I did something I should know?
Well, let me just finish really quickly.
Okay.
If you have more info, you can provide it. I think we have definitely the clear position of each side on this issue, and the question's been asked a couple of times, so I don't think the two sides are going to agree, and we do have the information to consider. If there's information that we don't have, Ms. Frate, on this specific thing, you can present it. Otherwise, let's go to another question.
Okay. So in generalities to the information that was provided, there's the question I have regarding the documents that are provided here is, do you have a comp of a property that was contaminated in which the State Water Resource Control Board indemnified the new party or did not indemnify the new party in terms of the cleanup, as well as the property being in bankruptcy, as well as the permits to operate being in a suspension mode? Do you have any comps as to those types of properties?
Trying to find a comp like that would be near impossible. The answer is no.
Okay, both of us are in the same position. I don't know what else I can offer you as evidence or rebuttal on the evidence they provided, but I feel that in this matter, they put a burden on me to provide evidence that in the end they couldn't provide themselves.
Okay, thank you. So we'll go next to questions of the assessor from the board.
If you can help me on your Exhibit B, page 35, there's a letter from the California Water Boards dated January 17th, 2014. The second paragraph down, talking about the underground storage tanks, site is in compliance with the requirements of subdivision A and B. Am I reading that correctly? That as of 2014, it was in compliance?
Absolutely. And we brought that up when I was asking your contamination questions.
Okay. Okay.
May I address that?
Let's first just see if there are. Well, yeah, go ahead.
Okay, the question is the value at August 1 of 2012. And that's the foreclosure date. The only reason why it was brought into compliance January 17 of 2014, which is a closure letter issued, is because the cooperation of Green Energy Holdings with the State Water Resource Control Board. So they had to address Gazprom in this letter, but technically it was a rite of passage of the effort of Green Energy Holdings, but it really, the closure letter doesn't affect the value that's being argued on August 1 of 2012. It's what is the value August 1 of 2012? But yes, there is a closure in a letter in place. This is basically the closure letter, January 1 of 2014.
Okay, good.
Thank you.
And in response to that, basically, the remediation began in 2005 when Ms. Fateh took ownership of the property. Remediation was very close.
Okay, thank you.
Thank you.
And let's see. Ms. Little, did you have any other questions?
No other.
Okay. Mr. Crow? Okay, I do not have any questions right now, so let's go next to closing summaries. We'll start with the assessor and finish with the applicant.
The assessor feels that the applicant did not actually provide the burden of proof and that they provided no information or evidence as to what the full cash value of the property was. Therefore, under Revenue and Taxation Code Section 501, the assessor is required to assess all property based on evidence before them. We basically valued the property based on the evidence that we had in our possession at that time, and we feel that that valuation should be sustained.
Okay, thank you. So we'll close the hearing to public testimony.
Oh,
that wouldn't have been very nice. Sorry, let's go next with the closing summary from the applicant.
For fear of being redundant, I'll make it quick and just basically say that although we're in a position where everyone, whether the proof is on my end or not, the assessor's office couldn't provide information on property that was similar to our property and the situation it was in and the complexities it was in because it doesn't exist. Otherwise, I would have brought it myself to show value. We're not asking for much. The value is high. We want it to at least the foreclosure amount. It's not much difference than to where it is, but there's significance internally that would, put $819,000 as the value, even though it's probably less than that. And in terms of, we could go page by page on the information to compare what these comps and what was not included in a very standard software that spits out data. But I think that would be over redundant. And at this moment in time, we submit to the board to make the best decision they can under the circumstances.
Okay, thank you. Now we'll close the hearing to public testimony. In terms of deliberation, the board could either deliberate right now, or in the interest of time, we could hear the next cases and then deliberate maybe at the end, just in order to make sure that we get everything done that we need to do.
It would be best to try and get all the applicants heard if it
Right.
could be achieved today.
Okay, so then what we'll do is deliberate at hopefully today, at a later time, probably in closed session, and then a minute order will go out, or you can check in with the clerk, Ms. Fateh, in terms of the status. Thank you for your information. Thank you to our assessors representatives.
Thank you for your time.
Okay, thank you. Okay, I did want to clarify just with our clerk that with our next two, and with the assessor's office, that with our remaining two, that whatever representatives might be associated with their cases will be available, assuming that we can get through these in the near future. So obviously people are here for this one, and then there's one other, which is item 217. So I want to make sure that whatever assessor staff necessary is available, when we get to that one, which hopefully will be soon.
We're good.
So it's the same group?
No, it's Rick Denham, Ventura County Assessor's Office.
But for the next one?
And for the next one.
Oh,
I was the lucky winner.
Okay, great.
And
Okay, I just want to make sure we don't
and I will
abandon someone.
stay as long as needed.
Okay, well, I appreciate that. Thank you.
Maybe I get
Careful
thrown
of
out.
what you say. Okay, so next let's go to item 93.
Sorry, board, I want to clarify on that last one. So is the board, for Green Energy Holdings, is the board taking that under submission and going to make a decision off the record, or are they going to, which is what I would recommend, or is the board going to come back and make a decision on that on the record
You
today?
mean announce their decision on the record?
They will announce the decision on the record? Okay, thank you.
No, I was asking you. You said
Oh,
to-
that's what I'm trying to
Is that what you
clarify. The board can take it under submission and announce their decision through the clerk off the record and not have to come back. And so if the board would like to take item 13 under submission, that's what I would recommend. That way we can send all our media people home and stuff once the board's done. But I just wanted to clarify that if the board was going to come back on the record for item 13 or not.
I suppose we could make a decision off the record and then relay that to the clerk afterward.
Perfect. All right, thank you.
Okay, great. So item 93, application 1410568. Applicant is Alan Avakian. Thank you for your patience.
Thank you. I'm Alan Avakian. I'm here to appeal the property base year value on my home.
Okay, hold on one second. No, I don't think
This one
so.
was amended earlier. The board should.
Do we have it?
might be
Yes.
buried somewhere.
Maybe
The
we-
board should-
It's a single page. Just a single page.
Well, I'm going to borrow
can
Ms.
share it.
Little's, if it's okay, in the interest of time. Or if, okay, so we do have copies. It looks like we have a single-family residence, owner occupied, and this is a Prop 8 decline in value. And so let's ask first if our assessors representatives could give a brief overview, and we'll go from there.
This was an amended application to base year.
Oh, you're right, thank you. So amended to base year value.
Rick Denham, Ventura County Assessor's Office. This is indeed a single-family residence, and with the amendment this morning, it's for a base year as of December 6, 2013. The subject property was purchased for $470,000. Was purchased from the MLS, meaning there was a broker that listed the property. There was a negotiated sales price, and that negotiated sales price ended up being $470,000. Upon receiving that information and running comparable sales, the assessor's office enrolled $470,000, which is common practice. It's under Rule 2. And Rule 2 sort of, I'm going to not say it verbatim, but the summation is that when we receive a sales price from a fair market sale, absence of any major factors, we are to enroll that sales price. And in this case, that's exactly what we did.
Okay, thank you, Mr. Denham.
Thank you.
So I believe based on the situation that the burden of proof is with the assessor, is that correct?
That's an interesting subject, but the quick answer is yes, but once we establish the burden of proof, it actually shifts. It's an unusual situation. So
Because he's trying to overcome the purchase price. So the burden shifts to him once we verify that we accepted the sales price.
Exactly, and why we verified it. So very unusual.
But we're willing to do our entire presentation first.
Yes.
Okay, so then we'll start with the assessor's presentation. The applicant can ask questions as well as the board, and then we'll go to the applicant's presentation. So go ahead, Mr. Denham, whenever you're ready.
Thank you. I will. Did everyone get a copy of my work? Good. Sir? Sir?
Yes, I have.
Yeah, we're going to go to this page. I
I
just
see
wanted
it.
to. They're familiar with my work, but I don't want to lose you.
Okay.
Good. Okay. The assessor's office utilized 3 comparable sales from the subject area. All 3 sales are from the subject neighborhood. The first comp is actually a direct model match. Comps 2 and 3 are slightly larger, but they're all 3-bedroom, 2-bath homes from the Moore Park area where the subject sits. They were obviously adjusted for size mostly and some miscellaneous improvements. The final values on the bottom was $454,000, $451,000, and $467,000. On the top line, raw sale prices, they were $450,000, $460,000, and $500,000. Under Rule 2, when we are dealing with sales price, there is a 5% deviation allowed, meaning we could be as much as 5% higher than any of our comps or 5% lower. And this is, of course, to account for market tendencies. In California, very much needed, because when an area, for instance, is appreciating rapidly, sometimes it's very hard to keep up with the sale price, and you won't find a model that, like, one will sell for $450 and the next one will sell for $500 or something like that. So that deviation is allowed, and under those circumstances, that's how this appraisal was produced. And under that criteria, both by raw sale price and by adjusted values, we meet the burden of proof. And within those number sequences is $470,000. And yes, we did accept the exact sale price, which basically is our duty. So that's what we did. The next page, sir, is a picture of where all the comparable sales are. They are all within, as you can see, the same track, and they are attached to open space areas, and that's what you see in front of you. Further back in the report is a copy of the MLS listing showing where one of the places that we develop the sales price, besides private information, which comes through what we call the PCOR, the property report that all taxpayers have to fill out when they purchase a property. And so this re-verifies why we did what we did. And that is basically our presentation, and that's why we evaluated the property at $470,000, and we will ask you to sustain that value. Thank you.
Okay, thanks, Mr. Denham. Let's go now to the applicant with any questions of the presentation made by the assessor.
I don't have any questions.
Okay. Any questions from the board to the assessor? Okay. I just have one. In terms of location of the specific location of the subject versus the 3 comps, any positive, negative adjustments, Mr. Denham, related to
we didn't see in the marketplace. I know some are near the open space and some aren't, but we didn't see anything in the market that caused those properties to go up or down.
Okay. Okay, thank you. So any other questions for the assessor? Okay. So we'll go to the applicant's presentation.
I have some documents here, perhaps Mr. Velakis.
Great.
Pass these out.
So the clerk will need one for the official record.
There's no findings, are there? I don't need a copy if there's no findings.
Okay, the first page I have there is the comps, which was included in my application, which showed other homes in the area sold for less than my property did. And the one property in particular on Sites, which is the same floor plan as mine, had a lot more upgrades, improved ceramic tile in the kitchen and wood floors. And then I have some photographs that I've included. They're the same photographs that the assessor's office presented, some of them. The picture number 1 and picture number 5 shows water damage that was to the exterior of the house. And the second photograph shows the kitchen, which is the old-style ceramic tile, old vertical blinds that were in the living room. Going on to the third photograph shows the bathroom, which is a fiberglass shower. The fourth photograph shows just builder-grade countertop in the bathroom. That sixth photograph shows the exterior patio where the cement slab is separating away from the foundation of the house. And the brickwork that's in between those slabs is sinking. And also when I took possession of the house, the seller had turned off the main water line, so I couldn't tell that a lot of the plumbing was not functional. And the last photograph I have is in the garage where there's 5 light fixtures which don't meet the code requirements because of the electrical connections. So there was a lot of fixer-uppers that was associated with the property.
Okay. Is there any other information you'd like to present?
That's everything.
Okay. And Mr. Avakian, do you have an opinion of the value of the home? I just wanted to clarify that.
My application, I put $430,000, but I would accept $450,000.
Okay. Okay, thank you. We'll start with the assessor. Any questions for the applicant?
Thank you, Mr. Chairman. Rick Denham from Ventura County Assessor's Office. Did you pay $470,000 when you bought the property?
Yes, I did.
Why didn't you pay less? Why didn't you pay $450,000?
My realtor advised me to pay more than the asking price.
Did you have the property inspected prior to purchasing it?
Yes, I did, but the inspector overlooked a lot of things.
I see. Did you pay cash for this, or was there a lender?
I paid cash.
You did pay cash. Okay. And did you look at other properties at the time you purchased this, or did you just look at one property with your realtor?
I was from Central California, and I had looked at other properties online, but this was I had that day that I looked at this property on Sosna Court, I was scheduled to see 3 other houses. I only viewed this house.
I see. Okay.
Why did you not go to the other homes that you were scheduled to look at?
Based on they were in another city, and so based on my, going through this first house, I liked that location.
So you decided just to not go to the other homes?
I decided to not go to the other homes and made an offer on this house.
Have you purchased other homes before this home?
Yes, I've purchased 2 other homes before this, so I'm familiar with inspecting houses.
All right,
and
thank you.
making offers.
Thank you.
Mm-hmm.
Okay. Any questions from the board to the applicant?
Go right ahead.
You say your broker recommended you put an offer on this. Was there any specific language that buy it now or it'll go away or something to that effect?
I made an offer immediately after I previewed the house. We went to the Starbucks, which was 5 blocks away, wrote up the offer right then and there, and it was accepted the next day by the seller.
I have a question on your pamphlet that you handed us here. On the very front, you have the house at 15333 Seats Court, and that one sold for $450, and that's also the assessor's comp number 1. My question to you is, over to the right side, you have price $401. Is that just per square foot price? Was how you adjusted for that?
Yes, that was the price per square foot based on the sale price of $450,000.
Okay. Okay, thanks.
Any other questions, Ms. Little?
No.
I had a question, but for the assessor. The applicant's comps, 2 and 3, the second and third comps at $425,000. Are you aware of those comps? I'm just curious about those versus the comps that you used.
We're aware of the comparables, yes. The situation is that under Property Tax Rule 2, there's a presumption, and Revenue Taxation Code Section 110, the presumption is that the sales price is fair market value, unless there's a preponderance of evidence to show that the value is something other than what they paid for it. Based on a preponderance of evidence, that means a deviation of more than 5%. Because of that presumption, we specifically do look for properties that will substantiate that sales price and allow us to enroll it. So we use the comps that best supported his sales price.
Okay.
I have one more question.
Go ahead.
To the applicant. Oh, go ahead.
If I could also note that both of those comparables were smaller and would require upward adjustments, and I don't know what the other characteristics of them would be, but I did note that they were both smaller than the subject property and would need to be adjusted upward.
Along those lines, I wanted to ask the applicant, the house on Stanford, is that in the same tract, or is that
No, it's in a different tract,
tract.
but the other comps that I've listed there, one is that sold for $425,000 on Braun is a larger house than mine.
Is that house on Braun same development or
Yes.
different?
Yes, just a few blocks away.
Okay. Okay. Any other questions from the board to the applicant? Okay. So then let's, it was to the applicant. So then let's next go to a closing summary from the applicant. Any final comments you'd like to make, Mr. Avakian, and then we'll end with the assessor.
All the photographs that you've been provided are when I took possession of the house. The last photograph showing the lights in the garage is how the lights were when I moved into the house. And so I think a lot of items were fixer-upper items. It was not in move-in condition. It was not really at the top of the level in terms of value.
Okay, thank you. And any closing comments from the assessor?
The assessor recognizes that this is a Rule 2 sale, and the applicant has provided comparables with their sales prices here. To overcome the burden of proof that is necessary, there must be a deviation greater than 5% of the sales price. If you look at his high comp at $450,000, 5% would bring that up to $472,500, which is within the range of what he paid. We request that you sustain our value.
Okay, thank you. So we'll close the hearing to public testimony. I think we could probably deliberate right now and come to a decision. So invite any comments.
We've got to deliberate, might as well wait till.
Oh, wait for all of them? I guess that's probably a good suggestion. Mr. Crowe suggested that we wait and deliberate on this one.
At the same time.
And so we can get the next hearing moving forward, which is fine with me. So,
Thank you.
Thank you, and we'll make a decision probably today. Okay.
Chairman, can you just clarify that you're taking this item under submission?
Yes, I think we will take this item under submission and deliberate shortly. Thank you. Okay, we'll now go to item 217. Sorry you have such a high number, but we're glad to see you. And this is application 14-12226. And I will ask one more time for the pronunciation of the applicant's name. I apologize for asking again.
No problem. I know. I understand. The Saint Rochelle.
Okay, thank you. And so let's look at the application. We have a single-family home that is not owner-occupied. Is that correct? Okay. And so we'll ask for a brief overview from the assessor.
Excuse me, Mr. Stern. Can we also get the name of the person who's assisting the applicant in her presentation?
Yes.
For the record.
Sorry, my name is Horst Hagner.
Okay, and
it shows that findings of fact were requested. Are they indeed requested?
Did the applicant get to review what findings of fact were prior to the hearing?
Did you see what they did? Yes.
No.
Huh? No, yes, you saw it. But can you repeat your question, please?
Written findings of fact. So on your application, you requested written findings of fact. That's a legal document entailing the evidence presented today and the methodology the board used to reach their decision. That would cost you $150. And that's only really necessary if you would intend to appeal today's decision to Superior Court. So if you don't think you'd go to Superior Court with the decision, you don't really need that document. But it is your ability to request it if you still want it.
No, we don't. That's okay.
Okay, so it's been stated that findings of fact are not requested. Okay, thank you. So let's go back to a brief overview from the assessor, and we'll go from there.
Rick Denham, Ventura County Assessor's Office. Thank you, Mr. Chairman. This is indeed a single-family residence in the city of Camarillo. Specifically, it's at Village at the Park. The property, this is a base year appeal for June 30th, 2014. This property was purchased by the applicant for $400,000. It was not purchased through a broker. It's sort of the opposite of the previous case. So it is not a Rule 2 case, and we had an obligation to look into the sale price. We developed a value based upon market comps at the time, and the assessor's conclusion was $550,000. And as stated by the owner, it's non-owner occupied, so they will go first and have the burden of proof.
Okay, thank you. Just a quick question: because the assessor is not going with a Rule 2 sale, even though it's non-owner occupied, wouldn't the burden be with the assessor?
It was not a Rule 2 sale. It was not listed on the open market. Therefore, it's not considered open market, and the presumption is that the sales price is fair market doesn't hold.
Okay. Any questions in terms of burden of proof from the board? Okay, so then what we'll do is start with the presentation by the applicant.
Okay. Have some materials prepared.
Excuse me, Chairman Curtis. I really believe that under Rule 321D, if the assuming the applicant has supplied all information to the assessor that was requested by the assessor in terms of the assessor performing their duties under 321D, I believe actually that presumption would be in favor of the applicant, and that the assessor should begin.
This is not an owner-occupied property.
Oh, it's not owner-occupied?
Not owner-occupied.
Oh, I'm sorry, I missed that.
However,
I withdraw that comment. It was incorrect.
And 321E also states that it is presumed to be the full cash value. Full cash value is defined as being an open market transfer. This was not open market.
I withdraw that comment.
Okay, it looks like we all have our information, so whenever you're ready, go ahead.
Okay. If I can give you a quick background on the property. The property was purchased about 2012, I believe, by my business partner as an investment property, and was as a rental property. My business partner decided in 2014 to move himself and his family back to Switzerland, his home country, and basically wanted to have a clean cut here. We offered him to manage the property for him, but he said, no, I don't want that. I'd rather have a clean table. And since it was still renter occupied, it was hard for him to put it on the open market. Also, there would have been a lot of improvement and refurbishment to be done because it was always a rental property. And he just didn't want to spend the time and didn't have the time to do that. So he offered us basically, take over this property. You can use it as an investment as well. You have already a renter. And I offer you the favorable deal for $400,000 because of his tax situation and everything. So he was okay with that. We say, okay, for this money, we take the house. And we are aware that the house is worth considerably more. We know that, and we have never argued that. On our application, it says $400,000 for the hearing, but that was because we don't know. We are not expert in taxation, so we say, customer, it's a sales price, so we put the sales price on, not what we believe is the market value. So having that said, we get a little bit shocked when we get the assessment for $550,000 because we think that's way too high on this open, even though it was an open market transaction. So first of all, on the map, it's in Village at the Park. Village at the Park is a mixed development having anything from condominiums up to 4,000 plus square foot houses. Our house is the smallest single-family house on the smallest lot in the entire development, to our knowledge. And the house was also, like I say, owner-occupied as is. It has zero upgrades to anything. So and it was bought as is, so without any warranties or anything, and but the price warranted it. As far as our information goes, we Sunrow has a California real estate broker license, so we pulled the information from the Southern California MLS, plus from the Parcel Quest and the Ventura County's tax collector's website on thing. We went through the area and printed comparables within the area, within Village at the Park, built at the same time in the same homeowners association, and mostly on the same street, and all sold between March 2014 and September 2014. And we only considered houses up to 3,200 square feet, because, like I say, ours was the smallest one, so we had to go up. We couldn't go down. We found a total of 11 properties sold in this time. And when we look at the per square foot price, our property was assessed considerably more than any property sold. I believe with the exception of one, no, not even one, not a single one was assessed higher than ours. So to a certain extent, we feel, because it was an open market, not an open market transaction, we feel a little bit punished because every real estate professional goes by the MLS system and listed and all, and we have here this properties that sold all for considerably less money. And if you want to see, you have the spreadsheets there with when and what properties sold, and the locations of those properties in relation to ours. There are only two properties next to us that sold over $300 a square foot. Both properties have been highly upgraded. They have been like tile floors and bathrooms with all stainless steel appliances. Some of them even included like refrigerator, washer, dryer, TVs. And most importantly, the one on Town Forest is even a corner property, which traditionally demands a higher price and a higher sales price, while ours is a small property in the middle and without any upgrades. As you will see later on in the pictures, it has still vinyl floors, carpet, not just plain simple appliances, really bare bones backyard and nothing special to it. Basically, as they come, basic from the builder without anything. And we feel this house has to be compared to much upgraded and much higher value houses. Then we got the next page. We have this one here. We compared 5. We took from the 11 houses, or from the 11 properties that sold within the time. We took the 5 smallest one, being all larger than ours, but most close in size to ours. So to be fair, and took a look at this one. If I look at the MLS, even today, which was now we had an up market the last year, so even today the MLS lists the median price for our house for $497,000 in a range from $450 to $540. If I go through that on the sales price and the price per square foot, a high was $313 and a low from $261 with an average of $295 a square foot, while our house after the assessment is $333 or $300. Now even with the new 2015 increased value, $338 a square foot. That's way higher than any property ever sold in this development. And we had, then it's just two properties, the information on the 2 properties that sold over $300 a square foot, showing how, there's the pictures and everything, how they have been upgraded and how much higher value they are in comparison to our place. And then a few pictures of our place, which shows the bare bones nature of the building. The problem is also our property is renter occupied, so it was very difficult to do anything. So to obtain these pictures, we had to ask our renter. He does not want us to intrude on him. The same holds true for like an adjuster, to get an adjuster there and evaluate the property. He did not want to cooperate on that, so we had to do let's say available information.
Yeah, this house you said is a minor in the bathroom, and also even bathroom is a carpet. There is no tile. The kitchen is a vinyl floor.
Or vinyl floors everywhere.
Either vinyl floor or either the carpet, including bathroom. So all is not upgraded. Most important, the old house.
This is, I'm sorry, this is. Are you 3 pages from the back of your?
2 pages.
The picture.
The 5.9. The 5.9.
The picture 5.9 says the pictures here.
That's 2 pages.
Got it. Okay.
Sorry about that.
Thank you.
Another to the property there in the picture, you can see the upgrade, and also the property entire. Because I have a real estate broker license, but I didn't practice it since my health condition. But I still can see the internal information. I go up the board to see. After 2006, there's a house gone, and there is no any house to sell. This like this square feet by lot, by the square feet living by the lot. Do not have this size on sale. That's why we only take a larger one to compare. But use larger one, we know that it's our house is by square feet is much higher. We understand that, and normally larger house is a little bit need a price better. But for this house, we are still thinking by square foot, by the house lot and size. This way too overpriced. That's why we gave you all the information. We have a 5 property compare, and they gave a 4 property. One of the property actually they didn't give it is most close June 20 sold. We bought it is June 30. It's very close, 10 days close. They didn't give it, but you can see that's why we 85 property. The totally 5 property you can see that there's average square feet, and where the property is much higher. We understand that they have to re-evaluation for the property and go to marketing price to assessment. No problem. We understand, but we cannot accept it is so high much higher than the marketing price.
We had also quite a few communications going forward with the assessor's office, and I was told, like, you cannot really use MLS as a per square foot price. It's not really reflective what the tax law says and stuff, and I understand that. And but being an engineer, I took the liberty and went through, I made a spreadsheet looking at evaluation of houses, and that's the second page from the back of the spreadsheet. Basically, I was told, well, you have land value, you have improvement values, and all that, and I understand that. So what I did, I took our tax bill on the house and took the land value and took the improvement value, and calculated each one the price per square foot, or the tax, what it comes out per square foot. And on our house now, with the newest tax information I have, it would come out $118.12 for the land and $118.71 for the improvements. And if I plug in the same numbers in all the 11 properties that have been sold in this time frame, which is applicable to ours, then either these houses are sometimes by several $100,000 under-taxed, or ours is way overpriced. I just don't see a consistency and a repeatability of the whole thing. If you look at it, if I calculate here in the spreadsheet, the calculated tax value land and tax and improvement, it comes out, the total tax value would come out, the calculated one would come out way higher than the houses are in reality. So that means our house is taxed way higher because I used it with our numbers. So I thought, okay, let's look at it in a different way, because this, because there was an off-market transaction. Then let's look at all the 11 houses sold on average, or what's their average size, land and improvement, and what's their average evaluation of on the tax on the assessor's office. So I went on the website and get all the 2015 tax values for land and property for all the other 11 properties, and basically divided the land by the average square footage. I made an average of the taxation, and I made an average of the size of the houses and divided it. And then it comes out that the average in Village at the Park comes out...
This is the last
page. On the last page, sorry.
And we just talk about the list in the last 2 pages.
Thank
you. A bit nervous, we never have a hearing.
Right, so it would come out that the average land value would be, for taxation, would be $91.40 per square foot, and the average value of improvement, $96.52, which would bring our house, if I calculated our size, to $441,796 in theory. And I understand there are is tolerance and up and down, and the certain brackets we can operate it, but I feel, however I look at the taxation of the other properties in relation to our rate per square foot, it's way out of line with anything on the market or anything ever sold, and that's really what we object to. And we have no problem, like I say, accepting a higher value, but we think in all fairness, going by about the value from the MLS system, what they say today in July of 2015 of like $295 or whatever was a square foot, or the $490,000 or $495,000 value on this house, because that's what we think would be realistic, and considering the condition and the shape of the house and all the comparables. Thank you.
Okay, thank you for the information. Is there any other info you'd like to present?
No, that's pretty much it. Thank you.
Okay. Let's go to the assessor with any questions for the applicant.
Thank you, Mr. Chairman. Rick Denham, Ventura County Assessor's Office. I'm referring to your comp sheet right here, the 11 properties.
Yeah.
Are all those 11 properties, I know they're from Village at the Park,
right,
but are they from your specific track?
Yeah. That's why we give it to the, you say all is in this area. Our track is the west, it's east side. Okay, this all belong to the same HOA. This all we surely belong to same HOA. All developed same year 2005 to 2006.
Once again, maybe I didn't make myself clear. You have a specific track. In fact, I think, I could be wrong, but there's 6 or 7 different tracks in Village at the Park. And I'm extremely familiar with that particular area. And my question was, your specific track, not Village at the Park as a whole, but in your specific track.
This one I don't know, because
you don't know.
As I said, just surround half a mile.
Okay.
All is this property in the half a mile.
It's within a half a mile, I agree. My next question, what did you say you think the value of the property is right now? Or, I'm sorry, at the time you bought it?
At the time we bought it?
Mm-hmm.
For us, we tell them without the commission, we tell this guy, we talk around 450 to 480 that time we talk.
Okay. I have a question about that. I'm using just your comps for now. If I look at the raw sale prices, the lowest comp is $540,000 of your comparable sales, and your highest comparable is $774,000, just the sold price. I'm using your file minus the subject property. Okay?
Right.
And so the range on a low goes at 540, on a high of 774. How did you come up with 449 as being a proper value?
440. The 449 was the value.
Well, the 450 to the 480 she just stated. That would be good.
Okay. The 440, but just to explain, the 449 was the value put on the house before from my former business partner. That was the tax value on before. When we purchased it. So that was also the first tax bill we got or we paid for before we got the assessment, right? And
you just tell about the price. Yes, we agree that's all the sold price surrounded in half a mile. However, as I said, entire many years, there is no same, our house is most smallest one. Most small lot and the smallest living the square feet. So that's the reason. If you ask say the 550, you can see that it's very close. It's by the per square feet. This is way too high. Even that's what we say that is should be below the 500 solid.
Are you aware mathematically? If you take all houses higher than yours, apply their price per foot on a lower house, it will always show exactly what you say. Any house, anywhere. And because I've seen it both ways. In reverse, when people were trying to get refis, cost per foot is always higher on a smaller house.
Yeah. Okay.
Okay. You're aware of that?
I'm aware of that. Okay.
Thank you.
But if I take the land, if I calculate the land, it's the same dirt it's sitting on. It doesn't matter if it's 3 houses down the road or here. It's the same HOA, the same development. As far as I know, the same builder. How can that be such a huge difference?
We only calculate the
That's
land.
what I'm questioning. I question the fairness. I don't question I question just the fairness compared to anything else in this development. That's what I have issues with, and I feel it's just not transparent. I mean, maybe I'm technically I'm an engineer, but I don't feel it's repeatable. My value, especially because normally the value is established on an open market with a broker transaction. Okay, then and usually you go by the sales price if it's somewhere in line. I know ours was out of the regular process, but we still feel that the evaluation is so far off that it's just, for us, it's just not.
But technically, right now, we're supposed to be asking you questions, but
Right.
you threw one out there
Sorry.
regarding, the land value being so far off from parcel to parcel. We do an analysis typically on an annual basis where we look at all tract homes throughout the county. And we try to make a determination as to what percent of value is attributable to the land on the tract homes.
Okay.
So we apply a percentage throughout the county as far as tract homes are concerned and apply that as an allocation each year. And then again, on the following year, we do that again. So
Right.
it's just based on a percentage of the total sales price. So it's not lot by lot, we apply that much money to it. We do mass appraisal. So we
Right.
have to come up with some
Right.
way to get this done quickly.
Right.
So we're still looking at the entire value of the property. We're just
Okay.
doing an allocation to the land based on a percentage.
Okay. But then let me ask you, why did...
Actually, it's our turn to ask you questions.
Okay, so let's,
Okay.
are there more questions?
Yes.
Okay, and then we'll have, we'll make sure
I'm sorry.
everyone has a chance.
And Mr. Denham touched on this a little bit. Are you aware of economies of scale?
Yeah, sure.
Yeah. When houses get larger, typically the costs go down. So
That's right.
the cost per square foot would be less as the house gets larger. As it
I
gets smaller,
understand
the
that.
cost per square foot would get higher.
I
So
understand
that's
that.
one explanation for what we were
That's why
going
we
at.
took only the 5 most close ones. As we found within the last 2 years, no house identical to ours has sold in the last 2 years in this development. So there is no direct comparable in our
So
opinion.
that's why, and you can start getting into that when we present our evidence.
Okay.
Okay, I want to say, Ricky, we do first of all, you ask a realtor to talk to you. We ask the realtor, this very good for this area. His name Alex. He call you, okay. He tell her opinion, and you do not recognize. You still want to compare. We give you compare. First one, we give you Zillow. You say Zillow is cannot accountable because Zillow so far by today our house value is 470. You best assessor, you said you're not accountable. Okay, we give you real estate board. You can say I make a high mark. Our house value by today, July 17, still 490 something. Today, another house, last month, because I can see the house sold. I just sold one house after 1 year. This means this year, June sometimes, okay, I cannot remember exactly the same house, exactly same house, and just different location, but the same track or similar half property still in half a mile. They sold 560, but their lot is over 5,000. The square feet is 1,650. We know that this last 1 year, the house marketing continue a little bit to go up. But for this same house, this just sold 560 after 1 year, is with a lot over 5,000 square feet, over 5,000 lot. If you say that we cannot compare, I don't know, by the unit count, I don't know how we can do. We, from our brochure, we from the hearing, we compare. That's how we, as the professional real estate, they do compare. Compare recently sold, compare the marketing the price, how many inventory, how many sold, how they market the price. But we really do not know how to assess the property. But my husband said that he put on you the tax, the last his form, he put on the calculator still not consistent. That's why he said we do not understand. That's how you calculate based on the whole is tax the assessment. That's why we still didn't understand by this by the tax by the tax assessment.
All of those properties that you show on there were assessed at fair market value because they were listed on the open market, and those are the enrolled values. That is required by the assessor to put that in there.
Okay. Are there any other questions from the assessor?
Assessor has no more questions.
Okay. Any questions from the board to the applicant?
I have none.
Okay. So we'll go next to the assessor's presentation.
Can't wait till we can do this in the computers. It'll be a lot.
All right. Okay, go ahead whenever you're ready. Oh, we'll wait till the applicants get theirs.
Thank you.
Okay.
As we are already aware, the property was sold on June 30th, 2014 at a purchase price of $400,000, direct from seller. It was not listed on the open market. Currently, it has a factored base year value of $364,642 under land, $196,346 under improvements, $560,988 total. We're recommending the $550 as the base value of the property, not as the factored value. So, go ahead 2 more pages. We have our comparables. We have a total of 4 comparables, all sold within 3 months of the subject property. All 4 comparables are larger than the subject. We did a time adjustment that was based on the price differences between comparable number 1 and comparable number 2, which are model matches that sold 4 months apart and established about $7,200 per month in increases during that period of time. By comparing comp number 1 to comp number 4, we established a square foot adjustment of approximately $149 per square foot on the improvements, and we adjusted the prices accordingly. We ended up with an overall value range of $532,700 up to $559,200, and the appraiser that worked this determined that the value of the property was $550,000.
Okay, any other information?
No more information other than the fact that there was a preponderance of evidence to support that the sales price was not equal to fair market value.
Okay, thank you. We'll just take 1 second and make sure that the board is able to see everything that's here. Okay. So next we'll go to any questions that the applicant has of the assessor based on the information they just presented. So go ahead if you have any questions for the assessor.
No, I don't have a question. The other is
This
the
basically
full house is the same as what we have put on comparable on the marketing. The property comparable is based on assessment. We comparable is marketing. And
Okay, let me just interrupt you just for 1 second. We'll have time at the end for you to summarize all of your thoughts. If there are any questions that you have for the assessor right now, this would be the time.
No question.
Okay. Any questions from the board to the assessor?
The applicant made reference that their house is not highly upgraded. Any of the comparables have any notations that they were highly upgraded or anything unique?
We had no indication of that. All of these homes are approximately 10 years old, so they're all relatively new. But we have no indication of high upgrades in any of them.
Okay, thank you.
One quick question from me. I noticed that all 4 comps are larger, so they require downward adjustments for size. Mr. Denham, were you able to find any comps that were the same, like model matches?
No, they correctly stated there wasn't a sale, I think, a year or two, something like that, before, and there's only been one since. Okay. But both are out of time, so they're not relevant.
Mr. Crowe, you have any questions?
Yeah, on your adjustments, the total net adjustments on sale 1 and 2 are considerably less than the adjustments on the other 2 comps, which would kind of imply, that more support for those a little less value than the 550.
I'm sorry, could you please repeat that?
Well, as I say, if you look at your net adjustment, you're adjusting sale number 1 for $26,000, come with a value of $543, and you're adjusting sale number 2 with a downward $4,300, which indicates a value of $535,700.
That's because we did a time adjustment also.
Yeah.
And the time adjustment, the comp number 2 sold 2 months prior to the subject, and comp number 1 sold 1 month after the subject, about 32 days. So we did a 2-month adjustment on comp number 2 and a 1-month adjustment on comp number 1.
Further, comp number 1, it's kind of confusing because of assessor law, but that's actually a negative positive adjustment. That's a negative time adjustment because it sold after the subject, so you have to take $7,200 off of it.
We have the 4 property from that is same. 1 property is still sold June 20. They didn't put on. Very close. That's why it's almost same. You can see our comparable property. We have the 5 property to compare to.
Okay. Mm-hmm. Mr. Crowe, do you have any other questions? Ms. Little, any questions?
No further.
Okay. So let's go next to a closing summary from, I believe, first the assessor, and then we'll finish with the applicant. So go ahead, Mr. Denham, whenever you're ready.
Thank you. I would like to point out that these 4 comparables are indeed from the subject neighborhood and tract, unlike the presentation by the applicant, so they're more concentrated. I would also like to point out that my raw values go from a low of 540 to a high of 619, so it's more concise than their range, and that would be attributed to the fact that our properties are all from the subject area. And literally the lowest actual raw sale price during the time period in both presentations is $540,000. And so from a sales price standpoint, 550 seems to be A, in the range in both ranges, and B, at the lower end of that range. And so for my part of the closing, I believe that you should sustain the assessor's value of $550,000. Thank you.
Okay, thank you. Before we go to the closing summary from the applicant, could you just clarify, please, what is the value you believe is the?
I believe now is for me. If the look at that time is around is maximum 500, should be 480 to 500. So that's a range. Okay. Especially they didn't think about upgrade this. They didn't think about the size. That's why we stay here to show the property on the value is the marketing value.
Okay, and thank you. And so you can go ahead if there's any other summary or comments you'd like to make before we close.
No, not really. It's pretty much we stated everything, and I just think that, like I say, I will have to come back on the per square foot, and that's really where we go apart. The total sales number at the total purchase price. Sometimes I think it's a little bit like I have a $2 million custom home next to it, and then I say there is no precedent, no comparable ever sold for that, because next to it is only $500,000 houses, so I cannot tax it for $2 million. You know, that's why I have a hard time with this argument, and always come back to the per square foot price. So, and that I think we are way too high. Thank you.
Okay. Thank you. We'll close the hearing to public testimony. In terms of deliberation for this hearing, we could either do it here right now while we're here, or we could do all three in closed session. Any feedback from the board?
We might as well go closed session.
Okay.
Get them all over.
Okay. So then what we'll do is we'll deliberate in closed session for our last three hearings. My guess is that we'll be able to get through it pretty quickly. And so, however, Mr. Vlahakis, if it's easier for you, we could make the decisions, close this hearing, make the decisions, and then just have them relayed separately from the hearing.
That's what I recommend, because I know there's several people working in
Okay.
some of audio, video,
Okay.
and stuff, and I'm not sure about restrictions. It'd be best if
Okay.
we just from the stipulations, comments, and then the board do the
Okay.
Take them for submission.
So we'll take the information under submission, and we'll deliberate in closed session, and that's where we are. So thank you to our assessor staff. Thank you to the applicants.
Thank you for the time.
Okay.
Also, I want to thank especially Mr. Meyer for all his help. He was very helpful. He sent me a lot of information. I appreciate that. It was very helpful. Thank you.
Also, he responded very quickly.
Very quickly.
Oh, good. Thank you. That's
Whenever we send an email, he immediately sent it back, even Sunday.
Wow.
So today is Sunday. This
Great.
Yeah, we
Thank you.
appreciate it.
Tell them that they'll get a minute order.
No problem. We can wait.
Okay, thank you. And you'll receive a minute order from our clerk in terms of the decision soon.
Thank you.
Okay. So we'll go next to, before we go into closed session, our stipulations, items 221 through 230. I believe there's one that we already ruled on separately. So for the remaining stipulations, I believe we all received them ahead of time via email. Are there any questions?
No questions.
Okay, so looking for a motion to approve the stipulations.
I've approved this, reviewed the stipulations, and I make a motion to approve as presented by the assessor.
I will second the motion.
Okay, moved by Ms. Crow and seconded by Ms. Little, and motion carries. And next, any public comment? Okay, and any board comments? Okay, this is I'd just like to make a quick comment. This is the first hearing that I've had the pleasure of serving with Ms. Little on in the past 3 years. So welcome back. We're so glad to have you back.
Thank you.
Okay.
Nice to be back.
And so we'll be adjourned and be meeting in closed session at 5:30.